Yes, so like today is a. Good. It's gonna do the whole. Okay, I'm literally.
All right. Good morning, everyone. We have, I think 2 calendars this morning. Yes. Final plea and an inquiry. The final plea calendar, Ms. Nelson, people are on what trial calendar?
Sorry, Judge. Probably the May 7th. I'll have to double check.
Wow, that's like 2 weeks from now. You guys better work things out. Okay. Could be a later one in May. We'll see. But if you are here on the final plea calendar, today is the last day. You can work your case out in the following manner. If you're interested in entering a plea, you don't have to, but if you are, today, if you enter a plea and the sentence you receive is not what you asked for, you can withdraw your plea, no questions asked. After today, you can always enter a plea. You just won't be able to withdraw that plea if you are dissatisfied with your sentence. That's the main transition that occurs after a final plea date. So today is the last day to be able to withdraw your plea if you don't like the sentence. Position 1 on that calendar is Kente Compton.
He's mine, Judge. Good morning.
Good morning.
I'm assuming, or I think it's just gonna be a final hearing. I do need to speak with him briefly, and Mr. Abadi will be here about 9:30.
Okay. We will handle it after he's here and you've had a chance to speak with Mr. Compton. Linton Greenway. Hey, Mr. Greenway, how you doing? So, who's your lawyer? You are your lawyer. That's what I'm remembering and seeing you. Like, this is the guy who for the longest time tried to hire someone. So I guess you're going to talk with Ms. Smith, the prosecutor, today about your case?
Yeah.
Right there. Great. You guys huddle up after I call the calendar and let me know a plan. Mr. Batiste, Javion Batiste. He's on Zoom.
That's a negotiated plea.
Plea, okay. We will do that shortly. Robert Bolton. There he is. What's going on, Mr. Bolton? Good to see you. Not in custody. Yes, sir. Ms. Wood.
Yes, this is most likely a non-negotiated plea today. I just need to speak to him once more.
Okay, as to both cases?
Yes.
All right, so Mr. Bolton, sit tight. Ms. Wood's going to talk with you, and it may be that we try out a plea today, okay? All right.
Hey, this is Mr. Batiste. Do I have to sit tight as well? The one you just called before?
You can stand or sit, but we will get to you. Your lawyer pointed out that you were on Zoom, and she said it's a negotiated plea, so we will get to that. I got to go through the calendar once to see what the plan is,
Okay.
and then we'll cycle back to you, okay?
Gotcha.
All right, but when we do cycle back to you, you will need to turn your camera on.
Gotcha.
All right, Lorna Heath. Hello, Ms. Heath. All right. Hello.
Good morning, Your Honor. I just spoke.
Twice in 2 days.
Yes. I just spoke with her counsel, Mr. Lee Howard.
Mhm.
He's on his way. He said he'd be about 10 minutes late, but he's
Okay. And what's your expectation with Ms. Heath's part of the case? It looks like we've got a few defendants in the case.
Co-defendants, I think we've worked out a few pleas, but with regards to her case, I need to speak to Mr. Howard a little bit more.
Okay. So Ms. Heath, if you will sit tight also, Mr. Howard is on his way. Once he gets here, I'm sure he's going to want to talk with you, and then he needs to speak with the prosecutor as well. We can figure out if we're resolving your case today or if we need to move it to the upcoming trial calendar, okay? All right, thanks for being here. Position 7 is Wanita Callaway. Maybe the same announcement, because I see, are you Ms. Callaway? There's Ms. Callaway. I don't see Ms. Cabrera, but she's often running between courtrooms.
Yeah, I think she and I had some communication, regarding Ms. Callaway, so I think we're close, if not, haven't resolved that one.
Okay, let me see if Ms. Nelson, do we have any info on the whereabouts of Ms. Cabrera? We'll find out about that. Ms. Callaway, once we learn if Ms. Cabrera is coming in person or dialing in, we'll let you know, okay? All right. And then the third defendant in the case is Mr. Arnold. He is on the screen from Robert A. Dayton. I think that's a federal, that's not Mr. Arnold. That's what Ms. Nelson said. Okay, my mistake. I'm wondering if that is, well, let's find out. Hey, who is at Robert A. Dayton Detention Facility?
Judge, that is my client, Jesus Enriquez Perez. He is in a federal facility, Judge.
He is.
Yes. If we can approach the bench at the appropriate time, I think I'm waiting for the prosecutor, but he is in federal custody. And we should be able to resolve the matter this morning with a plea.
Okay.
I'm hoping that they will hold him long enough at the federal facility for that to happen.
Okay, well, hopefully, unless he's leaving in 10 minutes, he'll be there because Ms. Nix, I trust, is on her way.
I'm on Zoom, Your Honor.
Oh, she's on Zoom. Okay. Ms. Nix, have you spoken with Mr. Sperling?
We have communicated via email. I think that we need to have a phone call to iron out whatever details. So
Okay. Ms. Nix, are you headed this way or are you going to be virtual today?
I'm going to be virtual. I can head to the courtroom, but I was.
No, I just needed to know the format, so Mr. Sperling needs to give you a call. Does he have your number?
if I can speak out my phone number and she can call me right now, I'll step outside.
There you go. All right, Ms. Nix, if you'll listen, Mr. Sperling is going to share a phone number, and if you could call him, he wants to see if he can tie up some loose ends, and maybe we could handle Mr. Enriquez Perez's case.
All right.
404
404
483
483
5530.
5530.
I am stepping out of the courtroom as we speak.
Okay, he's narrating every move. All right. He is now turning to his right and leaving the courtroom. If you'd give him a call, Ms. Nix. One quick question, Mr. Sperling. Does Mr. Enriquez Perez, Mr. Sperling,
No, he's already out.
narrate your way back in here? I am returning to the courtroom. Does your client need the services of a translator?
He absolutely does.
Okay, we're going to figure out if it's going to be a plea, we'll prioritize it because you're here and you're here. So talk with Ms. Nix, and if you don't mind waiting for that conversation to conclude, Ms. Nix is going to give you a call. Great, thanks.
Judge, I do have someone on the regular final plea, so I will wait to call Mr. Sperling until we're done with calling that.
Nope, call him now, please.
Okay.
Thank you. All right, so how about Reginald Arnold? He is in custody, but he's in state custody.
Yeah. Is it River? I can't remember where he's at.
Okay, Matt, we don't have GDC on here. Ms. Nelson, did we try to line up Mr. Arnold today? Ware State, she says. He's at Ware State. Are they going to be hopping on?
Judge, I will check. I did send a request.
Great, thank you. All right. Trinice Lawton.
He's on the Zoom call, Judge.
I'm here.
Okay. Hello, Ms. Lawton.
Good morning.
Good morning.
This is one, I don't know if it makes sense to actually have the final plea hearing.
So my understanding from Ms. Williams is that you would have just received an offer. Ms. Williams was working through some other things, and so you and Ms. Lawton either haven't had a chance to talk about it or would have talked about it for 10 seconds, and that's it. So my thought would be we just make sure there are no discovery issues, and then we move this to the trial calendar, date TBD, but we preserve Ms. Lawton's final plea rights. Does that work for you, Ms. Wood? Ms. Williams, is that all right by you?
Yes, thank you so much, Judge.
You bet. Are you aware of any gaps in discovery, Ms. Wood?
Yes, and I actually am sending what I think is missing to Ms. Williams right now.
Okay,
And I think she's already aware of some of that.
okay. It sounds like there's digital evidence in this case. Is it that kind of thing, or it's we don't have body cam, or?
It's most of the digital evidence. But yes, I'm gonna send her what I think is missing.
Okay. It also seems like it wouldn't, when you get it, it probably then wouldn't trigger a need on your part to get an expert or anything. You just need to be able to see it and share it with your client.
I don't anticipate any expert or anything on this case, Judge.
Okay. Ms. Lawton, I think what we're going to do is move your case onto the trial calendar, but preserve your final plea rights. So you could still, on the date of that trial calendar, enter a plea or some date before then. And if the plea didn't go well in your mind, you could withdraw your plea. But your lawyer needs a little more information from the prosecutor that she can share with you. And the state just now provided its potential offer to Ms. Wood, and she needs time, understandably, to talk with you about all that. Does that make sense?
Yes, sir, it does.
Any questions about anything we discussed?
No, sir.
Okay, did you get a notice in the mail to be here today?
Yes, and then I also spoke with Miss Woods and asked for Zoom because I am located in Miami.
Oh, and you being virtual is fine. I wasn't asking like, why aren't you here? I want to make sure you got notice because your next notice will be for the trial calendar. And I see you're on the May 28th trial calendar. So about a month from now. Interestingly, I have jury duty on May 28th. But it's a Thursday and I'm group 6, so I bet I won't have to come on in for jury duty. This is, anyway, neither here nor there. So you will need to probably be here in person, but Ms. Wood will help you navigate whether you could be here virtually on the 28th or in person. It partly depends on how your case may be resolving. But it sounds like we've got good contact info for you. So look for a notice in the mail telling you that you've got court on May 28th. But also, more importantly, look for contact from Ms. Wood. Do you have a way to reach her?
Yes.
Great. Ms. Wood, anything else on behalf of Ms. Lawton?
Yeah, thank you.
Ms. Williams?
No, Judge, thank you so much.
Okay. Ms. Lawton, you are free to go.
Thank you. Have a good day.
You too. All right. Scott Schoenher. I think we just rolled this to the trial calendar. Mr. Brill had a conflict. And so were you part of the email loop? And so I think this just went to the trial calendar, but preserved his final plea rights. Had you and Mr. Brill had any communications on this case?
Yeah.
Okay, so he's got whatever offer there is, that just, we're not working through it today. Okay. All right, Miles Harper.
Yes, Your Honor.
Hey, Mr. Harper, how are you?
All right, myself.
I am also all right. Your lawyer, Miss Sherry Lassiter, you talked with her recently?
Yes, she's running a bit late. She had another case she's for.
Okay, we will hold for her report, and then she and you and Ms. Smith and I will figure out what we're doing with your case. Thanks for being here. Makiba Clark. Hi, how are you? Your lawyer is Mr. Hirsch. All right, have you talked with him?
Yeah, he's running late, he has another case.
These lawyers, why are they not here first? All right, we will wait for Mr. Hirsch, and then you and he and Ms. Smith and I will figure out what the plan is. Thanks. Francisco Garcia.
Good morning, Your Honor. I'm here on that case.
Great. And that's Mr. Garcia. You're here for Mr. Lee.
Yes.
That's the other case Ms. Williams had where she encountered some complications, and so offers only recently went out, and it may have gone to Mr. Lee, so you may not even have seen it yet.
That's usually what happens.
Okay, I'm gonna ask you and Ms. Lee, you and Ms. Williams to speak briefly after almost through the calendar. I don't expect, unless it's the offer of the century, for you to say, great, let's do this. For you to say, I'd like to preserve final plea rights, I move this, the trial calendar is gonna be an A-OK response. But I will want to make sure you feel like you're good to go with discovery and give you an opportunity, because the offer may be such where you say, no, we want to resolve it. But I got a few more names to call, and then if you and Ms. Williams don't mind speaking, does Mr. Garcia require the services of our translator?
He does, and we've spoken about that.
Great, great. We are here for 2 reasons. Thank you.
Thank you, Judge.
All right. And Mr. Howard just arrived.
Yes, sir.
Excellent. When we're done with the calendar, you need to speak with the prosecutor.
Yes, sir.
Tanisha Dider? Dedier. I bet we've misspelled it. Ms. Dedier, how are you doing today? You're hanging in there. Your lawyer, Mr. Mohammed, is he with all those other lawyers who are going to be here later? All right. Would you do me a favor? We're almost done calling this calendar. Will you reach out to him to find out where he is and what his ETA is? Thanks. Ms. Smith, have you had communication with Mr. Mohammed about Ms. Dedier's case? Great. Then I'm expecting him to be here. So if you'll just reach out to him, we'll figure out when that's going to be. Thanks. Demoya Ballard.
She's on the Zoom, Judge.
Ms. Ballard.
Hello,
Hey, good morning. How are you this morning?
I'm good. How are you?
I'm also good. Ms. Wood, what are we doing today with Ms. Ballard's case?
I was in the hearing, however, I think, so Ms. Smith, needed to amend her offer late yesterday. I haven't had a chance to talk about the new offer with Ms. Ballard, but it wasn't gonna push this towards a plea. It actually increased.
Oh, it amended in a way that Ms. Ballard would be sad to hear about.
Correct.
Rather than glad to hear about.
Yes.
Okay. Well, why don't you chat with her just to let her know what the new one is, so she's not surprised when Ms. Smith says the state's recommendation is X, and then we'll do the final plea hearing. All right. And then finally, Mr. Cook.
Judge?
He's there, and you're Mr. Mondelli.
Yes.
Ms. Boykin, is this your?
This was, Ms. Nixon.
Okay, that's why Ms. Nix said she had one other case. This is it.
Discovering an offer last night. I'll talk to him about it, and
Gosh, discovery came just yesterday?
that's correct.
Had you had anything beyond the indictment before yesterday?
Just thought I might before we this is a relatively straightforward case, Judge, so we may be able to resolve today, or maybe have one more discussion.
Okay. Well, as you may have heard, I asked Ms. Nix to reach out to Mr. Sperling. So we got someone in federal custody on the call, on the Zoom session. So we want to knock that out if we're able to. And then she could pivot and engage with you. So you understand how final plea works. If it's not meaningful for your client to process what you just got, then I keep the final plea rights open and we just move it to the trial calendar. And it sounds like we're probably in that posture, unless the offer is something, or your negotiations this morning make it something that your client says, no, this is what I want to do. And we'd certainly do that. But if it's, gosh, I need more time, or you need more time to look at the discovery, fully understandable. And we would just keep those rights open and move it to the trial calendar.
Given that Mr. Sperling is back, maybe able to grab this instant phone real quick and chat.
Well, let's find out. Mr. Sperling, does it sound like we're going to be able to go forward with Mr. Enriquez Perez today?
Yes, but if there's some way that we can have a brief off the bench conference with the prosecutor, I believe that her child is sick, so she's not in the courthouse. It's a pretty serious matter. It would be helpful if we could have a very brief pre-trial. Typically, I would just ask, can we approach the bench, but we're in court. So I don't know if Your Honor would be willing to step on.
You want to have a conversation, you, me, and Ms. Nix. Okay, my sense was Ms. Nix was in the courthouse. She's not, okay,
Remotely, so.
Okay.
It'll be way logistically, we could do it is stepping off the bench for a moment.
sure, okay. We'll do that in just a minute. I gotta get through the rest of the calendar. All right. On our inquiry calendar, we got a few more positions. Daniel Simmons. Hey, Mr. Simmons.
How you doing, Fire?
Your case has been dismissed. You took care of all the things you were supposed to take care of. Thank you for doing that. And the prosecutor yesterday filed a motion to dismiss. I entered the order to dismiss. So early or late, happy birthday. I don't know when your birthday is, but good news. You did what you needed to do and the state has closed it out. Okay?
No?
You can stay if you want, but you, all right. Just get out of here while you can. All right. Yes. Christina Lockett.
Good morning,
Good morning. How are you, Mr. Tate?
how are you?
Okay. I'm not sure from the notes here why this is on an inquiry calendar. It was on a final plea a few months ago. Ms. Smith, can you loop me in?
Yes, Judge, when it was on the final plea calendar, I asked that it be placed in judicial hold. We had a proffer with the defendant in this case.
Got it.
The state is in the process of identifying the two other people that were at the scene. We were either in this case asked for it to be can stay in judicial hold or placed on the dead docket, but we just need a little bit more time before we move forward with those other individuals.
Got it. So no more dead docket. Don't say those words. But we'll leave it in judicial hold, but I want to not forget about the case. So how far out should I set it?
2 to 3 months.
Okay. So Ms. Lockett, you've kind of been in limbo for a little while and that's not ideal because these are serious charges. But it sounds like your case is trending in a good direction for you. You're going to be in limbo a little while longer. So whatever your conditions of bond are, I'm going to look at them in just a second. You'll need to continue to comply with those. Mr. Tate will continue to be your lawyer, but I think it's going to be pretty low key for the next couple of months. The state has some homework to do. And when they're done with that, they'll be in a better position to engage with your lawyer about what next steps are. Do you have any questions about any of that? No? Mr. Tate, anything on behalf of your client?
No, Your Honor, as long as, she stays on the same line, we're fine.
Yep. No, I'm not planning on changing that. I just want to look at the bond so I can refresh my recollection and your clients as to what the conditions are. It's an old bond. There you go. So pretty basic. You need to stay away from someone named Bryant Hall and someone named Master McKee. And then no contact with a Wanita McFadden. Any of those names ring a bell?
Yes, the last one is my mom and.
Well, that's complicated.
I thought it got cleared up,
Maybe we modified your bond.
That was one of the issues initially, when Ms. Davis was still on the matter, but she determined that,
Having daughter-mother contact was an okay thing. Ms. Smith, do you have any reason, based on the work you've done in the case, to think that Ms. Lockett needs to have no it lists Ms. McFadden as a co-defendant. Of course, she's not in the,
Judge, if I may, although this is not my case,
Yeah.
I actually remember that conversation happening in court. As both people were here, the mom and defendant were here the day it happened.
Okay.
So I do remember Ms. Davis stating in open court that she had no issue with it.
Okay, great. So it's okay to hang out with mom. What I'm going to do, I'm going to make a note to modify the bond, and the only modification I'm making is just removing that condition. Just in case another judge ends up with this, if this takes a while longer, there could be another judge who's looking at it, and that judge would say, oh my gosh, you've been with your mother, I'm revoking your bond. And that shouldn't happen, okay? but you need to stay away from those other two names and some address on Ralph David Abernathy. 226 Ralph David Abernathy. All right. Anything else, Mr. Tate?
Oh, yeah.
Okay, so if we further notice this 2 months out, is that too soon? And we're just gonna make Ms. Lockett come in again, or,
I think in 2 months, Charlotte, we should have a better grasp on what we have going on.
Okay.
So,
we'll try that. All right, so you'll get a notice in the mail, Ms. Lockett. Are you still at? Are you in Snellville?
Yes.
On Annistown Road?
Yes.
Great. So you'll get something in the mail there, letting you know when to come back here. And Mr. Tate, if the announcement is going to be still keep Ms. Lockett on judicial hold, you could reach out to my staff and we could probably excuse your appearance, both of you. So you don't have to come all the way from Snellville and you don't have to disrupt your workday. If it is something more substantive, hey, we've done our research now and we're going to do X with Ms. Lockett's case, then you guys should be here. But if it's a repeat of today, just hopping on Zoom is okay. All right?
Yes.
All right. You two are free to go. You too. Thank you, Ms. Willingham, for that good memory.
Your Honor, we do have an announcement with regard to my case.
Okay, I'll get back to that in a sec. We talked about Enriquez Perez, Derek Harrison. He should be in custody.
Is mine, I think this is gonna be a non-negotiable case.
All right. How did it end up being you?
Oh, I don't know.
That's fine. Okay. All right. Good old Mr. Harrison. All right, Jaden Ashley. Hey, Mr. Ashley. I'm doing all right. I hope we got you a lawyer. Has anyone reached out to you? No. Let's see.
I think Attorney Cabrera is the entry in this case.
She did. Excellent. You do have a lawyer. All right. And I'm gonna get you her contact information before you go, but she may be coming here today because she's got another case. So I'm waiting to hear back from my staff as to see when she's going to be here. Okay. So if you would take a seat, I will write her name on here and we'll be able to move your case forward. Christian Falconer.
They were excused.
I think he was excused. He got Mr. Blevins. All right. Blevins and Kamarian Mosley.
We're waiting on the revocation hearing.
This one you can go forward with today?
Yeah.
Great. Okay, we'll do that. And Frederick Avery.
Your Honor, I'm going to ask for a reset. So I just got an email yesterday that he was not accepted to drug court. And so he has a interview with the Salvation Army this week.
Okay, did they say why?
They said because in his past, he had some possessions with intent. They're very strict at drug court these days.
Okay. So reset to sort of the next available inquiry calendar. Is he here? Oh, Deputy Gordon's gone. He is here? Okay, we'll bring him out real quickly and I'll just let him know, but do you want to tell him first or does he know?
I don't think he knows.
Okay, if you'd let him know and then I don't like having people come over and then like, why did I come over here? So you don't need to bring him out quite yet. We'll have Ms. Rios talk to him first. And And then we'll get him on the next available inquiry calendar. And that is it. So we had a few of the lawyers who were running late get here. Mr. Howard, your client, Ms. Heath, is on for final plea. Did you get a chance to speak with?
Yes, Your Honor, and we've had a lot of conversations about this case. I've also provided opposing counsel with some exculpatory information. I have a specially set murder trial in Gwinnett, State of Georgia versus Stanley Elliott. It is specially set starting next week for a couple of weeks. And I'm requesting a one-time continuance. I won't be requesting continuance after this. Based on my conversations with opposing counsel and the exculpatory information that I provided her, I do believe that we are headed towards resolution in this case. But because of my specially set trial, I am requesting a one-time continuance.
So today's final plea is not interfering with the trial. I'm not making the connection between, I appreciate you got a big trial coming up. Today's just the day where if it was going to work out in a manner such that there'd be a plea, negotiated or not, Ms. Heath could go forward with that. And if she didn't like the sentence she received, she could withdraw her plea and we'd move on to the trial calendar. Instead of putting this on another final plea date, what I'll likely do is just move it. It's already slotted for the May 28th trial calendar, long after your 2-week trial is over. And that's where it will go. It's just then a question of whether we preserve Ms. Heath's final plea rights till then or not. And I don't think your trial of next week is a reason to preserve the rights. If there was something recent that the state gave you that you didn't have, that would be a reason to say, let's keep the final plea rights open. But it sounds like the information flowed the other direction.
Correct. And that's why I would ask that you keep, Your Honor, I completely understand that, but I would ask that you keep the final plea rights because I do think the state needs more time to evaluate what I've given them. And I would ask for that reason that we keep the final plea rights. Stay in trial calendar, you said May 28th, but keep the final plea rights.
Okay, Ms. Boykin, is what you've received, have you had a chance to even eyeball what you've received? Or hear it? It may have been Mr. Howard describing it and then he gave you something.
I need to review it, but I have no objection. Based on our discussions, it's definitely something I need to look into and could change our posture on the case. So,
Okay.
I'm fine with, I think my misunderstanding was that I thought we were going on the May 6th trial calendar, but 28th is more than.
Well, we've heard both today, but it's the 28th.
Yeah.
So everyone would have enough time. Oh, that's why you were sharing, hey, I'm gonna be in trial for 2 weeks. I'm like, great, I'm gonna be a judge in 2 weeks. But it's because it would interfere with, it would overlap, right? So no such overlap. Yes to keeping the final plea rights open. Do you feel, Mr. Howard, like you've received all the discovery that ought to be out there from the state?
I do believe I have all this.
Okay, all right, then that's what we'll do. Ms. Heath, you'll need to be here on the 28th. And of course, if you guys sort something out before then, it'd be great to avoid the congestion of the 28th. That's going to be a day where this looks like a small group. And so if there is something sorted out, especially if it's going to be a plea with a lot of back and forth, not because it's non-negotiated, but because if Ms. Boykin is involved, it's not a real simple case with, hey, he dropped the drugs on the ground and that's it. So I encourage you to get an earlier date if that makes sense. If not, the 28th. I also don't know if this is something where you'd want to do more than one plea at once, or if the facts are different. We'll figure all that out.
I'll let
Okay.
this stuff know. If we can resolve it with the others on an earlier date, I'll definitely let you know.
Okay, so Ms. Heath, at the latest, I will see you again on May 28th, same courtroom. You just need to be right here. Mr. Howard will be in touch with you well before then, giving you his thoughts and counsel as to what's going to happen. Okay? Do you have any questions? All right, Mr. Howard, anything else on behalf of Ms. Heath?
Good to see you, Judge.
Same. Good luck for that. Where is the 2-week trial?
In Gwinnett County.
Okay. All right. Good luck with that. We just lost a judge in Gwinnett County.
Oh, we did?
Yes, Judge Fluker passed.
Oh, we did. Got
Yeah. But good luck with the trial.
My client's completely innocent, so.
Well, let's see if the jury sees it that way.
It's good to see you.
Bye. Mr. Hirsch, how are you, sir?
I'm good. I'm sorry to hear about that. She and I were hired on the same day by J. Morgan, the county office in 1998, I think it was.
Going way back. So Ms. Clark is here and she told us you were running late. You're here, which is fine. Final plea date. Ms. Smith didn't want to speak out of turn with you not here. Is this something we're working out today? You need to pre-try with Ms. Smith. What's the plan?
Thank you for holding for me, Your Honor. I asked if we could move this to the next final plea date. The plaintiff witness in this case has filed a civil lawsuit. Depositions are going to be heard. They've been scheduled, but they've also been rescheduled. Our civil lawyers have gotten a bunch of internal video that I just finished going through. Hopefully that will resolve the case, but I need to turn that over to the state. So if this court's inclined, given that, to give us another month, that's my request.
Okay, what I'm inclined to do is exactly what I just did with Ms. Heath, which is to have Ms. Clark's case stay on the May 28th trial calendar. That's more than a month from now. So you'd have a chance to review, what's a dog noose?
She's Dr. Clark is a veterinarian. So it's one of those things, like if you think of a dog catcher and they've got it has like a lasso at the end of it and you put it around its neck so you don't get bit.
Got it.
Basically a stick with the rope.
Got it. Okay. Anyway, I want to give you a chance to work through what's happening on the civil side. I usually don't delay a lot of criminal for civil. It's usually the other way around. But with these charges hanging over Dr. Clark's head, it can't be good for her situation. And so I'm going to keep it on the May 28th trial calendar. Ms. Smith, do you have any objection to preserving Dr. Clark's final plea rights? Okay. Any discovery issues you see on the state? Sounds like you have things you're going to push in the state's direction.
Yeah, the state has turned everything.
Okay. All right. Dr. Clark, you still here somewhere?
Yes.
What, there you are. Hey, so you're going to remain on bond. I will see you no later than May 28th. If Mr. Hirsch and Ms. Smith work something out in advance that involves a plea, then you could come in earlier. If it involves a dismissal, no one needs to come in. That's just paperwork flowing. I'm not saying anything's going to be dismissed. That's not my call. That's the state's call. But otherwise, I'll see you on the 28th here for the call of the trial calendar, but I'll preserve your final plea rights. Okay? Any questions? No? All right. Anything else, Mr. Hirsch?
Yeah, good to see you, man.
Yes, sir. All right. Good morning.
Good morning, Your Honor. Chantel Sherry Hackler for Mr. Harper. I had a conflict this morning, but I'm here.
Yep. He told us you would be here shortly, and you are.
Thank you, Your Honor. We are ready for approval on this matter.
Great.
We negotiated some terms that I think is move forward.
Okay. I put that on the list. We've got a couple pleas that we will knock out in just a little bit. Thank you for being here. Mr. Mondelli.
Yes, Judge, I spoke with Ms. Nix, while you were handling other matters. I will present her with some little bit of mitigation evidence, and we asked we move this to the 28th and keep the negotiation open until then. And I think we'll be able to resolve it certainly by that point.
You're on the May 7th trial calendar.
May 7th.
Yeah, that's okay. I mean, it's a mix here, but this is one that's on the May 7th. So it's sooner. Any reason, unless you're in trial with Mr. Howard for 2 weeks in Gwinnett, is that too soon or?
It'll be too soon to get some of the documentation together. Some of this is some mental health related aspects. So if we could move to the 28th, and then between now and then, I think we'll be able to find a resolution, I think, before the 28th itself.
Okay. I believe, has the May 7th trial calendar already been published? I think it's out there. So you're on it. And it sounds like you're asking for a continuance from that to move to the 28th. so that you can marshal the mitigating evidence.
Yes, Judge.
Okay. Ms. Nix, are you okay with that approach to Mr. Cook's case?
Yes, sir, that's fine with me. I think that we might be able to come to a resolution prior to that. But I think just in in abundance of caution, in case we can't, it would be best to put it on the 28th. So
Okay.
that documentation.
All right, Mr. Cook, you following all that? So you stay in touch with Mr. Mondelli. It sounds like he's going to need to get some information from you or some of your care providers. He will be speaking with the prosecutor, and as you've heard me say now several times, Mr. Mondelli, if it is resolved before the 28th, let's line up a window to do that, because you'll avoid some of that congestion on the 28th.
And do you want us to appear also on the 7th, or are we?
I'm going to talk with Ms. Nelson about that, the litigation manager, and she'll get word to you either way. You got to be here or you're excused from that calendar.
Perfect. Thank you, Judge.
Okay. All right.
And be excused.
Yes, you and Mr. Cook are good to go.
Have a good day.
You too. Ms. Nix, in just a moment, Mr. Sperling and I are going to give you a call, okay?
Yes, sir.
Good morning, Mr. Abadi. Ms. Wood forecast that Mr. Compton is probably just a final plea hearing. Okay, we'll do that in a second. Anything else before I step off the bench for a couple moments and people can pre-try, et cetera?
I have a walk-in here.
Oh, Artie Leidecker?
Yes.
All right, can I have that case number?
26 SC 000260.
And Mr. Leidecker is here because there was a bench warrant or because he's resolving his case?
I don't think a bench warrant, I don't know if the bench warrant was actually ever,
Uh-oh.
issued. It was March 10th was the date.
Hi there.
Arnold is on.
I saw that.
Okay, I just didn't.
Yep, thank you.
Yeah, I'm not sure if we actually issued the bench warrant. He has been participating in DeKalb County's drug court program, so I don't know if there's a good address in the system.
It doesn't look like there's a warrant. It just, there's judicial hold. So we need to take him off judicial hold, arraign, all that kind of stuff.
Yes, I have not, so I'll do a waiver today, and I've connected with him, so we have contact for each other.
Okay. Yeah, so Mr. Leidecker, we'll need to get a good address for you. I got one in Douglasville, but it doesn't sound like you're there anymore. Okay. Ms. Wood needs to get a good address from you. She'll fill out the change of address form. She'll also do a waiver of arraignment, which is just you entering a not guilty plea in this case. And we'll move it along. Are you actively participating in DeKalb County's drug court, or you did in the past? You're doing it now. Okay. Well, then, Ms. Wood, you may want to reach out to a colleague there, and then you and Ms. Smith could talk about whether this goes in there on a diversionary basis, or I don't know anything about the evidence. It may be one like, look, I'll plead to that and just roll it into their drug court. I'm fine with either approach, and we'll lift the judicial hold.
Thank you.
Okay. All right. Mr. Leidecker, you have any questions for me?
I got a clustering day on a big hole in me. I'm not supposed to sit up on the 23 minutes I'm laying down. I got doctors noticing here and whatnot. If I'm not trying to get out of that through.
No, you know what? Ms. Wood's going to talk to you real fast, get your information, and then she can let you go. No, none of us here want you to have colostomy bag issues here in court. All right. All right. Okay. Thank you. All right, Ms. Rios.
I have Mr. Mosley ready to go. If you want to do something before you stepped off the bench.
Mr. Mosley ready to go.
Probation revocation.
Oh, there's several things that are ready to go, but we have a gentleman in federal custody. We need and an interpreter here. So if we're going to be able to do that this morning, we're going to do it. And one other thing, who represents Mr. Arnold? He is now on? And so if we could just get a sense, I think that's Ms. Boykin's other, well, you still got to talk with Ms. Cabrera. Oh, look who's here. Hey. Hey. Yes, right. Just so we can make the connection, Mr. Ashley, that's Ms. Cabrera. You guys will connect, okay? All right. On the inquiry calendar, you filed an entry. He needed conflict counsel signed, and you are it. But
anything with him today other than intro?
no, it would just be waiving arraignment or not waiving arraignment.
Okay, well, while he's standing, we can do it, and I'll go speak with him. We would waive, waive formal arraignment, enter plea, and I'll go.
Okay, great.
And I'll.
And then as long as you and he exchange, can you stand up for a second, Mr. Ashley? You see him? Okay, got it. So when you're done talking with Ms. Cabrera, you're good to go. She needs all your contact information, phone, email, et cetera, and she will give you hers. All right? And Ms. Cabrera, when you get a chance, if you'll just fill out one of the waiver forms for him. Great. As for Ms. Callaway, what are we doing? Do you need to speak with Ms. Boykin some before?
I think
Great.
resolve this Callaway today, but I don't want to speak.
Excellent. And Ms. Wood stepped outside. Mr. Arnold, when Ms. Wood comes back in, we'll figure out what's happening with your case today, okay? All right. Let's get Ms. Nix on the phone. If you just go into the jury room, you can call her up and I'll listen.
Mr. Perez, can you hear me? Can you hear us? Can you hear us?
He can't. I muted on his end, but he reacted. Just tell him, hey, 5 minutes.
We'll be back in 5 minutes, okay?
I could have said that. I thought you were going to say it in Spanish.
Other way, other way.
Oh, that way, okay.
Yeah, of course, it's. Yeah, 25, that's the. Here you go, 769.
How are you?
How are you? Good to see you.
Yes, fine.
Okay. Understood. Of course. Well, there was a motion for an inspection in the background. I sent the order to the back and then starts the process, and I do not know whether the McBurney's office will receive it. Right, so that's one issue. The second issue is, if I'm not.
I'm gonna come.
Yes, so I also. Don't have any.
So I don't have much
Hear that.
time to get to.
Definitely questions.
Yeah.
And so comfortable asking them, how possibly see.
Yeah.
Those two.
Yeah.
Well, yeah, definitely. Work done in there.
Yeah, definitely.
The first one. Help.
It's an outcry in his very session, I think, at least the notes or the recording, whatever from that particular session.
We were both about that.
Yeah, yeah, at least for both of us to see the consistency of the
Right.
or like there. Right, so I'm fine with an in-camera inspection. Yes. I will talk to the family and get that information. So
Okay.
it may be a premature, but she's on that. So it's.
Okay. Sounds good. Right, right. So do we just, after we just finish speaking with, Sperling and
Yeah.
their ADA ask approach?
Yeah, because.
Yeah, we got it, right.
Yeah, so you can just, any of 20 questions.
Okay, sounds good. And we'll probably roll through, I guess, to the next round, I would think. You'll have a lot of stuff to try on this one.
Not. You know, we're trying to get, everybody's trying to get stuff, trying to debug.
Oh, yeah.
Yeah, because it's gonna be
Nobody
crazy.
come down.
Yeah, it's gonna be crazy.
Yeah, I'm not looking forward to that either.
And it's more dangerous for the sheriffs.
Yeah, I didn't even think about that.
So, yeah.
Hey, thanks.
Welcome.
Did you go to Georgia State?
I
I
did.
think we might have been in the same. Did you
Oh,
graduate in 2011?
I graduated in 2013, so you came
Okay,
out.
we were there at the same time.
Yeah. Yep.
So you did get to the fancy new building.
No,
So you
I
were
was
the last class that didn't
yes,
get it.
yes.
Go there in the urban life and the old.
Yep, exactly, in the wetland. Yep. Mhm. Yeah. I think, yeah, we were the last class because we got an email saying that some of our colleagues had been inducted into the Order of the White Cross, because that started. We got.
Sounds fancy.
I heard about that.
Yeah, I mean, it probably doesn't do anything. That's funny. Yeah, a special email saying, hey, you don't get the benefit.
Yeah, exactly.
Despite your tuition payments faithfully.
So it was, I think it was retroactive for 2 years, so
Okay.
2013 could be.
So you still were eligible?
Inducted in 2012.
Okay.
But some of my colleagues got it.
I got invited to this weird thing that was like,
What? That's what happened.
in a court, you ever heard of this? We'll talk about these things.
Yes.
And I still remember once, you know, like 15 years later, went to some rich guy's house. And everybody's like, hey, where's your dad play golf? I was like,
Yeah, you just sit
don't,
around
not
and
one
talk.
of you. Like, I don't know what this
You
is.
sit around and talk about
And they're
it.
like, hey, you know, rich
Yeah.
people, you know, it's like they're trying to see if you can
Yeah.
bring them into this, like it's all just like, they're not recruiting you because they think you're potentially gonna be a good lawyer. They're recruiting you because they want to see if you are gonna be. Right?
Yeah, you just talk about the latest things. I did one with at a high school, though. We did an import at high school.
Well, that's nice. Yeah, that does sound nice, actually.
Yeah.
I'm trying to encourage people to look into law as a career.
Yeah, basically that's what it was. And, you know, some of the kids on their mock trial team were in the end of courts. They would have questions. Yeah, they are.
It's funny, like the younger high school age, you know, better than some lawyers I've seen in court, which is kind of weird.
So
How
that
long have
was,
you been with the officer?
3 years.
Okay.
Yes. So this is I just passed 3 years in March.
Okay. Do you just do, CY?
Yeah, now I do. I was in trial division up until October. So.
Okay. Yeah, we get a lot of this
Yeah.
types of cases.
Yeah, because there's a lot of.
I guess that's why, it's-
Yeah, there's a lot of attorneys that honestly will not do job.
I don't blame you.
Yeah.
It can wear you down,
Yeah.
but they also are frequently.
Talk about it. Exactly.
Yeah, so I guess this one, we'll just talk to Judge McBurney.
Find out.
He wants to keep it on the trial calendar or roll it over, or if he's got the camera.
And I'll get the name of.
Okay. And procedurally, I filed a motion, but I think we probably need an order from the judge for them to turn it over. Look, my mother-in-law's in there, and
Yeah.
she won't, there's all kinds of confidentiality and privilege involved. Without a court order, she won't give us either one of us. So
Exactly.
I think it does have to be a camera too. I know DPAC's records have to be. I can't remember if the statute says therapy records do or not. I think they do.
Well, generally they do. I think right now the case law
Unclear.
it could go either way.
Yeah, like those case law
Right, it could go either way, but usually we're always gonna ask.
for the camera. I prefer, yeah, I mean, that's fine with me. I don't have any problem with that. I trust them.
Yeah.
All the judges.
Right.
In terms of like the law. Right thing.
Which is a lot of work for them too.
It is, yeah, that's part of it. You just give it to your staff attorney, and be like, you don't get anything. Or give it to your staff attorney, I'm gonna give you the entire file without doing any, I've had it both ways. They give me nothing, or they'll give me everything. All right.
Do you have an update on your case?
Yes, sir. There was a, Miss Williams here. We were talking about the motion for in-camera inspection that was filed into the order also that we had sent to feedback. So we were going to inquire what the court.
Right, yes, we did, hold on a sec.
I think I sent the order to the right place.
You did.
I wasn't sure about that.
Your Honor,
Yes?
I am in the Zoom. If you would be so kind to please send us to a breakout room.
Yep, you're gonna need to tell, your client, Mr. Enriquez Perez, he's gonna need to unmute. I muted it and I'm not able to unmute it, so someone at Dayton will need to unmute, but I'll move the two of you into a breakout room.
And Judge, I speak perfect Spanish, so if the court will allow me to just speak in Spanish right now so he can hear me and I can advise him what to do.
That's fine.
Ok, señor Pérez, vamos a entrar a una sala privada para hablar usted y yo. Ahora que te manda a la sala privada el juez, por favor tienes que apretar el botón en la computadora o en el device que tienes en la cárcel federal para que me puedas escuchar y te podamos escuchar también. ¿Ok? Apriete el botón ahora, por favor. Y ahorita nos van a mandar a un breakout room, a una sala privada por Zoom, o sea que tienes que apretar el botón cuando el juez nos mande a la sala privada, ¿ok? Thank you, Judge.
You bet. When I see it unmuted, I will move the two of you into a breakout room.
Perfect. Por favor, apriete el botón quitando para que haya volumen, para que te podamos escuchar.
All right, while I'm waiting on that, right, I'm dangerously multitasking here. Let's see. This is Perez Garcia?
Yes, sir.
Okay. Okay, we did receive them and the records don't contain material that is exculpatory or otherwise pertinent to the present charges.
Understood.
Okay.
The other matter was the outcry in this case took place during a therapy session. So we also filed a motion for production and in-camera inspection of psychiatric and or therapy records. I have no way of identifying where that therapy session took place. So I've spoken to ADA Williams about it. My understanding is she's going to inquire of the family of the alleged victim and determine whether those records are relevant to either of our cases. And then, of course,
well, if that's when the outcry occurred, it seems like it would be relevant. It may need to be vetted by the DA's office or even in-camera review. So if that's where it happened, I think it clears the relevancy hurdle.
Fair.
It would just be, do you get a synopsis of it? Or because if details differ from if later on there was a forensic interview, then you have an inconsistent statement and you're certainly entitled to that. Do you have those records yet, Ms. Williams?
No, Your Honor, we do not have those records, not to my knowledge. I will contact the victim's family and get that information so that we can, get going on that.
Okay, let me see. You are position 13. That's not till the May 28th calendar. So my thought is we preserve your client's final plea rights, and folks stay focused on this one. You try to get those records, and we just reconvene on May 28th, if not before. If you run into any friction with the records, you think they need to be disclosed, you disagree, just reach out and we can get on Zoom or have a quick hearing to figure out if there's something that does need to be disclosed from what may be in the therapist's records.
Sounds perfect.
Does that work?
Yeah, absolutely.
Yes, Judge.
Do we need our translator to explain that to Mr. Garcia?
That would be fantastic.
All right. No, you're good. You were not pressing the service. What I'm going to do is ask you, if you go outside with the translator and just let Mr. Garcia know what we discussed. He'll be up to speed. And should we be noticing you or Mr. Lee?
It would be preferable for the notice to go to me.
Okay.
And the email address that would typically make sure that the entire department receives is criminal@htlweb.com. I think Ms. Nelson has been on top of that.
She usually is, and I think we do send it to that generic address so that it will go to everyone.
I get it, paralegal gets it.
Excellent.
Mr. Lee ignores it, just kidding.
Good. All right, as he's supposed to. So if you don't mind working with the translator and your client, just to give him the update, he's good to go until the 28th. We'll preserve the final plea rights.
We'll see you then. Thank you, sir.
All right.
Good to see you.
Good to see you, Terry. Your Honor, I believe that concludes my business in front of you today. Might be excused.
You bet.
Thank you so much.
Thanks for being here, and I hope everything is all right
Thank you.
on the family front. All right, he has unmuted, so let's get him in there. RADDF, John Sperling, and go. They are in. Ms. Wood or Ms. Rios, or Ms. Smith, you ready on something?
I think that, Mr. Greenway will be answering.
Oh, before we do that, yes, we'll do that. Mr. Arnold is available. Ms. Wood, I think that's your client.
Yes.
And since he's from Department of Corrections, I want to prioritize that, just like we are the gentleman at the federal facility. That's Ms. Boykin's other defendant in the 3-defendant case.
What's happening with Ms. Callaway's case? The other case, so
I think there's a plea.
is Callaway? Okay, so I just need to tell him that. Okay. If I could, hop on Zoom and do a quick breakout. Judge?
Okay, Mr. Arnold, good morning. Hopefully your voice works better than that. But Ms. Wood is going to join the Zoom call and go into a breakout room with you so you two can speak confidentially, okay?
Yes, sir.
Great. So should we do Mr. Greenway's plea?
Yes, Judge.
You ready, Mr. Greenway?
Yes, sir.
All right, if you come on up to the podium. All right, Ms. Wood is on. Let me get everyone in the breakout room. Excellent. There in there, we'll close that. Okay. Good morning, Ms. Rivers. You ready to take down a plea?
Good morning. Yes, I am.
Great. Well, let's get on the record. In 25 SC 001-819, State versus Linton Greenway. Mr. Greenway is here in court representing himself. Ms. Smith represents the state. Mr. Greenway, are you ready to go forward with your plea?
Yes, sir.
You've had an opportunity to discuss the state's offer with Ms. Smith.
Yes.
You feel like you understand what it is she's proposing?
Yes.
Okay. In a moment, Ms. Smith is going to put you under oath.
Okay.
And then she'll ask you questions about your rights as a defendant, some about the case, and then ultimately she's going to ask you how you plead. When she's done, I'll have some questions for you, and I'll give you an opportunity to share with me anything you want to about yourself or about this case, in the same way that a lawyer would if you were represented by counsel, but you've chosen to represent yourself. And then at the end, I will impose a sentence. If the sentence that I impose is different from the one that you advocate for, and it sounds like, is this a negotiated plea? You think that what Ms. Smith is recommending is what you're recommending?
Yes, that's fair.
Okay, well, if I differ from that, then you'll have a chance to step back and think about it a little bit and say, yeah, that's not exactly what I wanted, but I'm gonna roll with that, or nope, no, sir. I was willing to do what Ms. Smith was talking about, but not what you're talking about, Judge. And no questions asked. You get to leave the courtroom. We don't suddenly grab you, but you'll get a chance to think about it if I differ. I'm not saying I will. I just want you to know that you'll have that opportunity. Okay? All right. When you're ready, Ms. Smith.
Yes, Judge. Before I start, would you like to know about the updates to the charges in this case?
I would.
For count one, it'll be reduced to pointing or aiming a gun or pistol at someone. That's OCGA 16-11-102. And because of that, count two will be no pros.
Got it. So, Mr. Greenway, now I understand you're pleading to a misdemeanor. You were charged with 2 felonies. The state has agreed to reduce the first felony to a misdemeanor and dismiss the second felony. Is that your understanding?
Yes, sir.
Okay. All right. Let's keep going.
Mr. Greenway, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Linton Martavius Greenway.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you would normally take that you haven't been given this morning?
No.
How old are you and how far have you gone to school?
46 and I have associate degree.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Representing yourself, do I ask about the waiving the formal reading of the indictment?
Sure.
Okay.
You just don't say counselor. You say Mr. Greenway.
Mr. Greenway, do you waive the formal reading of the indictment in this case?
Yes.
Do you also waive any and all defense in the indictment for the purposes of this plea?
Yes.
Do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 12 months probation?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No.
And are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, that's what's considered the alpha plea.
Yes, sir.
Mm-hmm.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
As to indictment number 25 SC 001819, how do you plead to the reduced count of pointing or aiming a gun or pistol at someone as count one?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a direct right to appeal from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you understand that that procedure must be completed within 30 days from today?
Yes.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you, Mr. Greenway. Your Honor, if this case were to proceed to trial, the state would show that on April 29th, 2023, officers of the Atlanta Police Department responded to a weapon call at 1134 Moreland Avenue Southeast. That's in Atlanta, Georgia, and also in Fulton County. When the officers got there, they spoke with the victim, Mr. Tony Williams, in this case, who stated that the defendant, Mr. Greenway, pointed a handgun at him prior to the officer's arrival. Mr. Greenway was still on the scene, sitting in his vehicle at this time, and the officers approached him to talk to him about the disturbance or the weapon call. Mr. Greenway matched the description of the person that the victim described as the person who pointed the gun at him. When they talked to Mr. Williams in this case, he stated that he asked the defendant or said something to the sort as, "I heard about your incident last night." And Mr. Greenway replied saying, "Mind your effing business." And at that point, that is when the victim stated Mr. Greenway pointed a gun at him. Mr. Williams stated that Mr. Greenway then left the location and returned when he saw the police there. Mr. Greenway gave the officers permission to search his vehicle. When the officers searched the vehicle, they found a handgun, a black and silver Taurus handgun with 9mm rounds. At that time, the defendant was taken into custody and charged with the charges that we have here today, or the ag assault and the possession of a firearm during. All this occurred in Fulton County, and those are the facts of the case. Regarding the negotiated plea between the state and the defendant in this case, the state is asking for a 12-month probation for count one. And for special conditions of probation, we're asking for the defendant to complete an anger management course, 40 hours of community service, to stay away from the incident location. It's my understanding that it's like a liquor store or something, but to stay away from that incident location and to have no violent contact with the victim in this case. The state did get an opportunity to speak with the victim. He said since this has occurred, he saw the defendant out like in public and they squashed their beef. It's something where if they see each other now, they just dab each other up. He doesn't feel threatened or it's safety for his life if he sees Mr. Greenway. Also, Your Honor, when it comes to this reduction, it came after listening to the facts and circumstances of the case, how the victim felt, what he wanted out of the case, and kind of the I want to say inconsistencies regarding if Mr. Greenway pointed the gun or not, hence why he's taking it under the Alfred plea. But that is all from the state, Your Honor.
Got it. Thank you so much. Good morning, Ms. Stallworth. How are you?
My apologies. Good morning. How are you?
I'm doing all right. Can you share whatever criminal history information you have on Mr. Greenway?
Yes, Your Honor. Mr. Greenway has 4 cycles total and no felony convictions listed.
And what's the most recent cycle?
One moment.
Thank you. Perfect.
It would be. There was a DUI in October of 2025 from the city of Atlanta. No disposition listed. It was a misdemeanor though.
Got it. Thank you.
You're welcome.
Mr. Greenway, tell me what you do for a living. You've probably told me before, but I don't
I'm a
remember.
surgical technologist.
Where do you do that?
At the Atlanta VA.
How long have you done that?
Since 05, close to 20 years.
Okay. And how do you know Mr. Williams?
I didn't know Mr. Williams before the incident.
It was just sort of happenstance that you guys were in the same place?
Well, I guess it was kind of like happenstance, but can I speak?
It's your turn.
The night before, I was actually shot at, and my windshield was shot out of my car.
Okay.
So the next morning.
Near this liquor store?
Yeah.
Okay.
So the next morning, that was the reason for me having my handgun on me. I went to the store because I know the owner of the store to maybe look at the surveillance tape to see who did it so that possibly I could press charges.
Mm-hmm.
I encountered Mr. I don't even really know his name or whatsoever.
Okay, Mr. Williams.
As I was passing out of the store. And he did say something to me, and I just glanced at him and kept going. I got in my car before I could put my gun in the glove compartment and everything and get my watch. Whatever I was doing, police came out of nowhere. I never even knew Mr. Williams had anything to do with being a witness until I was locked up at pretrial at my bond hearing.
Okay. Have you seen Mr. Williams since you bonded out?
Yes.
In what capacity?
At the grocery store, because evidently we stay in the same area. This was in the area where we stay at. And I was in the grocery store and he approached me and introduced himself to me.
Okay. And you still live in that same area?
Yes.
All right. So you might encounter him again.
Mm-hmm.
Okay. All right. So you've been a surgical tech for a long time, steady job. You have decided to move forward without an attorney. Is that correct?
Mm-hmm.
And that's after a lot of thought and a lot of discussions that you and I have had.
Yes.
Okay. And you're comfortable continuing to do that?
Yes.
All right. You understand that you are entering an offered plea, which is, we also call it a best interest plea, where you say, I don't think it happened exactly the way the state says it happened, but I like this offer enough that I want to move forward. Is that a fair description?
Yes, it is.
Okay. You understand it's still going to show up on your criminal history as a misdemeanor, pointing a pistol at another.
That's fine.
What's the status of your DUI? I don't want you to tell me anything about the facts, just you got arrested not all that long ago for a DUI. Is it going to be a trial? Has it been dismissed?
I'm going to take a plea deal
in
that case also.
You're working it out in state court?
Mm-hmm.
Okay. That'll be another misdemeanor.
Mm-hmm.
Yes? Okay. All right. Anything else you want to share with me about your life or this situation?
No, I just have one question.
What's that?
Where would I be able to get my firearm back if possible?
Well, that's a good question because I was going to address that. Why are you so anxious to get it back?
No, because it's a nice gun and I actually paid a good little penny for it. And since I worked the deal to get it reduced, I knew if I would have been convicted of a felony or it didn't get dropped down, I know that was bye-bye to the weapon.
Right.
But since I worked the deal to where I don't have the felony anymore, just a question.
Got it. Okay. Once you get your final disposition, that's the paperwork indicating what your sentence is, you could, it sounds like this is Atlanta police, it should be an Atlanta police property somewhere. And so you would go saying, look, this was my arrest number or ticket number or whatever it was, and I'm trying to track down my firearm. You should release it. They may say, well, we need an order from the court or whatnot. I'm happy to assist you with that. But you'd want to start with the Atlanta police.
Okay.
And I don't mean to make it sound like it's a simple process. You may have to go from place to place to place, but if you're motivated enough, it ought to still be sitting in evidence. Okay?
Okay. And the only reason why I asked, because like I say, I don't have a firearm now because I knew there was a no-no under my bond conditions.
No, I appreciate
and I have a family at home and no protection. And like I say, this whole incident started with me being
shot at. Right.
Exactly.
Any idea why someone would shoot at you?
Yeah. I was actually sitting in the car about to leave, and some panhandlers walked up and was asking for spare change. And I never rolled down the window and waved them off. They went within an alleyway, and I found this out the morning when I went to look at the tape. And one of the guys gave the female the gun, and she shot at me. She actually shot at me twice.
Really?
The first time, I just thought it was random shooting. The second time, as I looked up, I could see the trajectory of the bullet coming, and if the caliber gun would have been big enough, I might have only been sitting here today. It hit right where I was sitting at, and I had to duck, and it shattered my windshield.
Wow. Okay. So it was the panhandlers. All right. And you want a gun because you're going to shoot back at them?
No.
No.
No, I want a gun so I can protect myself.
Okay. All right. Those are fair questions, and I've given you what I can share, which is you start with the Atlanta police and say, look, my case is closed now. I'd like my property back, because that's what it is, it's your property. If they say they need an order from the court, then you know how to find me.
Okay, no problem.
All right. Well, Mr. Greenway, I find there's a factual basis for your plea. I appreciate it's an offered plea. But if Mr. Williams came in here and testified one way, a jury could believe him. I don't know how that would play out. I understand why you want to put this behind you. I also find that your plea is knowing, meaning you've understood what we talked about, and voluntary. No one's forced you to enter this plea. Do you agree with that?
Yes.
Okay. Mr. Greenway, we now typically electronically sign the indictments rather than hand them around. Do you authorize someone in my office to electronically sign your name to the indictment indicating your offered plea to the misdemeanor that count one has been reduced to?
No problem.
No problem. Okay. Ms. Smith, can we sign for you? All right. Mr. Greenway, I will follow the negotiated resolution and sentence you to count one, which has been reduced to pointing a pistol at another, to 12 months probation. During those 12 months, you'll need to complete an anger management course, and probation can help you find that. You'll also need to complete 40 hours of community service and stay away from that address on Moreland Avenue. It's probably good for your safety if that's where you got shot at. And then no violent contact with Mr. Williams. You guys live in the same neighborhood. So if you see him, you can wave, do whatever, but don't point a gun at him.
I ain't gonna do nothing to him.
I don't think you will, but that's just, I understand why the state has asked for that to be a condition of your sentence.
Gotcha.
All right. And if you complete that anger management course and that community service promptly, you can ask misdemeanor probation to reach out to me about ending your probation early. If things are going smoothly and you've taken care of all those obligations, I'm open to an early termination. Okay.
Thanks a lot.
There is a form. You'll do that? Thank you so much. Ms. Simpson is with felony probation, so you're not going to have to mess with her.
Okay.
But she's going to give you a form that you do need to fill out with all the contact information so that misdemeanor probation can reach out to you. When they call you or do whatever they do, you need to respond. Because if they reach out to me saying, we can't find Greenway, I'm going to sign a warrant, and you've turned everything upside down. Okay?
No problem.
So work with Ms. Simpson and filling that form out. Once that's been filled out, you are good to go.
Okay.
Any questions about anything?
No, but I just want to thank the court. And thanks to the DA, Ms. Smith, for working with me or whatsoever. And thanks for working with you because you seem pretty fair. I've seen you a lot on TV in bigger cases or whatsoever.
All right. Well, now you know in real life I'm fair, not just on TV.
And I just recently had twins about a year ago.
Well, congratulations.
So if I could have afforded a lawyer, I think I could have beat this.
You may well have, but I also understand why you made the decisions you did. I'm excited for you. Boys, girls, one of each?
2 boys.
2 boys. So how many other kids in the household?
No more in the household. I actually have a sophomore in college, a senior in high school, and a sophomore in high school. I'm too old to do that again. I know.
Yeah,
Say no more.
you're in the medical profession. You should know how, like, babies don't fall from the sky.
Oh, I know it, but
Yeah, twins. Whew. Well, congratulations. You've reset the parental clock by 18 years.
who you telling?
Well, I'm telling you and their mother. Good luck with all that. Okay. Meet with Miss Simpson and then you're good to go.
Okay.
All right. Thank you, Miss Smith.
Thank y'all. Thank y'all. You couldn't.
And Judge, I'm ready at the court's convenience, so I'm at federal clock.
Okay. I think we ought to see if we can pull that one off. This is going to be a feat. So if you'll come to the podium, Mr. Sperling. This is going to be really complicated. Why don't you be up here at the witness? Because there's a microphone right there. Ms. Nix, can you fire up your camera, please?
And Judge, can I talk to my client very briefly to let him know there's an interpreter that he can't see?
Yeah, he can see.
Mr. Perez, can you hear me well?
Yes.
Okay, there is an interpreter here in the courtroom that you might not be able to see, who is going to be translating all that is said between me, the prosecutor, and the judge. Do you understand that? Go ahead.
Yes, and he can see the interpreter. There are four people on the screen,
Good deal.
one of which is our translator. Okay?
Señor Jesús, ¿me puede ver y escuchar?
Correcto.
Ah, okay, yeah. He can see me and hear me.
Bueno.
Muy bueno.
Okay, we're going to get on the record.
Señor, vamos a empezar con el acta.
This is 25 SC 004-795.
Su número de legajo es 25 SC 004795.
State versus Enriquez Perez.
Sí, es el estado de Georgia en contra de Enrique Pérez.
Mr. Enrique Perez is appearing from the Robert A. Dayton Detention Facility.
El señor Pérez está presente a través de Zoom desde la cárcel federal Robert A.
Dayton Detention Facility.
Cárcel.
He is represented by Attorney Sperling.
Su abogado, he left. Do you see him, Your Honor?
Yeah, well, we see someone else there. Are you still there, Mr. Enriquez?
Señor Jesús. Ah.
Sí.
Yes.
Okay. The camera moved somehow and it's showing a guard through a window.
Sí, se movió la cámara, me parece. Estoy viendo al oficial en la puerta. ¿Qué pasó?
No lo sé.
I don't know.
Can you please kind of remove the camera or reposition the device so we can see you?
¿Usted tocó el aparato, la computadora, algo? ¿Lo puede mover?
El aparato está arriba del televisor.
There you go. You're back.
Ahí volvió.
Okay. The state is represented by Ms. Nix.
El estado está representado por la abogada Nix y a usted lo representa el abogado Sperling.
I will now swear in our translator.
Ahora, el juez va a tomarle juramento a la intérprete.
Do you swear or affirm that you will translate to the best of your ability from English to Spanish and Spanish to English?
Yes, Your Honor, I swear.
Thank you. Mr. Enriquez Perez, you may understand what is said in English, but I need you to wait until the translator translates it before you answer.
Señor Enrique, quizás usted entienda lo que yo digo en inglés, pero necesito que espere a que el intérprete interprete todo antes de contestar.
Okay.
Okay.
And you may, if you choose, answer in English, but it's what the translator says that will be your official answer on the record.
Si usted quiere contestar en inglés, lo puede hacer. Solamente espera que el intérprete interprete lo que nosotros decimos al español.
Entiendo.
Understand.
Ms. Nix is going to put you under oath in just a moment.
La señora Nix le va a tomar juramento a usted en un momentito.
After that, she will ask you questions about your rights and about this case.
Después, ella le va a hacer preguntas acerca de sus derechos y del caso.
You need to answer her questions truthfully and completely.
Usted necesita contestar en forma completa y con la verdad.
You also need to let me know if at any time you have a question or you cannot hear what is being said.
Usted en cualquier momento me puede decir que no entiende la pregunta que le hago o nos puede decir que no ha podido escuchar correctamente.
Will you do that?
¿Lo va a hacer?
Sí.
Yes.
Excelente. Ms. Nix.
Señora Nix.
Thank you, Judge. Mr. Perez, please raise your right hand.
Señor Nix, señor Pérez, levante la mano derecha.
Do you swear or affirm that the testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
¿Usted jura y afirma que el testimonio que va a dar aquí en el caso que usted tiene frente al juez va a ser la verdad, toda la verdad y nada más que la verdad?
Lo juro.
I swear.
You can put your hand down.
Baje la mano.
Please state your true, correct, and legal name.
Díganos su nombre completo para que conste en actas.
Jesús Pérez Enríquez.
Jesús Pérez Enríquez.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
¿Usted está bajo la influencia de alguna medicina, drogas o alcohol?
No.
No.
Is there a medication that you normally take that you have not taken or been given today?
¿Hay alguna medicina que usted toma a diario y hoy no la ha podido tomar?
No.
No.
How old are you?
¿Qué edad tiene?
45 años.
45.
How far have you gone in school?
¿Hasta qué grado fue la escuela o qué nivel educativo terminó?
Primaria.
Elementary.
Do you understand that you've been charged with the following offenses? Count 1, aggravated sexual battery.
Usted ha sido acusado con los cargos que le voy a mencionar. El cargo número 1 es agresión con agravante sexual.
And count 2, criminal attempt to commit rape.
Y el cargo número 2, intención penal de cometer una violación. ¿Entiende?
Sí.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
¿Usted entiende que podría declararse culpable o no culpable de estos dos cargos?
And if you
Correcto.
plead not guilty,
Correct. Mhm.
and if you plead not guilty or remain silent, you may receive a jury trial.
Y usted entiende que si se declara no culpable o se mantiene en silencio, usted tendría el derecho de llevar el caso a juicio, ¿lo entiende?
Lo entiendo.
Understand.
Mr. Enrique Perez, your lawyer has explained to me that you are entering your plea today because you've decided that it's in your best interest to do so. Is that correct?
Señor Pérez, su abogado me explicó a mí que usted quiere declararse a cargos hoy porque, según lo que usted habló con él, es para su mejor interés o es mejor para usted. ¿Es así?
Es correcto.
That is correct.
In other words, you disagree with the evidence that the state will share with me in a little while, but despite that disagreement, you want to resolve your case today.
Lo que quiero decir es que en un momento la fiscal va a mencionar las evidencias que tienen del caso en contra de usted. Usted está en desacuerdo con esas evidencias, pero aún así usted quiere declararse a cargos hoy. ¿Es verdad?
Es correcto.
That is correct.
Okay, I will let that happen.
Voy a dejar que eso suceda.
Gracias.
Thank you. Mr. Perez, have you reviewed your rights with your attorney?
Señor Pérez, ¿usted revisó el documento con la lista de derechos que usted tiene con su abogado?
Sí.
Yes.
Have you had enough time to speak with your attorney, Mr. Sperling, about all of the facts and circumstances known to you regarding the charges in this indictment?
¿Usted ha tenido tiempo suficiente para hablar con su abogado, el señor Sperling, acerca de los hechos que están mencionados en su documento oficial culpatorio?
Correcto.
Correct.
Do you need more time to discuss the case with your attorney?
¿Usted necesita más tiempo para seguir hablando con su abogado?
No.
No.
Are you satisfied with his services?
¿Usted está satisfecho con el trabajo de su abogado?
Sí.
Yes.
Mr. Sperling, are you satisfied that your client has a full understanding of this proceeding?
Señor Sperling, ¿usted cree que su cliente ha entendido completamente lo que está sucediendo aquí?
Yes, ma'am.
Sí, señora.
Do you waive a formal reading of the indictment?
¿Usted va a renunciar a la lectura formal de la acusación?
We do.
Sí, lo hacemos.
And do you waive any and all defects in the indictment?
¿Y usted también renuncia a cualquier defecto que pudiera haber en esta acusación formal?
Yes, ma'am.
Sí, señora.
Mr. Perez, can you confirm that you have been arrested on these charges?
Señor Pérez, ¿me puede confirmar si usted fue arrestado por estos cargos?
Correcto.
Correcto.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading best interest to?
¿Su abogado le ha dicho cuál podría ser la sentencia mínima y la sentencia máxima por cada uno de los dos cargos que usted tiene?
Sí.
Yes.
And Judge, for the record, I think I would respectfully ask for the prosecutor to put that on the record, if you will, please. What the maximum is for each one of those offenses.
Sí, su señoría, le voy a pedir por favor que la fiscal diga y mencione para que conste en actas cuál es la sentencia mínima y la sentencia máxima de estos cargos.
Yes, one moment.
Sí, un momento.
The minimum is 1 year and the maximum is 30 years.
Bueno, la sentencia mínima podría ser 1 año, la máxima 30.
You understand that, sir?
¿Entendió, señor?
Entendí.
Understood. To criminal attempt to commit rape.
Eso es solamente por el cargo número 2, de la intención penal de cometer una violación.
That is correct. And on count 1, sir, for aggravated sexual battery, that offense carries a mandatory minimum of 25 years to a maximum sentence of life in prison. Do you understand that?
Ahora, el cargo número 1 que usted tenía de agresión con agravante sexual, ese tiene una sentencia mínima obligatoria de 25 años y podría también recibir, lo máximo sería cadena perpetua, ¿entiende?
Entiendo.
Understand.
Do you understand that this is a negotiated plea of guilty, which means that the joint recommendation to the court is a sentence of 10 years, that you serve 1 year with the balance on probation?
¿Usted entiende que esta declaración a cargos y la sentencia ha sido negociada entre los abogados y que se la vamos a presentar al juez? La sentencia negociada fue de 10 años a cumplir 1 año en la cárcel y el resto bajo libertad condicional. ¿Lo entiende eso?
Lo entiendo.
I understand.
Lost the visual on my client.
But he's still there.
Okay. It hopefully will bounce back, but as long as we can hear him and he can hear us, I'm comfortable proceeding.
Ok, no lo podemos ver otra vez, pero el juez dice, ahí volvió. Que mientras lo podamos escuchar, estamos bien continuando. ¿Entendió
Yo
lo
lo
que
veo
puedo interpretar?
Todo, escucho y veo perfectamente todo.
Yeah, it goes back. I can hear you all and I can see you all perfectly. And the answer to the last question from Ms. Hicks is yes.
And just for the record, Ms. Nix, and that is with the understanding that the state will be no prosing count 1 for aggravated sexual battery and that his guilty or his nolo contendere or Alford plea would be entered on count 2. Is that correct?
Ok, y quiero agregar a lo que acaba de decir la fiscal que esta sentencia sería por el cargo número 2, al cual usted va a poder declararse nulo bajo Alford. En la negociación fue que el cargo número 1 iba a ser desechado.
Yes, that is a sentence to count 2 and under an Alford plea, and count 1 is null prost.
Correcto. Esta declaración a cargos es del cargo número 2. El cargo número 1 se desecha.
Correcto.
Correct.
Mr. Perez, are you aware that the court does not have to accept that recommendation and can sentence you to the maximum on each charge?
Señor Pérez, ¿usted entiende que el juez no está obligado a aceptar esta negociación entre abogados y que el juez podría sentenciarlo a lo máximo que la ley le permite?
Entiendo.
Understand.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you are expecting today, you may withdraw your guilty plea?
¿Usted entiende que si el juez lo sentencia a algo diferente a lo que habíamos negociado con los abogados, usted puede retractarse y no declararse a cargos? ¿Lo entiende eso?
Ok, entiendo.
Okay, I understand.
Do you understand that the offense you are pleading to is a sexual offense?
¿Usted entiende que el cargo el cual se está declarando es un cargo sexual?
Sí, entiendo.
Yes, I understand.
Do you understand that you'll be subject to additional special conditions of probation as a result of pleading to this offense?
Y usted entiende que al declararse a este tipo de cargos, usted va a tener unas condiciones especiales cuando usted esté en libertad condicional.
Sí, entiendo.
Yes, I understand.
Have you been informed of those additional special conditions of probation?
¿A usted ya le explicaron cuáles van a ser esas condiciones especiales cuando esté en libertad condicional?
Me lo explicó el abogado.
The lawyer explained it to me.
Did you complete and sign the following documents that detail those special conditions of probation?
Usted leyó y firmó estos documentos de libertad condicional donde estaban detalladas estas condiciones especiales?
Sí.
Yes.
The sex offender special conditions probation form?
Entonces usted firmó ese documento que es el documento de libertad condicional y condiciones especiales. ¿Ese documento firmó?
Judge, he has not signed that document. I did not have that document when I went to visit with him at the federal facility. Go ahead, ma'am.
No, él no tiene ese documento porque cuando yo lo fui a visitar a la cárcel federal, yo no tenía conmigo ese documento.
I did explain the conditions of probation if he was to not be deported.
Yo le expliqué a él cuáles serían las condiciones de libertad condicional si es que él no es deportado.
I did explain that he would have to register as a sex offender in the event that he was not deported.
De no ser así, si no lo deportan, usted tendría que anotarse en el registro de delitos sexuales.
However, it is my firm belief that he will be deported as a result of this guilty plea. So therefore, whether he would have to report and register as a sex offender, that would be subject to him remaining in America. That's what my explanation was.
Pero, como ya le expliqué a él, creo que él va a ser deportado debido a la declaración a cargos de este cargo que tiene hoy. Pero, si no lo deportan y se queda en el país, usted va a tener que seguir estas condiciones especiales. Una de ellas es registrarse en este registro de ofensas sexuales.
You understand that, sir?
¿Entendió todo eso?
Sí, entendí.
Yes, I understood.
Thank you, Judge.
Regardless of whether he has to do them or not, if he's in the United States, he still has to sign them as operation of law because they are the conditions.
Okay, we'll work through that. He just hasn't signed them yet.
Igualmente, si se queda o no se queda en el país, va a tener que firmar ese documento. Y el juez acaba de agregar que sí, que en algún momento vamos a hacerle llegar ese documento para que lo pueda firmar.
Está bien.
That's fine.
Do you understand that as a result of a conviction for this offense, you will be required to register as a sex offender?
¿Usted entiende que al declararse de esta ofensa o este cargo, usted va a ser un delincuente sexual? Usted va a tener que estar registrado en ese registro que le expliqué. ¿Lo entiende?
Sí, lo entiendo.
Yes, I understand.
Do you understand that you would be required to register even after you are no longer under sentence for this offense?
The interpreter didn't understand completely. Can you repeat, please? Le estoy pidiendo que repita porque no me quedó claro.
Yes, I'm sorry. Do you understand that you will be required to register even after you are no longer under sentence for this offense?
Entiendo. Entonces, ¿usted entiende que una vez que usted concluya con la sentencia, igualmente usted va a estar siempre en ese registro, va a quedar registrado para siempre? ¿Lo entiende?
Sí, lo entiendo.
Yes, I understand.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
¿Usted entiende que cuando esté en libertad condicional, usted no puede quebrantar ninguna ley estatal o federal durante ese periodo?
Or any special conditions of probation without being subject to revocation of the balance of your sentence?
Y si usted viola o quebranta alguna ley o alguna de las condiciones que se le van a implementar por estar en libertad condicional, usted estaría sujeto a una revocación y podría ser sentenciado a la cárcel. ¿Usted entiende eso?
Sí, lo entiendo.
Yes, I understand.
Do you understand that this Alford plea is a plea which is permanently recorded on your criminal history?
Usted entiende que usted se va a declarar bajo Alford, pero aún así esta declaración a cargos va a quedar registrada en sus antecedentes. ¿Usted lo entiende eso?
Sí, lo entiendo.
Yes, I understand.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
¿Usted entiende que esta declaración a cargos de hoy puede ser utilizada en el futuro en otra jurisdicción o aún en el Tribunal Federal para agravar o aumentar una sentencia en futuro si le sucediera? ¿Usted me entiende?
Sí, lo entiendo.
I understand.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
¿Usted entiende que si ahora usted está bajo libertad condicional o libertad vigilada, declararse a cargos hoy aquí provocaría que revocaran este tiempo que usted estaría en libertad condicional o en libertad vigilada?
Sí, lo entiendo.
Yes, I understand.
Do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, just as a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else?
¿Usted entiende que si usted no es ciudadano de los Estados Unidos de América, su situación inmigratoria podría ser afectada en forma negativa con esta declaración a cargos, incluyendo la deportación? Es igual como si usted hubiese ido a juicio y lo hubiesen encontrado culpable. Y no importa la consejería que le haya dado su abogado en cuestión de este tema, así es como funciona. ¿Usted entiende que podría ser deportado?
Sí, lo entiendo.
I understand.
Do you understand that neither the court, your attorney, nor the DA's office has anything to do with parole, the Department of Corrections, or the Board of Parole, Pardons and Paroles, and no one can guarantee parole?
¿Usted entiende que ni el juez, ni su abogado, ni la fiscal trabajan o pertenecen al Tribunal de Libertad Vigilada y que nosotros no tenemos ningún control sobre eso? ¿Lo entiende?
Sí, lo entiendo.
Yes, I understand.
Do you understand that there may be other adverse or unfavorable consequences as a result of this plea, just as there would be from a conviction following trial?
¿Usted entiende que, además de todo lo que le dije, quizás haya otras consecuencias negativas como resultado de que usted se declare a cargos hoy como si hubiese ido a juicio y lo hubiesen encontrado culpable? ¿Lo entiende?
Sí, lo entiendo.
Yes, I understand.
Do you understand that by pleading to a felony, you may not receive, possess, or transport a firearm, or use a firearm in a crime?
¿Usted entiende porque se está declarando culpable de un cargo mayor, usted no puede tener, no puede portar y no puede usar un arma de fuego? ¿Lo entiende?
Lo
Or you will
entiendo.
be
I understand.
or you will be guilty of a felony which may carry a sentence of up to 15 years in prison.
Porque si así lo hiciera, a usted le podrían imponer otro cargo mayor cuya sentencia podría ser de hasta 15 años. ¿Lo entiende?
Lo entiendo.
I understand.
Do you understand that you are not allowed to possess or use a firearm while on probation?
¿Usted entiende que durante el periodo que esté bajo libertad condicional usted no puede usar armas? ¿Lo entiende?
Lo entiendo.
I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty or Alford plea or best interest plea?
¿Usted entiende que al declararse a cargos hoy aquí, usted renuncia a todas las defensas que usted podría tener, incluyendo la defensa de incapacidad mental, aún declarándose bajo Alford? ¿Lo entiende?
Lo entiendo.
I understand.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not criminate yourself.
¿Usted entiende que si se declarara no culpable, usted tendría el derecho de ir a juicio frente a un jurado, usted tendría derecho a ver, escuchar y hacerle preguntas a los testigos que vinieran a declarar en su contra? Usted también tendría el derecho de testificar si así lo quisiera, o también usted tendría el derecho de mantenerse en silencio.
Okay.
Okay.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury,
Usted entiende que si se declara culpable hoy aquí, renuncia a los siguientes derechos que le voy a mencionar. Uno es el derecho de llevar su caso a juicio frente a un jurado.
the right to remain silent and not incriminate yourself,
El derecho de mantenerse en silencio y no incriminarse.
the right to confront witnesses against you,
El derecho de hacerle preguntas a los testigos.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case.
Usted renuncia al derecho de tener un abogado presente durante ese juicio. Podría ser el abogado que usted ya tiene, o si no tuviese dinero para contratarlo para el juicio, el tribunal le nombraría un abogado de oficio.
The right to
Okay,
the
lo
presumption of
I
innocence.
understand. Sorry.
The right to the presumption of innocence,
Usted también renunciaría al declararse culpable a la presunción de inocencia.
the right to testify on your own behalf and present other evidence,
También renunciaría a su derecho de dar testimonio y presentar sus propias evidencias.
the right to subpoena witnesses and compel the production of evidence,
También renunciaría a su derecho de presentar sus propios testigos y presentar sus propias evidencias.
the right to have the charges against you proved beyond a reasonable doubt,
El derecho de que la fiscalía demuestre su culpabilidad más allá de duda razonable.
and the right to appeal if convicted of these charges after a trial.
Y también su derecho a apelar si fuera encontrado culpable en ese juicio.
Entiendo.
I understand.
Has anyone forced, threatened, or promised you anything to get you to enter your plea?
¿Alguien lo está forzando, amenazando o prometiéndole algo para que usted se declare hoy aquí?
No.
No.
Are you pleading guilty because you have decided that it is in your best interest to do so?
¿Usted se quiere declarar culpable porque usted cree que es en su mejor interés?
Correcto.
Correct.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
¿Usted entiende que aunque usted no está admitiendo culpabilidad, declararse culpable es igual a que si hubiese ido a juicio y en el juicio lo hubiesen encontrado culpable? ¿Usted no entiende eso?
Lo entiendo.
I understand.
How do you plead to the charge of criminal attempt to commit rape in indictment number 25 SC 004795?
Entonces, ¿cómo se declara del segundo cargo que usted tiene en su contra de intención penal o criminal de violación? Es el caso 25 SC 004795. ¿Cómo se declara de ese cargo?
Me declaro nulo.
And Judge,
Hold on one sec. Is that your client?
No. I don't know.
Okay.
Hubo una interrupción porque hay un poco acá de alboroto con un preso.
Yes, sir.
in that regard, Judge, for the following reasons, my client has respectfully requested for the court to accept a nolo contendere plea.
Okay.
Su abogado acaba de intervenir y él no quiere que usted se declare culpable, él quiere que usted se declare nulo. No lo contesta, vendría a ser.
Outline the reasons why the court should consider that at the appropriate time.
Y yo le voy a decir al juez, cuando llegue el momento apropiado, del por qué quiero que acepte el nulo no culpable.
Lo entiendo.
I understood.
Yo me declaro nulo.
I declare nulo. I want to plead nulo.
Okay, we'll get to that, Mr. Enrique, not quite yet.
Ahora ya vamos a llegar a eso, señor Enrique, todavía no.
Okay.
Ok.
Is this plea freely and voluntarily given with full knowledge of the charges against you?
Usted se está declarando en forma libre y voluntaria y con completa, y sabiendo completamente el caso en su contra.
Sí.
Yes.
Do you understand that you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of your plea?
Usted entiende que tiene a partir de hoy 4 años para hacer un habeas corpus, que básicamente usted está diciendo que usted no se declaró a cargos en forma voluntaria. ¿Lo entiende?
Sí, lo entiendo.
Yes, I understand.
Judge, had this case gone to trial, the state would expect the evidence to show that on December 15th, 2024, the defendant did perform an act which constitutes a substantial step towards the commission of rape with the intent to commit rape.
All right,
Si fuéramos,
pause.
si fuéramos a juicio, la Fiscalía podría demostrar que el día 15 de diciembre del 2024 el acusado cometió un acto que constituye, según la ley, una violación.
By attempting to penetrate the vagina of Kaylee McCutcheon, Kailee McCutchen, with his penis.
Él intentó penetrar la vagina de Kaylee McCutcheon con su pene.
This defendant took her, Ms. McCutcheon, who was a waitress at his restaurant, back to an apartment that he was staying at while she was intoxicated.
Él se llevó a la señora Hutchins, que era una moza en el restaurante de él. Él se la quiso llevar al hotel.
And attempted to have sex with her without her consent and while she was in and out of consciousness.
Ella estaba intoxicada o bajo la influencia del alcohol y él trató de violarla. Ella estaba como ida y venía por el alcohol.
This occurred in Fulton County.
Todo esto ocurrió en el condado de Fulton.
Judge, Ms. McCutcheon is on the Zoom and would like to make a statement.
La señora Hutchins está aquí en el Zoom y quiere hacer una declaración.
Okay. Ms. McCutcheon, I'm going to hear from you in 1 second. When I do, I need you to turn your camera on. Before we get to that, Ms. Stallworth, could you share with me if there is any criminal history information for Mr. Enrique?
Bueno, señora McCutcheon, todavía no vamos a hablar con usted, me va a dar un momentito. Cuando llegue ese momento le voy a pedir por favor que prenda la cámara para dar su declaración. Pero antes de llegar ahí, vamos a hablar con la señora Stowell, que nos va a decir cuáles son los antecedentes penales del acusado.
Yes, Your Honor. There are 10 cycles total, 4 from ICE and 6 from Georgia.
4 from where?
ICE.
ICE. Tiene 10 ciclos en total. 4 son de ICE o inmigración, 6 son de aquí de Georgia.
There was a 2016 alien inadmissibility under Section 212.
El 2016 es entrada ilegal de un extranjero.
The last date of arrest was November the 14th of 2025 for illegal entry.
Y el último es del 14 de noviembre del 2025, una vez más, por entrada al país en forma ilegal.
Thank you.
Gracias.
And Judge, one very brief correction regarding
Yes.
some of these ICE contacts. The latest in 2025 is not that he entered the U.S. illegally. it's when he went to ICE custody after posting bond on this matter.
Understood.
Su abogado acaba de clarificar la interpretación incorrecta que yo hice porque yo dije que el 14 de noviembre del 2025 fue el último contacto con ICE cuando usted ingresó ilegalmente al país. Es incorrecto. Eso fue porque usted fue al Tribunal de Inmigración después de haber salido bajo fianza.
Ms. McCutcheon, I'd like to hear from you now if there's something you want to share. Let me get you on the screen as well. Good morning. Thank you for joining us.
Thank you for having me. Can you hear me okay?
I can. So I have one request, and that's that you share a little bit of what you have to say and then pause so our translator can translate it into Spanish. And then you sort of have to break it down into bite-sized chunks. I want to give you a complete opportunity to say everything, but we have to break it into pieces, okay?
Buenos días, señora Kylie McCutcheon. Gracias por estar aquí presente. Yo voy a permitir que usted diga lo que tiene que decir. Solamente le voy a pedir, por favor, que vaya haciendo pausas cada 2, 3 oraciones para que el intérprete pueda interpretar y usted puede continuar hablando de lo que usted quiera hablar.
When you're ready.
Cuando esté lista.
Attempting to put this into words feels minuscule in comparison to the ways I've suffered because of what Jesus did to me.
Bueno, poner en palabras lo que quiero decir, lo que me pasó, es minúsculo comparado con lo que él trató o hizo conmigo.
There aren't words strong enough to capture the impact of his actions, and there isn't any amount of time or punishment that will undo what he chose to do.
No es suficiente las palabras que puedo decir para captar lo que él hizo conmigo y lo que él ha perpetrado o lo que él trató de hacer conmigo.
For over a year, I've lived in a state of fear, flashbacks of the defendant's violence woven into my everyday thoughts.
Por más de un año he estado viviendo en temor y recordando lo que pasó, lo que este acusado hizo conmigo.
The heaviness of fear gripping my chest and moments where I've been tempted by thoughts of not wanting to be here anymore just to find peace from the emotional turmoil.
Este temor que he sentido fue tan pesado en mi pecho que muchas veces he sentido que quizás irme o terminar con mi vida podría de una vez encontrar la paz.
Jesus took something from me that I can't get back. What he did was cruel. It was a choice to violate me, to hurt me, and to ignore my humanity.
I'm sorry.
Yeah, Ms. McCutcheon, if you could say that again. We had someone have a little bit of an outburst, totally unrelated to your case. And I don't think the translator could hear you. And I'm sorry, I know this is difficult for you to get through. But if you could repeat that part once.
Lo siento mucho, señora, pero hubo mucho ruido aquí, la intérprete no la pudo escuchar. Entiendo que esto es algo muy difícil para usted, pero si nos podría, por favor, repetir lo último que dijo.
Jesus took something from me that I can't get back. What he did was cruel. It was a choice to violate me, to hurt me, and to ignore my humanity.
Él tomó o se robó algo de mí esencial con esta acción que él decidió hacer en contra de mí y violarme.
The weight of his actions is something I'm forced to live with every day, but his choices didn't affect just me. The harm Jesus caused reaches beyond me, and that responsibility is his to carry. That's all. Thank you.
Y estas acciones que él tomó no solamente afectaron mi vida, pero afectaron más allá de eso, y él es responsable de las acciones que él decidió tomar. Gracias, esto es lo que quería decir.
Ms. McCutcheon, I very much appreciate you joining us. I know that wasn't easy to talk about, but it's very important that I hear from you. So thank you.
Señora McCutcheon, entiendo, muchas gracias por haberse presentado. Entiendo que esto no es fácil para usted, pero es muy importante escucharla. Muchísimas gracias.
Mr. Sperling.
Señor Sperling.
You're up.
So this is an incident, Judge, that happened about a year and a half ago, give or take. This was after a night of drinking. My client was a part owner of the restaurant where the alleged victim worked.
All right.
Ujú.
My apologies.
Su señoría, este incidente ocurrió hace más o menos 1 año y medio atrás. Fue una noche de tragos en el restaurante que mi cliente es dueño junto con la supuesta víctima. Y no, mi cliente es dueño de este restaurante donde la supuesta víctima trabaja.
Several people, including my client, the alleged victim, and others, went dancing and drinking to a local club, I believe in Midtown, on that evening.
Ujú. Muchas personas, incluyendo mi cliente y la supuesta víctima, se fueron a bailar y tomar tragos a un lugar en el centro de la ciudad.
Everyone, including my client, had alcohol that evening.
Todos, incluyendo mi cliente, habían tomado alcohol esa noche.
My client went to an apartment along with the alleged victim, just the two of them, after a night of drinking.
Mi cliente se fue a un departamento con la supuesta víctima, solo ellos dos, después de haber pasado la noche tomando tragos.
At some point in time, they ended up in bed.
En algún momento de la noche terminaron en la cama.
And during the course of whatever happened in the bed, it is alleged that my client attempted to engage in sexual intercourse with the alleged victim.
Y durante algún momento de esa noche, cuando estaban en la cama, se alega que mi cliente quiso tener relaciones sexuales con la supuesta víctima.
Interestingly enough, in the discovery and in the alleged victim's own statements, she told police that when he attempted to sexually penetrate her, she said no and that he stopped.
Es muy interesante acotar que en los documentos de prueba, en la declaración que ella le hizo a la policía, dijo que cuando ella le dijo a él que parara, él paró.
And that is exactly why he was not indicted or ever charged with rape, but merely with criminal attempt.
Y es por esa razón que él nunca fue acusado de violación, sino de intento de violación.
This was a delayed disclosure for no reasonable reason because the allegations were made, I believe, 2 days after the incident and not immediate after.
Y no sé por qué la divulgación de los hechos se hizo tardía, porque no se divulgaron los supuestos hechos hasta 2 días más tarde.
There was absolutely zero act of violence on my client's end, not one.
No hubo ningún acto de violencia, nada, cero, por parte de mi cliente.
There were zero injuries to the alleged victim that would be consistent with a criminal attempt or with an attempt to rape somebody.
No hubo cero, nada, ninguna lesión en la supuesta víctima, ya sea hubiese sido una violación o un intento de violación. No hubo ninguna lesión.
My client was contacted by law enforcement, by a detective, contacted me. I made several attempts personally to contact that detective because he wanted to meet with the detective to provide his version of what had taken place.
Él fue contactado por un detective, después él me contacta a mí. Yo traté varias veces de ponerme en contacto con ese detective porque mi cliente quería ir a dar su versión de los hechos, qué es lo que había pasado esa noche.
We did some investigation as to the conduct of the alleged victim after the fact, and respectfully, some
I
of the
don't object to going into any
I will
of this
not
kind
go
of
there.
information.
I will not go
Thank you, Ms. Nix. Let's just stay focused on this situation. And I think you've shared with me why it is a best interest plea.
Yes, Judge.
Bueno, entonces yo hice más investigación por mi parte acerca de la conducta de la supuesta víctima. No. No vamos a hablar de la supuesta víctima. Sí, no. No vamos a hablar de eso. Usted ya lo compartió conmigo esa información, así que enfoquémonos en el por qué esta declaración a cargos es en el mejor interés de su cliente.
The last comment I will make is that a $10 million demand was
I'm also going to object to this kind of information, not relevant to the sentencing.
Okay, fair enough. Do you have any other last comments that won't draw an objection?
not regarding the.
El último comentario que quiero hacer es que se quiso hacer una demanda de $10 millones. No, objeto ese comentario. Una vez más, no vamos a hablar de eso. ¿Algún otro comentario que quiera hacer que no vaya a ser sujeto a una objeción?
Anything else in closing?
¿Algo más que quiera decir?
I greatly appreciate Judge Ms. Nix working with us, understanding that the case was extremely defendable from my perspective, and that is how we stand before the court to present a negotiated plea to these very serious charges in the fashion that we have.
Su señoría, solamente quiero decir que aprecio muchísimo a la señora Nix. Entiendo que este fue un caso que podríamos haber defendido, pero por eso estamos presentando esta declaración a cargos, porque es en el mejor interés de mi cliente y por eso lo estamos presentando de esta manera.
Judge, my client's 45 years old, has no convictions for any act of violence, I believe. I think he may have a number of traffic violations. He does have a simple battery from 2016 out of DeKalb County for which he was not convicted.
No, está bien. Su señoría, mi cliente tiene 45 años de edad, no tiene ninguna convicción en su récord de violencia. La mayoría de los casos que él tiene en su pasado es de tráfico y creo que tuvo uno solamente de agresión simple del 2016 del condado de DeKalb, donde no tuvo convicción, no tiene en su récord.
He has a 2-year-old daughter that he's basically going to lose as a result of this. He was a part owner of a business, I believe, that he has lost as a result of this. The effect of this incident has really ruined his life in many different ways and has been significant over and beyond the 1 year that he has spent in custody.
Él tiene una niña de 2 años a la cual no ha podido volver a ver por este caso. Él era socio en un negocio que ha perdido a causa de esto. Esto ha afectado a mi cliente de muchas maneras diferentes, más allá del año que él ha estado preso.
Judge, he was arrested on these charges on 4/25/2025. Today is April 21st, 2026. At some point in time, without providing the exact date, my client posted bond on these charges here in Fulton County, was picked up by ICE, spent a couple of months in ICE custody. Sorry, I'll pause for the interpreter.
Él fue arrestado el 25. The interpreter couldn't get the arrest date. It was 4/25/25.
2025.
Okay, sí.
April 25th.
Yeah, 1 year. Sí, él fue arrestado en abril 25 del 2025. Hoy es el 25 de abril del 2026. Él había puesto fianza para salir de aquí de Fulton y fue apresado por ICE, donde estuvo un par de meses preso.
Judge, he has been in continuous custody as a result of this arrest, whether partially in Fulton, partially with ICE, and partially in federal detention based on these charges. And respectfully, based on the pretrial that we had, I would kindly ask for the court to please accept the negotiated plea of 10 years to serve 1 year with credit specific running from April 25th, 2025 to today's date.
Entonces, su señoría, quiero aclarar una vez más que él ha estado continuamente preso en Fulton, en inmigración, en cárcel federal, por este incidente. Así que, su señoría, le quiero pedir, por favor, que acepte la negociación que ya estuvimos hablando. de 10 años a cumplir 1 año en la cárcel y que le dé crédito a partir del 25 de abril del 2025.
And Judge, for all of the reasons that I have expressed today, I would respectfully ask for the court to accept a novo contendere plea.
Por todas las razones, su señoría, que le expliqué y mencioné, le pido por favor que acepte una declaración de nolo.
Mr. Enrique Perez, is there anything you want to add to what your lawyer just said?
Señor Enrique Pérez, ¿hay algo que usted quiera agregar a lo que ya dijo su abogado?
No es necesario, ya el abogado lo dijo todo.
It is not necessary. The lawyer said it all.
Okay. Well, I'm going to say a few things now, and then we'll wrap up your plea.
Okay. Entonces yo voy a decir un par de cositas y después ya vamos a tomar su declaración.
I want to impress upon you, Mr. Enrique Perez, as well as Ms. McCutcheon, how serious this is.
Quiero decirle tanto a usted como a la señora McCutcheon cuán seria es esta situación.
Mr. Sperling referred to it as merely attempted rape.
El señor Sperling lo mencionó como que solo fue un intento de violación.
But there's nothing mere about that, as Ms. McCutcheon clearly showed us with the way this continues to have an effect on her.
Pero de la forma que la señora McCutcheon habló hoy aquí y nos dijo cómo esto ha afectado su vida, esto no podemos decir que solo casi fue algo.
And while I agree with Mr. Sperling that there wasn't evidence of physical injury, that's not necessarily the only proof that someone has sexually assaulted someone else.
A pesar de que estoy de acuerdo con el señor Sperling que no había evidencia de lesiones físicas, no es necesario una lesión física para demostrar que hubo una violación o intento.
Whatever happened on December 15th, 2024, deeply affected Ms. McCutcheon.
Sea lo que sea que sucedió el 15 de diciembre del 2024, ha afectado profundamente a la señora McCutcheon.
It has also deeply affected Mr. Enrique Perez.
También ha afectado profundamente al señor Enrique Pérez.
He has sat in jail for over a year.
Ha estado preso por más de 1 año.
He has lost contact with his 2-year-old daughter.
Ha perdido contacto con su hija de 2 años.
He's lost his investment in his business.
Perdió la inversión que hizo en su negocio.
And he will undoubtedly be deported from the United States as a result of this.
Y sin lugar a dudas va a ser deportado de los Estados Unidos de América por esta situación.
So there have been some very heavy consequences for Mr. Enrique Perez as well.
Así que han habido consecuencias bien pesadas en la vida del señor Pérez también.
I am willing to accept this as a best interest plea, like we discussed at the beginning. And I find, Mr. Enrique Perez, that there's a factual basis for your plea.
Bueno, voy a aceptar esta declaración a cargos como ya hablamos antes porque es el mejor interés y... Uy, acá frunce.
That doesn't mean that you agree with everything the state says that happened, but I find that the state could possibly convince a jury that it happened.
Y lo voy a aceptar porque hay base suficiente para la acusación. Usted quizá no esté de acuerdo con lo que diga la fiscalía, pero si yo creo que la fiscalía podría convencer a un jurado de que esto ocurrió.
Mr. Enrique Perez, I need to make sure that you want to go forward with the plea, despite the fact that it will virtually certainly result in you being deported or removed.
Señor Enrique Pérez, quiero estar seguro de que usted quiere declararse a cargos hoy aquí, a pesar de que esta declaración a cargos va a terminar con su deportación de este país.
Sí, ya deseo terminar con esto para poder rehacer mi vida, porque he perdido
Yes.
todo.
Yes, I would like to finish with this. I want to restart with my life.
But you understand you'll be restarting with your life not in the United States.
Pero usted entiende que va a reiniciar su vida fuera de los Estados Unidos.
Sí, lo entiendo.
Yes, I understand.
Okay. Then I find that your plea is knowing, meaning you've understood what we talked about, and voluntary, meaning no one's forcing you to enter the plea. Do you agree with that?
Entonces, encuentro que usted se está declarando a cargos a sabiendas. Quiere decir que usted entiende todo lo que está pasando. Y en forma voluntaria. Quiere decir que usted, nadie lo está obligando a declararse. ¿Está de acuerdo con lo que acabo de decir?
Sí, estoy de acuerdo.
Yes, I agree.
Mr. Sperling, can someone in my office electronically sign the indictment on your behalf?
Señor Sperling, ¿alguna persona en mi oficina puede firmar la declaración a cargos en su nombre?
Of course, Your Honor.
Por supuesto, su señoría.
Ms. Nix, can we sign for you?
Señora Nix, ¿podemos firmar por usted?
Yes, sir. But the defendant hasn't said that he'll plead best interest yet. So should you ask him if he'll plead best interest, or because he still has just said no?
Sí, su señoría, pero todavía el acusado no ha contestado que él se va a declarar a cargos porque es para su mejor interés. ¿Le podría preguntar eso? Porque todavía no lo dijo.
So I'm sorry, I thought I was clear. I'm accepting it as a best interest plea and he wants to go forward. So I took that as a yes, I want to go forward with this opportunity.
Bueno, yo creo que yo lo entendí bien cuando yo le dije a él que voy a aceptar su declaración a cargos porque es para el mejor interés de él. Él dijo que sí, así que yo tomo eso como que él se declaró.
Am I mistaken, Mr. Enriquez Perez, or do you want to go forward?
¿Estoy equivocado, señor Enríquez, o usted quiere continuar?
No, está bien, continuemos.
No, that's fine. Let's continue.
Okay. Ms. Nix,
Sorry, Judge.
may someone in my office sign the indictment for you?
Señora Nix, ¿alguna persona en mi oficina puede firmar en su nombre?
Yes, sir. I was just trying to make as clear a record as possible.
I appreciate that.
Sí, su señoría, solamente quería que el acta quedara lo más clara posible. Entiendo, lo aprecio.
Mr. Sperling, was there something you wanted to get on the record?
Very briefly, Judge, just for clarification so that I can talk to my client after the plea. Is the court accepting a nolo contendere plea or an offered plea?
Sí, señoría, sí, quiero a ver si podemos aclarar esto, así después le puedo aclarar a mi cliente. Su señoría, ¿usted va a aceptar una declaración de nolo o una declaración de alfor?
So I had explained both of those scenarios to my client.
Okay.
Porque yo ya le expliqué a mi cliente las dos posibilidades.
So as I said at the beginning, and as I said just a few minutes ago, and as I think I just confirmed with your client, I'm accepting this as a best interest plea. If you want to call that an offered plea, you can. But I am hearing Mr. Enriquez Perez say it is in his best interest to move forward with this plea so he can restart his life. And that's how I plan to accept it.
Bueno, yo ya lo dije al principio, ya lo aclaré hace un ratito y su cliente me parece que me entendió porque él dijo que él se quiere declarar porque es por su mejor interés. Usted lo puede llamar alfor si quiere, pero sí, el señor Enrique Pérez me ha dicho que él se quiere declarar para terminar con esto y poder reiniciar o continuar con su vida.
What it will likely show on the final disposition is offered. It doesn't have the term best interest. I typically explain it because many people offered, who is that? And it's not the who, it's the what.
And that's exactly what I was going to ask, Judge, if the sentencing sheet could reflect an offered plea.
It will show that.
Y para terminar de aclarar este tema, en el documento que usted se declara a cargos va a decir alfor. Pasa que yo siempre quiero aclarar lo que es, porque es por su mejor interés. Porque si yo digo, sí, usted se declara alfor, usted dice, ¿y quién es alfor? No es quién es alfor, ¿qué es alfor? Por eso siempre lo quiero explicar.
Mr. Enrique Perez, count one has been dismissed by the state.
Señor Enrique Pérez, entonces, como ya le dije, el cargo número 1 fue desechado por la Fiscalía.
Count 2, I will follow the negotiations and sentence you to a term of 10 years. You will serve 1 in custody. The balance will be on probation.
Entonces voy a aceptar la negociación hecha por los abogados, lo voy a sentenciar a 10 años con 1 año de cárcel, el resto va a ser libertad condicional.
You will receive credit for the time you've been in custody since April 25th of 2025.
Y usted va a recibir crédito por todos los días que ha estado preso a partir del 25 de abril del 2025.
That's not only what was negotiated, but what the law requires.
Eso no es solamente lo que los abogados negociaron, pero es lo que exige la ley.
Special condition of probation, if you are released. 1, no contact with Ms. McCutcheon.
Entonces, las condiciones especiales que usted va a tener que cumplir si está bajo libertad condicional, primero, que no puede tener contacto con la señora McCutcheon.
And number 2 is that you would register as a sex offender and comply with all the special conditions of probation for a sex offender.
Y la segunda es que va a estar registrado en el registro de delitos sexuales y va a tener que cumplir con ciertas condiciones que le van a explicar en libertad condicional.
However, it's my expectation that you will not be released, that you will be deported out of the United States.
Pero yo creo que usted no va a ser dejado en libertad y usted va a ser deportado de los Estados Unidos.
Do you, Mr. Enrique Perez, have any questions about anything anyone has said during our conversation?
Señor Enrique Pérez, ¿usted tiene alguna pregunta que quiera hacer acerca de algo que haya dicho cualquier persona durante este procedimiento?
No, señoría.
No, Your Honor.
Mr. Sperling, anything else on behalf of your client?
Señor Sperling, ¿algo más?
No, Your Honor.
Ms. Nix?
No, su señoría. Señor Nix.
No, sir.
Last thing, Mr. Enrique Perez, should you be released into Atlanta, Georgia, before you are deported, you must report to probation within 48 hours.
Una última cosa, señor Enrique Pérez. Si a usted lo dejan salir de la cárcel y usted queda en libertad aquí en Atlanta, Georgia, antes de ser deportado, tiene 48 horas para presentarse a libertad condicional.
Contact Mr. Sperling and he'll tell you how to do that.
Usted se pone en contacto con el abogado Sperling y él le va a explicar cómo lo hace.
I don't think that's going to happen, but stranger things have happened.
No creo que vaya a pasar, pero cosas raras suceden.
Entiendo.
Mr. Enriquez Perez, if you get released, you need to contact me. You have my cell phone. Send me a text immediately upon release. I don't expect that's going to happen, but that's what you need to do. Understood?
Señor Enrique Pérez, usted tiene mi información, tiene mi contacto. Si usted lo dejan salir, por favor me llama, me manda un mensaje de texto. No creo que vaya a pasar, pero si pasa, se comunica conmigo, ¿entiende?
Lo entiendo perfectamente.
I understand perfectly.
It's been a pleasure representing you, Mr. Perez. Best wishes.
Gracias, abogado. Gracias a todos.
Fue un placer representarlo, señor Pérez. Le deseo lo mejor. Thank you, everybody.
Thank you, Ms. Nix.
Gracias, señora Nix.
All right, and thank you to the Robert A. Dayton Detention Facility for patching us in. Appreciate it.
Gracias al centro de detención por ayudarnos con esta declaración.
That's it.
Judge, one very brief side note. I got to say, I understand Spanish perfectly. The interpreter here today is amazing. Just FYI.
Go Fulton.
Oh.
There you go.
Thank you.
Excuse me, can I have the interpreter's
Excuse me.
record, please?
You don't have nothing else to say?
Yeah, it's Ms. Fitzgerald.
Okay, thank you.
Sure. Just getting your name on the record.
Yes. Mr. Sperling likes to talk a lot.
Yeah.
We know way back. He's still here. I'm
You're
very
still here.
excited.
She was saying nice things about you. So, thank you everyone for your patience with that process. I want to do a couple things real quickly. Deputy Gordon, is there someone we need to deal with so we can get him on his way, or it's just going to be a happy camper? Okay, he's good. We still have Mr. Arnold on, and so next up is we can't keep DOC sitting around. what are we doing with, Mr. Arnold? Final plea hearing. Well, we'll knock that out and then we can go in whatever order you guys want to go. If there's some quick things we can knock out before lunch, then people can have a lunch break. And then we'll pick everything back up. So Mr. Arnold, appreciate your patience and thank you, Ware State. Let's get you right there. And Ms. Wood, if you don't mind coming up to the podium. All right, let's get on the record. It's 25 SC 007-022, State versus Reginald Arnold. Mr. Arnold is appearing from Ware State. Ms. Wood is here in court, his lawyer, and we have Ms. Boykin for the state. Ms. Wood, first with discovery. Do you feel like you, from your review of the record, have all the discovery?
Yes, I do need to get Mr. Arnold a copy. We've discussed everything, but he wants to see what I can send him, so I will get that to him later this week.
Okay. Mr. Arnold, you understand that Ms. Wood can send you all the paper discovery, but if there is digital, if there's body cam, digital files, she's not allowed to send to you, or at least you're not allowed to receive a DVD or a thumb drive. So she'll get you paper, but there may be some things that she's not able to get to you at Ware State.
Yes, sir.
Okay. Sounds like you understand. Ms. Boykin, what's the real quick thumbnail sketch? Is this about getting contraband into the jail?
Yes, yeah.
Got it. Okay. What is the state's offer to Mr. Arnold if he wanted to resolve the case today?
Was just served right concurrent with the sentence he currently has. I think it's for involuntary manslaughter.
Okay. Mr. Arnold, your current sentence is for how long?
15 years.
Okay. Do you have yet a parole eligibility date?
Mm-mm.
Is that a no?
No, sir.
Okay. All right. You understand that what the state is offering today, if you were interested in entering a plea, would be a term of 5 years, but those 5 years would run concurrently with, at the same time with, your much longer sentence for involuntary manslaughter. Do you understand that?
Yes, sir.
Okay. Is that a plea you are interested in pursuing at this time?
No, sir.
Okay. That's your right. The only thing that changes after today, well, two things may change. One, Ms. Boykin may not make that same offer going forward. That's her decision, whether she re-extends it. The other thing that changes is that after today, should you decide to enter a plea, you do not get to withdraw that plea if you're unhappy with whatever sentence I give you. So if we fast forward a month and you've looked at the discovery and you say, yeah, let's do this. And Ms. Boykin again, I'm not saying she would, but she again offers you 5 years and you take a plea to that, I might learn something and say, I think it should be 6 years. And you're stuck with whatever sentence I impose. You don't get to back out of it just because you don't like the sentence. That's the main thing that changes after your final plea date. Do you understand that?
Yeah.
Okay. Ms. Wood, do we need to bring Mr. Arnold here? He should be on the May 28th calendar.
Yes.
And so I guess we should line up a production order so he's brought back here.
And that way I can show him the digital discovery.
Okay. All right. So Mr. Arnold, I don't know how comfortable you've gotten at Ware State, but because your case is on an upcoming trial calendar, we're going to have to uproot you, bring you back to Rice Street, where you will be in the week leading up to, and then the time surrounding your trial calendar, which is about a month from now. Okay?
Yeah.
All right. Anything else, Ms. Wood, on behalf of Mr. Arnold?
No, Your Honor, thank you.
That's it. Well, thank you, folks at Ware State, and thank you, Mr. Arnold, for waiting for us to have this conversation. You're good to go. Okay. Are there any quick, we'll do that. Are there any quick announcements?
I think, well, what time are you getting off of the bench?
I think it's got to be kind of close to noon,
Right.
but then we're starting back up.
Is Batiste your only thing? Okay, so we have a misdemeanor plea on Mr. Batiste, who's on Zoom. I know Ms. Rios has people here though, so I know everyone's got stuff, so.
Everyone's got stuff,
Yes.
I know. What about, did Mr. Muhammad ever show up? I know you're not Ms. Didier, but, did she get an update on when he might be here?
She just stepped out for a minute, have discussion with one of the lawyers.
Okay.
She hadn't heard.
Got it. We'll wait to hear back. Ms. Sherry Lassiter, tell me what is, I'm trying to find. There it is. Mr. Harper, that's a plea? Okay. And then Ms. Boykin, your plea is. Right. Oh, with Ms. Cabrera. Okay. So we got two, lawyers, that we have queued up here. Well, we can do one of them. Do you guys want to arm wrestle? Do you want to do one or two? Ms. Cabrera, tell me your schedule for the rest of the day.
Honestly, it's my mother's birthday.
Oh my gosh.
So.
I'm sorry. Were you supposed to have lunch with her?
Yes.
Okay, so go have lunch with
I
her.
was told I hope that I'd be done around lunchtime.
Okay.
But she's out by herself. But yeah, that's the rest of my day. I asked somebody else to come with me for that.
Okay. And Ms. Sherry Lassiter, your situation.
Yeah. Just need to get back to work, that's all.
Okay. Why don't we do this? We'll do both. We'll be quick. For those of you whose names I didn't call, if you want to go to lunch, be back by 1:20-ish. There's lunch around here, but we'll pick back up. I really had not forecast that we'd have an hour-long multilingual plea, but that threw a spanner in things. So please be back 1:20-ish to pick back up, and let's get going with our first of the pleas. All right, we'll do Ms. Callaway. Ms. Callaway, come on up.
For part of this. Pleased to hear you.
You guys ready?
Yes, sir.
Great. All right. Can you slide that way a little bit? Excellent. So the court reporter can see and hear you. This is 25 SC 007022, State versus Wanita Callaway. Ms. Callaway is represented by Ms. Cabrera here in court, and Ms. Boykin represents the state. Ms. Boykin is about to put you under oath, Ms. Callaway. Once you're under oath, you'll need to answer all her questions truthfully and completely. Please let me or Ms. Cabrera know if at any point you've got a question. Will you do that?
Yes.
Okay, Ms. Boykin?
Ms. Callaway, please raise your right hand. Do you swear or affirm the testimony that you give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your correct and true and legal name.
Wanita Callaway.
Are you known by any other names?
No.
Are you under the influence of any alcohol, drugs, or medicine?
No.
I'm sorry?
No.
Okay. How old are you?
49.
And how far have you gone in school?
I got a certificate in practical nursing.
Yes. Are you able to read, write, and understand the English language?
Yes.
Do you understand that you're charged with 4 counts of conspiracy to commit a felony and 4 counts of possession or procurement of prohibited items, providing prohibitive items to an inmate?
Hold on one sec. Hey, Deputy Gordon, do you mind taking folks into the vestibule? We sit with very soft-spoken Ms. Callaway.
I'm just sick. I'm ready.
That's okay.
I'm sorry.
You happen to also be soft-spoken, right? It's not a critique. We need to be able to hear you.
Yeah. Yes.
Okay. And do you understand that you have the right to either plead guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Okay. And have you gone over this indictment and its charges with your attorney?
Yes.
Have you had time to speak with your lawyer, Ms. Cabrera, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Cabrera, do you waive formal reading of the indictment?
Away.
Do you waive any and all defects in the indictment, including with respect to your client's name?
Yes, I do.
Ms. Callaway, has your attorney advised you of the minimum and maximum sentence for each charge you're pleading to?
Yes.
Do you understand that neither the court nor the district attorney's office has anything to do with parole or Department of Corrections or Board of Pardons and Paroles, and no one can guarantee any type of parole or parole in this matter?
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and defense to the court will be a sentence of 1 year probation on conspiracy to commit a felony, count 1. Counts 2 through 8 will be non-prossed by the state as it relates to you. That the conditions of probation is that you get evaluated, seek mental health treatment, that you not work in a jail or correctional facility, and that you have no contact with co-defendants in this case.
Yes.
Do you understand that the court does not have to accept that recommendation? The court can sentence you to the maximum on each charge and can run those sentences consecutively, one after another.
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea, you have the right to withdraw your plea of guilty?
Yes.
Do you understand that by pleading guilty, you give up the following rights? The right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to the assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at the trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
and the right to appeal if convicted of these charges at trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Ms. Callaway, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, please.
Have you ever pleaded guilty or nolo contendere or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained to you the First Offender Act and conditional discharge statute to you?
Yes.
Do you understand that if you violate the terms of your first offender conditional discharge sentence or commit a new offense while on probation, your first offender conditional discharge status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in the indictment?
Yes.
And do you understand that if you successfully complete your probation under the First Offender Act and are discharged, you can honestly say that you have never been convicted of a felony?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of a guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, and transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, that you could be found guilty of a felony?
Yes.
With respect to, this indictment, how do you plead to one count of conspiracy to commit fraud? Commit a felony?
Oh, guilty.
Okay. And I apologize. I lost the last page of my plea colloquy, so I wanted to make sure I didn't
Uh-oh.
forget to go over something. Are you pleading guilty to this charge because you are in fact guilty?
Yes.
Do you understand that you have 4 years from today's date for a felony to challenge the voluntariness of this plea through a habeas petition?
Yes.
Okay, I think I went over everything. Your Honor, should this case go to trial, the factual basis for the state would be that on June 27th of 2024, Lieutenant Battle with the Fulton County Sheriff's Department initiated, as a part of the Jail Investigations Unit, started an investigation based on a seized cell phone from inmate Reginald Arnold. Throughout the course of their investigation, they learned that the defendant in this case, Wanita Callaway, who was also working as a nurse through NAFCare, which is the assigned provider within the jail, had begun a relationship with the defendant, Reginald Arnold, while he was an inmate at the Fulton County Jail. Throughout the course of the investigation by the Jail Investigations Unit, they were able to pull the phone calls between the defendant and Mr. Arnold, where it was clear during those calls that they had engaged in a relationship and talked multiple times. There were also text messages found on the phone seized from Mr. Arnold, where they discussed the bringing in of contraband, specifically a phone in the Fulton County Jail. Throughout those text messages, Ms. Callaway acknowledged that she had two phones brought in for the defendant. On the jail calls, which were recorded, you could hear them discussing the activation of the phone, her providing him with the password for, or the SIM code in order to activate the phone while he was still within the Fulton County Jail. Your Honor, obviously the defendant has been charged with a significant number of counts, and the state felt pretty confident that we could prove this case going to trial. But some of the things that factored into the decision to reduce and non-press some of the charges is that Ms. Callaway took responsibility fairly quickly when she was interviewed by the jail investigation staff. Also, Your Honor, we would note that she did spend almost a year incarcerated at Fulton County Jail prior to indictment.
Yeah, I have 428 days,
Over a
more
year.
than a year.
More than a year. There are also some additional extenuating circumstances that I'll allow her counsel to relay to the court.
Okay. Tell me Ms. Heath's alleged connection. I understand Mr. Arnold's connection now.
The detention officer at the jail and assisted, there's some text messages that implicate her in bringing the phone she had seen on some surveillance footage, carrying bags back and forth.
So she would know Ms. Callaway, or she was just a separate channel into Mr. Arnold?
We believe that there's a connection, but I think that it's also possible that they were not connected and they were working
Independently?
Independently.
Got it. Okay. And is Ms. Callaway, is any part of her resolution here an agreement to provide truthful testimony?
Not at this time, Your Honor. We
Okay.
don't think it's necessary.
Okay. Got it. Ms. Stallworth, do you have any criminal history information on Ms. Callaway?
There is no prior history, Your Honor.
Thank you. All right. Ms. Cabrera.
Yes, Your Honor. Ms. Callaway, she did accept responsibility almost immediately. She is eligible for first offender, so of course we're asking for first offender. She is licensed as a nurse, and throughout this process, obviously, she can't work as one. She can get through the interviews, but she can't get any further. Unfortunately, in January of this year, her daughter passed away, leaving behind what was then a 4-month-old. That child is now in DFAC's custody, and Ms. Callaway is the only one here in Georgia, but she cannot take the child because this case is pending, and so DFAC's will not give her the child. Family would otherwise be in Florida.
So one of the things is she's hoping that she can actually return to Florida at some point. There's concerns about some probation fees. She's working full-time right now. She's working for Publix, so she's working overnight. I spoke with the state about possible early termination of probation upon completion of any of the conditions that she has. And I would also be asking, Your Honor, if you would consider allowing this to be filed under seal, so that she can actually take up a job as a nurse without having this pop up on her.
Okay, got it. Ms.
Oh, I'm sorry, Your Honor. Just other small things. While she was in custody, it was like 14 months that she was in there. She was a chair for the New Beginnings program, so she was actively engaged in things that were positive while she was in custody. I guess making the best of that situation that she could. Hopefully, you believe that the resolution we reach is appropriate. But I'm glad.
Was the bond just too high? Why so long? It's just a bond you couldn't make?
Yeah.
Okay.
Yeah, I'm sorry. Yes.
And then did you eventually make it, or did the bond get lowered, or both,
The bond got lowered.
until you could make it?
Yes.
Okay, all right. And you have a granddaughter now who is in de facto custody,
Yes. In Cherokee County.
and you would like to get custody of her?
Try to, yes.
Try to, sure. And if you did, and you managed to wrap up probation, your goal is to go back to Florida?
That's where all my family is. So I was only here with my daughter, and my daughter did not want to go back to Florida.
Got it.
So that's where all my family is. That's where I would get the help.
It would be natural for you to go back to Florida.
Yes.
You'd have support as you tried to raise your granddaughter.
Yes, yes.
Okay, that all
But
makes
to be
sense.
fair too is my family in Florida is trying to get my granddaughter too. So
Okay, got it. All right. Do you have any questions about anything we've discussed?
no.
Anything you want to add?
I just want to say that although this was a very negative experience, for me it was positive too, because it kind of changed me to be a better person. So although it was a long time, it was the right amount of time for me to mold myself to be better.
Give me an example of a way in which you're a better person now.
I was a little impatient before.
Okay, you're more patient now?
Yes, I didn't really have humility, so.
Okay, 428 days in the county jail will do that to someone, make them patient
Yes.
and humble.
Yes.
Okay, well, I hope you maintain those attributes as you move forward. Ms. Callaway, I find there is a factual basis for your plea. It sounds like the state's case was particularly strong. I could see why you wouldn't want to go to trial. I don't know that that would have turned out real well for you, but that's not really what this case is about anyway. It's about you taking ownership and not repeating something like that again. And it sounds like you've learned some important lessons, and you have an important role to play going forward in your granddaughter's life. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter this plea, but you're doing so after consultation with your lawyer. Is that a fair statement?
Yes.
Ms. Cabrera, can someone in my office sign the indictment for you?
Yes.
Ms. Boykin?
Yes, Your Honor.
And Ms. Callaway, is it okay if we sign your name? And so we're clear that there are a bunch of counts in the indictment. You're pleading guilty to count 3. That's the first count that names you, but in the indictment, it's count 3. That's the conspiracy count. And then counts 4 through 10 are being null prossed. Those are the other counts that name you. Okay?
Yes.
Doesn't change anything we talked about, just the numbering. You're pleading guilty to count 3. All the other counts naming you will be dismissed. I'll sentence you as a first offender. I think you qualify for that. I think you understand the risk of it. It's a pretty limited risk because you're not going to be on probation for very long. And the only way it's a bad idea is if you get in trouble again. And I don't get the sense you're going to do that. No, she says. Okay.
No.
I'm going to sentence you a little bit differently because I want to reflect the time you served. To count 3, I am sentencing you to 2 years to serve 1 year with a balance on probation. You'll get credit for all the time you served. You're not going back into custody, but you will be on probation for a year. Special condition of probation number 1 is that you meet with a mental health provider to have an evaluation. And if that person recommends any treatment, that treatment is part of your probation. Number 2, while you are on probation, you will not work in any type of detention facility in any capacity, whether it's healthcare or otherwise. 3, no contact with either of your co-defendants. I will waive your probation supervision fees for the first 3 months as you continue to establish yourself doing what you're doing and not being in custody. And I'll be very open. It's only a year, but if probation comes to me early on saying, why are we supervising this woman? She's doing fine. If they advocate for an early termination or turning it into unsupervised probation early on, I'm fine with that. But like I said, it's a pretty small window of supervision. I'm very sorry for your loss of your daughter, and I hope that you are able to step forward and be there for your granddaughter, and if not you, then your family down in Florida. Ms. Cabrera, anything else on behalf of Ms. Callaway?
Nothing further.
Ms. Callaway, what county do you live in?
DeKalb, I live in Decatur.
Okay, I'm asking because Ms. Simpson's going to need to talk to you in a minute about reporting to probation, and it'll be in Conyers rather than here in Atlanta. Ms. Boykin, anything else on behalf of the state?
No.
Okay, thank you, everyone.
Thank you.
You don't speak.
Thank you. Thank you, Judge.
You're welcome. Happy birthday to your mom.
I know.
Where are you taking her?
So we're gonna go to Five Church in
Ooh,
Midtown.
yeah.
Yeah.
You gonna bring the leftovers back here?
You know, you guys might still be here.
Yeah. It's been that kind of day.
Yeah, you have to do things with my mother on her birthday. My sister said something about a concert or something. She's like, this weekend. I said, no. I said, it's the words with my mom. And so I didn't do anything on my birthday. Now, I didn't do anything for my birthday. So she'll tell you she didn't do anything on her birthday.
Got it.
So I was like, oh no, we're doing things today.
All right.
Thank you.
You bet. All right, let's knock out this other plea. Mr. Abadi, I'm sorry that I know you do some work here, but we're gonna pick back up at about 1:20. If you want to have someone stand in for he's not accepting. This is part 2 to the little guy case. Yeah.
I think that 120 on.
Okay, either way.
Can I ask you a question?
Yeah. July 1. Okay. All right. While you're getting set up, Ms. Smith, I'm gonna get us teed up. This will be our last thing before we break for lunch. This is 25 SC 007473, State versus Miles Harper. Mr. Harper, thank you for your patience this morning. He is represented by Ms. Sherry Lassiter, who is also here. Thank you for your patience. Ms. Smith is representing the state, and in a moment, when Ms. Smith is all fired up, she's going to swear you in, ask you some questions you've heard other people be asked today. I may have a few questions. I'll hear from your lawyer and from you, Mr. Harper. If there's anything you want to add, we'll get you sentenced and out the door. Okay?
Okay.
All right, Ms. Smith?
Yes, Your Honor, thank you. Mr. Harper, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Miles David Harper?
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you would normally take that you haven't been given today?
No.
Are you able to read, write, and understand the English language?
Yes.
How old are you and how far have you gone in school?
I am 33 and I have a bachelor's degree from Morehouse College in math.
In math, you said?
Yeah.
Ooh, all right. What do you do with that?
Data analytics and a manager of a data analytics team as well. So kind of do 2 jobs at once.
All right.
Ms. Smith, pull your microphone down, please. Thank you.
Sorry about that. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
So waive.
Mr. Harper, do you remember being arrested on these charges?
I do.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 6 years probation?
Mhm.
Yes.
You got to say yes or no.
Yes, sorry.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
It's my understanding that you want to take this plea under first offender. Is that correct?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes.
Do you understand that the federal government considers a first offender plea a conviction for purposes of deportation and can still affect your ability to remain,
Yes.
if that was an issue? Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Harper, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 25 SC 007473, how do you plead to count 1, criminal damage to property in the first degree, and count 2, criminal damage to property in the first degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea, but if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes.
Do you understand that that process must be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you, Mr. Harper. Your Honor, this case were to proceed to trial. The state would show that on September 7th, 2024, officers of the Atlanta Police Department responded to 390 17th Street, Northeast Atlanta, Georgia, also in Fulton County. They responded to a shots fired call. When they got to this location, it was an apartment complex, but they went to a parking garage in the Atlantic Station community, and the officers were told that there were just people on the parking deck that were shooting. When the officers investigated, they were able to see several shell casings by 2 of the cars that had been hit by bullets that had damage because of those bullets also. One of the officers with the Atlanta Police Department went to the leasing office a few days later and watched a video that depicted the defendant and another unnamed person shooting at a third person that was riding on a bike. Now, is the state's belief or version of events is that the defendant and his friend went to this apartment complex and they both ride motorcycles. They got off of those motorcycles and the defendant's friend or the person he came with, a third person came to steal his bike. So his bike was being stolen. As that person was driving away with the stolen bike, the defendant and a second unknown person started to shoot at the person who was stealing the bike. When they started to shoot at the person that was stealing the bike, 2 cars were hit in the midst of it. APD, through their investigation, were not able to identify who that person was that was shot at or potentially shot, hence why there's no charges for aggravated assault here. However, with the 2 charges we do have here, those are the facts. Those 2 cars were shot. And I was able to speak with the victims of both of the cars here, and they've sent me estimates and receipts of them getting their cars fixed. One car's windshield was broken. Another car had a shot going through their hood where their radiator was broken, so they had to get that completed. I've been able to get those documents. I'll share them with counsel, and we are asking for restitution in this case. But those are the facts of the case. Regarding the charges that we have before us, the negotiated plea is for count 1, sentencing to be 3 years probation, and then for count 2 to also be 3 years probation for those to run consecutive. Regarding the special conditions of probation, the state is recommending for the defendant to complete 50 hours of community service and anger management course, for him to stay away from the incident location, and for him to pay restitution to the victims in this case. Again, like I stated earlier, there was video footage of this. I've seen it. The defense counsel has watched it also. But because of that, this is the negotiated plea that we're presenting to the court. And that's all from the state, Your Honor.
So the cars were sort of innocent bystanders.
Yes.
Unfortunately, it was cars and not people. But Mr. Harper and someone else decided it was worth risking life, limb, et cetera, to shoot at someone who was stealing a motorcycle.
That's correct.
Okay. And we don't know if the guy on the motorcycle got hit. He didn't stop. He sped away on the motorcycle.
Well, he fell off.
Oh, he fell off.
He fell off the motorcycle and then ran away. I'm not sure if that person was shot or not.
Okay. Regardless, he left. He didn't stick around to say, wait, why are you shooting at me? Or I'm so sorry, or whatever.
That's
Okay. Interesting. Any reason why Mr. Harper is charged all by himself and not the other guy who was shooting?
Well, the police officers were able to identify Mr. Harper through his license plate that was on his bike.
Okay.
And he fit the description of the person in the video when they were able to identify him.
Got it.
I just think unfortunately the second person was not identified and we didn't have any information on him.
Okay. Got it. Ms. Stallworth, criminal history information on Mr. Harper.
There's no prior history.
You've been boring the last 2 of these. Okay, appreciate it. We will see you at 1:30, please.
Okay, see you then.
Thank you. Have a good lunch break. Ms. Sherry Lassiter.
Okay, yes, Your Honor. Before I get into explaining who my client is as a person, I want to speak on the facts just a little.
Sure.
The situation was, no good deed goes unpunished. He gets a phone call and said, hey, somebody's stealing my bike. I don't know what's going on. I need help. So he comes to the location, which is the parking garage. As he's walking up, he sees a person on the bike. He's walking up the ramp to the parking garage. He hears gunshots and sees gunfire. He doesn't know what's going on, so he ducks behind a vehicle. You can see him on the video, ducking behind another vehicle. He's shooting because he's thinking he's being shot at. So there's this other unidentified person coming from another direction shooting as well. I think we were still waiting on ballistics to find out exactly what shell casings and what gun it belonged to, but my client at this point is willing to take responsibility, not knowing if it was from the other person's gun or his weapon. And then the person, I believe, it seems like he dropped the bike and jumped off. It didn't seem like he was hit on the video. It seems like he just was like, oh, it's too much going on. I'm getting out of here.
Right, not worth
Forget
it.
this bike. Yeah, forget stealing this bike, stealing this motor vehicle. And he runs off. And my client Mr. Harper doesn't have any criminal history. He's 33 years old, a mathematics graduate of Morehouse College in 2015. This is not his life. And And I appreciate the state being willing to look at those factors as well. He is employed, he has 2 jobs, Comcast and a tech company called PDI, where he does data analytics. He's involved in his community. He helps the elderly in his neighborhood with, yard work or things like that that people need assistance with. And again, like I said, he has a bachelor's degree in mathematics. We do ask the court accept this plea under first offender. The restitution, I'm still kind of murky on, so I'm not sure the exact amount.
Well, the way we're going to handle that, just so there aren't any questions, the victims to the counts to which Mr. Harper is entering pleas are entitled to restitution if it can be proven up. And so Ms. Smith has previewed the fact that it looks like she's getting some paperwork. She obviously has to get that to you. If you can test it, we have a hearing, and if they prove it up, then those are the dollar amounts. It may be that you and Mr. Harper look at it and say, hey, how about, I'm making numbers up, how about we just agree $1,000 for this guy, $500 for that guy? There also needs to be evidence that they didn't get insurance coverage for it because they can't double recover.
Right.
And it may be they decided not to use their insurance because they didn't want to hurt their policy or who knows what. But those are all fair questions for you to ask of Ms. Smith as she gets you that info. If there's a meeting of the minds, then Ms. Smith will just send an email to Ms. Nelson, copying you, saying, could we please amend the final disposition to add X dollars of restitution for this guy and Y dollars for that guy? If there's not a meeting of the minds, then we have a hearing. It's a little evidentiary hearing that is either based on the documents, or it may be that the 2 gentlemen whose cars got shot up, that they come in and they say, here's, yep, I got it fixed. I didn't use insurance. And we can make a big mountain out of it. It can be a small mountain. It also depends on the dollar amount. If it's $100,000, I would expect a whole lot more pushback than, hey, you know what? It cost me $50 to replace the hubcap on the car. You know what? I'll give you $50. I want to move this behind me. So real reason, but you need to see the paperwork first. It's not simply that the state says, the victim says it was $400. Okay?
Okay, thank you.
You bet.
And then I believe we agreed to a behavior incentive date of 3 years.
I didn't hear that.
A part of the plea is if he was taking the plea under first offender, the state would ask for a 3-year bid date.
Okay.
It's entitled to.
And in addition to that, I'm just going to push it just a little bit more and see if we can have it based on his cooperation and having no further issues, if he can go to non-reporting after 1 year.
Okay, we'll see.
Okay. And to have this filed under seal.
All right. Anything else?
The community service that we talked about was 30 hours. I believe the state mentioned 50. I just want to make sure we're clear on the number of community service hours.
I have 50 on my paper, but let me go back to our conversation.
I have 30 in the email. I just want to double check.
I'm gonna go with 50, so.
Oh, you gonna go for,
Yeah.
okay. All right, Your Honor. Just had to put that out there. And that's all I have. We just ask that you accept this negotiated plea.
Okay. Mr. Harper, anything you want to add?
I've learned a lot from this. Learned I'm not built for jail. Sitting in the cell.
You were only there 3 days. That was 3 too many?
3 too many.
Okay,
So,
I hear you.
ever since then, been trying to stay on the straight and narrow.
Well, you were on the straight and narrow. I mean, to your client's point, it's not like, because I get cases where this is the 9th time someone has shot up a car. And like, this isn't just about, I'm trying to help a friend and there was a crime going on. Don't play Rambo cop anymore, though. If something's going on, say, hey, that's too bad, man. I hope you get your bike back. I'm staying in my apartment.
Yeah, the plan is, I've already gotten rid of my firearm, just sold it, got rid of it, didn't need it anymore.
Great.
Just want to avoid
Good.
anything.
You are moving in a great way. 2 jobs. You're in a management role already. You've got a great degree from a phenomenal institution. Keep going in that direction. If you want to do a family, all those things are great. And they only get held back when you're like, hey, I'm going to go help my friend, so I'll just put my piece here and we'll do this. And that can end so, and you're firing these rounds and there's a kid walking through the parking deck and you didn't know it and you didn't mean to hit him, but that death is on you. And we're not talking about probation or this or that. It would be, well, would that be voluntary manslaughter, murder, and that's never in your heart. That wasn't in your heart at all, but that's what can flow from something like that. But you learned it. I'm preaching to the choir here. Any other questions?
The only thing is I do planned on doing a little bit of traveling in the country, not out of the country, but I didn't know how that would impact that. I know the probation, you have to speak to the probation officer, but I wasn't sure if it was just no travel for X amount of time and then it ramps up or anything?
No, it's seek permission first.
Okay.
And so you probably wouldn't want to do it week one because they wouldn't have gotten a good read of you. You seem like you're going to be a very low maintenance supervisee, but there's no guarantee. And so you would want to have a few months of good rapport with your officer under your belt before you say, hey, I'm going to Colorado with some friends. Show me the itinerary. Great. When are you going to be back? And they either get permission from me or they may be authorized to give you that permission for leisure travel. Where it's a problem is if you say, oh, my new job and I got to be in Chicago all the time. They can't supervise you if you're in Chicago all the time. But a one-off trip here and a one-off trip there generally is not an issue. Just the key thing to remember is you get approval before you go.
Understand.
And if you're not getting approval, you let Ms. Sherry Lassiter know. She reaches out to me and I can engage with probation saying, tell me the concern. And then I can let you know, hey, that's a valid concern. You keep testing positive for this when you take it. I'm making it up, but whatever the deal is. And if it doesn't seem reasonable to me, I'll say, fine, I'll authorize it. Let the guy go to Chicago. He wants to see a Cubs game or whatever it is you travel for, a math conference. So anything else?
No.
Okay. Well, Mr. Harper, I find there's a factual basis for your plea. It sounds like you've processed this, and I appreciate it was a long time ago. You've had a while to process it. I'm glad no one got hurt. At least we don't think the guy on the bike got hurt, but that was on him. I also find that your plea is knowing and voluntary, meaning you've understood what we've talked about. No one's forcing you to enter this plea. You agree with that?
I agree.
All right. Ms. Sherry Lassiter, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Smith?
Yes, Judge.
And Mr. Harper, can we electronically sign your name to the indictment indicating your first offender plea to both counts?
Yes, Your Honor.
We'll do that. I will sentence you as a first offender. I think you understand. I know you appreciate the benefits. It's not a conviction. When you leave here today, you're not a convicted felon. As long as you finish out probation with no major hiccups, you remain not a felon. I'm happy to seal things. You should submit a proposed order, copy Ms. Smith on the email that you send to Ms. Nelson, and that proposed order should be in Word format. The downside to first offender, I need to say it on the record, just so you know, but I know your lawyers told you, is that you're on probation for a while, and even if I give you the behavioral incentive date, it's a few years. If you have a hiccup in a big way and you get arrested 6 months from now because you fired your gun in a way you shouldn't, it's all going to come tumbling down. I can take away your first offender status and resentence you up to the maximum on both counts. I don't see that happening, but I need to make sure you understand that that's a possible consequence if you have trouble staying in the right lane while you're on probation.
I understand.
Okay. Do you want to be sentenced as a first offender?
Yes, please.
I will do that. I will follow the negotiated resolution to this extent. 3 years probation on count 1, 3 years probation on count 2. I'll stack them, meaning a total of 6 years probation. That's a little longer sentence than we normally see for someone with no history, but it fits the, I shot my gun, and did they kick you out of the jury room?
Yes.
I tried to see if we could move, we have a meeting.
Yeah, no, it's fine.
I'm sorry, you can be in here. I tried to get it moved to a different jury room, but I had to do that. Anyway, because of the nature of what was involved, and it could have been so much worse, I think 6 is a reasonable window, but I will set a behavioral incentive date of April 22 of 2029. That's 3 years from today. If you have done everything you needed to do, and there are actually not many steps you have to take, then probation can, that's actually closing the case out. Well before then, I suspect you will be unsupervised. I don't need to recommend that. You earn it by being low maintenance. And because it's a property crime rather than you stab someone, the probation is likely to turn it into unsupervised pretty early on, provided you're doing all the things you need to. Special condition of probation number 1. So there was a request for a stay away, but I couldn't tell if you lived there. I'm not going to make you stay away from your own parking deck.
No, I wouldn't have any reason to go over there.
Great, then don't.
That's easy.
Stay away from that parking deck. And you'll need to complete 50 hours of community service. You'll need to knock that out in the first 6 months of probation. So you just be done with it. Take care of that. Obviously no firearms while you're on probation.
Understand.
You're not a convicted felon, but first offender probationers, that's what you are, may not have firearms. It's actually a felony offense to have a firearm as a first offender probationer. You told me you already got rid of it, you sold it. Once you're done with your sentence, you're not under that sentence anymore, should you choose to. It is legal, it is allowable for you to get back into the I own a firearm business, if that's what you want to do. No restitution at this point, but just you're on notice. We may come back and have a conversation about restitution. The state's gathering that paperwork. It may be that we don't have to have the conversation because your lawyer looks at the paperwork and says, Mr. Harper, this is all legit. It's a windshield, it's a radiator, and these don't look like crazy prices. And then you'll agree, that's my restitution. But you don't have to agree to it. The state has to prove it up. And so if we need to have a hearing, I'll happily do that.
Understood.
What county do you live in?
Cobb County.
Cobb County. All right, when we're done with this conversation, Ms. Simpson, who is with felony probation, is going to give you reporting instructions. Where is it in Cobb? What city?
It's in Marietta.
Marietta. So the Department of Community Supervision's office is in Marietta. You'll need to report there. Ms. Simpson's going to let you know where that is and when you need to be there. But that's a hot date. It's not a, hey, it'd be good if you showed up around that time. If you don't make it, they try a couple times to track you down, and if that doesn't work, they send me a warrant. That is a really bad start to first offender.
Yeah.
So don't miss your hot date, okay?
I won't.
Good. Ms. Sherry Lassiter, anything else on behalf of Mr. Harper?
That covers it. Thank you for your attention to this matter. I appreciate you hearing us out.
No problem. Ms. Smith, anything else on behalf of the state? All right, Mr. Harper, good luck with everything. Please meet with Ms. Simpson before you go, and then you are all done.
Thank you.
Okay, all right. We'll go off the record. Ms. Rivers, we'll see you at or we'll have you back at 1:30, please.
Hey, have a good lunch.
May I be excused?
Yes, ma'am. Ms. Didier, I heard that you've learned that Mr. Muhammad is in Floyd County. So I wish he had told you that at 9. But what I'm going to do is move your case to the trial calendar. I'm going to preserve your final plea rights. So the rights you had today to, if you were going to enter a plea, withdraw it if you didn't like your plea, you'll still have that. Your case is on our May 28th trial calendar. You got a notice to be here today? Good, you're going to get another one that says be here on May 28th. Great, there's a form here. Deputy Gordon's going to give it to you. You should fill that out with your new address. Mr. Muhammad will also get notice, and so in theory, he should be reaching out to you. But it's important that the notice make it to your mailing address as well. So fill out the form and get it back to Deputy Gordon, and we'll get it into the system. Anything else? I appreciate you sitting here all morning. All right. Hey.
Hi, I guess I'll arrived.
Wait, we just wrapped up? That's okay, it's all good. Ms. Rios rolled with it.
I do have a quick visitor in chambers.
All right,
All right.
I'll be there in a sec.
Okay.
I'll mute this.
Do we leave or do we stay?
Huh? You gonna sit with Connor or you gonna come in? Man. We got quarters back, Connor. You ain't shit, boy. I got change in my purse and this quarters right here. Under her car seat. Did you ever got that blood from under the seat? That Kodak don't have or that shit right there in front of you, that white one. So I can hit them motherfucker. I don't want it if it's not Kodak. I mean, yeah, shit. Keep them out so that's nothing. If you ain't grab it, then it's on the bill. Yeah, okay. It's under your seat. Come on.
I'm on the goddamn court thing.
Just get in the car. I don't know how to act.
Explain to you why I picked the switch that I picked, because it was this one or the next one at the end of the year. And And so then people were very grateful that the transition they were getting was down the hall as opposed to another floor. So I took the hit for you guys and my staff. So, all right. Ms. Rivers, can you hear us?
Yes, I can. I'm sorry, I had you on mute.
That's okay. We're back on. I just unmuted the podium. And we are picking up from where we were this morning. We also have a real short calendar this afternoon that I think is just Mr. Muse that I need to find. Is one of our trusty public defenders handling Mr. Muse?
Yes, and that's going to be reset. I already popped in. He still wants to see you. So
Good.
I thought it was.
And I want to see him.
I thought it was going to be Mr. Richardson, but he was not paid.
Max Richardson or Ricky Richardson was going to represent Mr. Muse?
Yeah, he's on his unindicted case, and so the family thought he was going to be seeking the probation revocation also. When I reached out to Mr. Richardson, he said that is not true, so.
I thought maybe Mr. McClendon, he was retained for both of the original cases. I guess not.
Yeah.
Okay.
So, but we're gonna ask for a hearing.
He probably should have a hearing. But let's figure out, we have some super patient people from this morning that we should take care of. Remind me, Ms. Wood, what we're doing with Mr. Compton. Oh, Mr. Compton will bring out for the final plea. Right, I didn't notice the charges. And did we get halfway through the trial of his co-defendant, or it was never a trial? I know he ultimately pled, Mr. Partridge pled him.
But on the day that it's supposed to go to trial.
Okay, it was jury selection day. Okay, got it. Mr. Batiste, I see is back on. He said very plaintively after you had left and I had shut the microphone down. It's like, hello? Like, oh, don't disappear. That's a plea.
Yes.
All right, we will likely do that next. Mr. Bolton is back. What happened to your jacket? Okay, phew. Is that also a plea?
Please, ready to go.
Okay. Then we took care of, Ms. Dedier, Ms. Smith. I excused Ms. Dedier. Were you here for that?
Yes.
You were here for that. Okay, boy, you stuck around. So further notice to trial, final plea preserved. What about Ms. Ballard? Did we not end up doing the final plea? Is she still here?
You on the stand.
Okay.
I've communicated her. We held off because I needed to just tell her what the new offer was.
Got it.
Did she follow up at the Zoom?
I don't see her there. There's an Andrew Spires, probably not the same person.
I'll email her for Kamara and Mosley.
Okay.
They're here and they're on Zoom now.
Got it. Fair enough. So we just need to track Ms. Ballard down and we'll do that. And then from the inquiry calendar, Derek Harrison, still maybe a plea?
It is a plea.
Great. Jaden Ashley met his lawyer and she did the waiver. So that's waive and schedule. And then Kamari Mosley is here for the revocation. He's got some people online. So with that said, maybe we do Mr. Compton's, no, what would you like to do?
So Judge, I apologize.
Oh, Mr. Batiste.
Donovan Phillips, stand up. He's not a gallery.
He is or is not?
Not.
Not, okay.
So I'll give you these are, it's 26 SC 000541. He missed court on April the 9th. It was just an arraignment calendar.
Okay, and he's coming in now?
Yes, he contacted the pre-indictment attorney from our office and let them know that he had missed court.
How did he know he missed court?
They gave me a text message saying that I missed it.
Who sent you a text message?
The bonding company.
Oh, the bonding company did, okay.
But they didn't let me know I had a court date. They just told me I had missed it.
It's a little late. This all happened pretty quickly though. It looks like you got your bond and then there was, okay, got it. So you were supposed to be here in court on April 9th? So it's not all that long ago. All right, do we have a good address for Mr. Phillips? I've got you living at 901 Bolton Road. Not good? Okay, so you're gonna need to fill out a change of address form that Deputy Gordon's gonna bring to you. Do you have good handwriting? Okay, good, because we need to be able to read it to put it in the system.
Just filed a waiver.
You did, thank you. This is an interesting set of charges. Who is Jewel Thompson to you? Okay. What's at 150 Woodland Hills Drive in Fairburn? All right, you're staying away from there? Okay. Do you and Ms. Thompson have any kids together or any reason that you would need to be interacting with her in any way? No, sir. Good, don't. Because that's what your bond says. All right. If you fill out that address form, you've done the waiver, Ms. Wood, that'll get a scheduling order out and I'll move the case along. If you'll just remind Ms. Nelson to do a bench warrant set aside.
Thank you.
We'll take care of that. Do you have any other walk-ins?
I do not.
Okay. What do you want to do first?
Well, only because I think Mr. Mosley would be quick, if we could just put this is now a plea, and it should take like 5 minutes.
Okay, but well, it's gonna take longer if you keep justifying it. Let's just do it. All right. Can we do Mr. Batiste after that?
Yeah.
Okay. Oh, I recognize Mr. Spires. Yeah, he was in court earlier today. All right. Good afternoon, Mr. Mosley.
Good afternoon.
We're going to get on the record in your case, which is 24 SC 000708. You are on probation in that case. You've got 2 years and almost 10 months of probation remaining. And in October of last year, I signed a probation warrant in your case that alleges that in early October, you were arrested by the Atlanta Police Department for aggravated assault. And then a couple months earlier, in August, you were arrested in Clayton County for driving with a suspended license. And then you hadn't done community service, your anger management, kind of messed up on probation in a lot of ways, are the allegations. I think your Clayton charges are still pending, as in nothing's really happened with them. Your aggravated assault got reduced to simple assault. I think you've already pled guilty to that, but Ms. Rios will clear all this up. And we need to figure out, what do we do for someone who was on probation and was supposed to do a bunch of things and didn't do them, wasn't supposed to do some things, but did those. Ms. Rios is here on your behalf, and we have Ms. Smith for the state. Ms. Rios, is Mr. Mosley admitting to the arrests and the technical violations?
Yes, Your Honor.
Okay. Tell me about those and what you think I ought to do.
Yes, Your Honor. Mr. Mosley, our understanding is that other case was reduced. When I initially.
Other case meaning the other Fulton case?
The other Fulton case,
Mhm.
Your Honor. When I talked to him when he first got arrested, he explained that it didn't happen as they alleged to happen. They're trying to attack the mother of his child, and it was like some altercation. And I think that is why it was reduced. I spoke with his attorney who represented him on that case, Ms. Salisbury, and she told me a while ago that it was reduced. We were just trying to figure out who then now handled his probation revocation. He was supposed to be going to Atlanta Tech before he got arrested. That's what his coach, who's still in his life, Mr. Spears, told me. His mom was also here, Miss Jenkins. He's supporting trying to support his 11-month-old child. At this point, he's been in for 6 months. And I do understand that he needs to get those things that he was supposed to complete done as soon as he gets out. I believe the 6 months, him being in, is appropriate to revoke those 6 months and give him credit for the time he served. I spoke to Ms. Simpson, and that was her recommendation. And I just ask that you go along with that recommendation, with, of course, reiterating that he needs to get that anger management and community service done as soon as possible.
So Mr. Mosley was on first offender probation. His plea back in April so it was a year ago, that you helped him with. You managed to get him first offender, and it sounds like you've not done any community service. Is that right?
I did a little, I just didn't finish.
Okay, you did some, but not all.
Did some, not all.
Got it. Had you taken the anger management course?
She took my PO, she told me she was gonna send me the class to start instead of me going to find my own, but she never sent it to me, and I ended up getting arrested.
Before you could take
Before I could start, because she told me she was gonna send it to me in September, by September 28th, but I ended up getting locked up in October, so I didn't have time to actually join the class.
Got it. Okay. And Ms. Destiny Dowell, remember that name?
Yeah.
You stayed away from her?
Yes, sir.
Okay. All right. And who was that a former girlfriend?
Was.
Yeah. Okay. All right. That's not the mother of your 11-month-old?
No.
Okay. All right. So your recommendation is revoke 6 months, but credit for time served. And then reinstate the balance and
Yes, reinstate the balance.
just get serious about probation?
I wouldn't want to say that he wasn't taking it seriously necessarily. I think, like he said, he was trying to do that. As far as the altercation goes, they pled it down because they were trying to attack him, his child, I believe, was also in the car. And so, but he wasn't, the reason why he put it down is because he didn't put any gun at anybody. He didn't commit aggravated assault, which is why it was reduced. Him being out more, maybe we can do within 2 months or so that he get those things finished. And Mr. Spears is on the call, and he's been really good at staying on him. So I'm going to ask for his help to make sure he gets this done.
Okay. Hey, Mr. Spears, I appreciate your patience this morning being here. We weren't able to get to Mr. Mosley. I think you sat through the Spanish language plea we had. Is there anything you want to add on behalf of Mr. Mosley?
Yes, sir. Most definitely. Of course, as Mr. Rios stated, I am still involved with Mario. So I am always here to help him get through whatever it is he's getting through. And in the time that he had these incidents going on, I can say he was trying very hard to kind of balance everything that was on his plate. It was kind of new territory for him. I was trying to help navigate through it. He had some outside individuals that wasn't agreeing with, his new way of life. and the track that he was on, and he had a lot that was coming at him to derail him from the path that he had chosen to take. And he was actually headed down the right direction, and he still is. He's just waiting to get this behind him, so that he can get on that path. And in order to help Mario and actually myself actually purchase a larger place, a larger home, so that I do got room for him to get away from anything that may cause any distractions from him continuing down the path that he was on before these incidents happened. And I will continue to be in his life as a guide, mentor, and help him through these things. I would ask if you would be gracious enough to consider what Mr. Reeves is presenting for you. I'm sure he'll continue down the correct path. I know that this was a big wake up call for him. I've been speaking with him throughout the duration during his time in incarceration. So he's got a lot better understanding of things, and I think we've got a lot better grip on it now. And I ask if you would please be gracious enough to actually hear to what Mr. Rios is presenting. And I appreciate you because you have been lenient towards him and everything, and have been very understanding. And I appreciate you for that and acknowledging, those things. But yes, sir, I'm always here, and I will always be here to assist him and his family, however possible, to make sure that he stays where he needs to be.
All right. Well, thank you for being that resource for Mr. Mosley. I hope he uses it wisely. Ms. Simpson, had there been any other issues? I say any other, there are plenty here, but does the warrant, sometimes the petition has added because there's been an additional thing.
No, Judge, Mr. Mosley does have a new case, but it's not the basis for it because it took place before he pled on this first probation.
Pending in Fulton?
Yes.
Okay.
It's now currently with, not.
Okay. All right. Revoking 6 months, does that trigger you can't get credit for time served, or it's revoking a year? Over 6 months. 6 months is that magic line. 6 months and a day, he wouldn't get credit for time served. Whew, just made it. Okay. All right. Ms. Smith, what are your thoughts about Mr. Mosley's situation?
Yes, Judge, the state is in agreement with the defense and prosecution when it comes to this case on revoking 6 months. It is a bit of a concern that the new offenses happened just months after he took this plea. With the new charges and the fact that it was reduced to a misdemeanor and the facts and circumstances of this new violation, the state is okay with the 6 months to revoke. I do understand that the defendant is under first offender probation. At this moment, we're not asking for it to be revoked. However, if the defendant comes back before the court with anything else, just to put on the record that the state will be asking for his first offender status to be revoked.
Okay, I think I will be too. Yeah, so that'd be 3-1. So that might be the winning vote. Plus, the non-complex case may make it all moot. If that's not something that goes away or is reduced to a misdemeanor, I guess technically it could be at 16, 13, whatever we call that type of disposition. But that's not in front of us right now. Mr. Mosley, your young child stays with whom?
Right now, she resides with her mother.
Okay. Is that in the Atlanta area?
Yes.
Okay. I mean, it's local. It's not in Texas or.
Yes, it's in the Atlanta area.
Is this a family member of yours right here?
My mother.
Your mom is here. How do you feel how should your mom be feeling right now that you got first offender and then you messed up and you've been sitting in jail for 6 months?
Personally, I wouldn't know how to feel for nobody else. I can only tell you how I feel.
How do you feel for your mom that you've been stuck in jail for 6 months?
I disappointed my mother because I just literally took my first offenders and I turned around not no more than 3 months to get arrested. And
yeah,
I've been gone from my family. I ain't been able to see my child, not been there for my mother. Ain't no telling what she been going through while I've been in here. Ain't no telling what I've been going through through her head.
Right.
So
well, very well spoken. You need to act on those words. I agree with you. I think that was that shows sensitivity to what your mom maybe have feeling, going through, et cetera. When you get out, I wasn't quite clear from what Mr. Spears was saying. Where will you stay?
I reside with my mother.
Okay, she just raised her hand. Sounds like that's where you can be. Is that a safe place for you? And by that, I don't mean your mom is dangerous, but I mean, is it in a neighborhood where it's going to be practical to think that you're going to stay out of trouble?
Yeah, it's a safe place for me.
Okay. One of the things you did while on probation was to get pulled over for having a suspended license. What's the status of your license right now?
They're suspended. I have to get it reinstated.
Yeah, so don't drive until you get it reinstated. It's just not worth it, because if you get, you've heard what everyone in here says. If you're arrested again and we're getting back together, there goes the first offender. So Uber it, Lyft it, get someone to drive you until you can get that license back. Okay?
Yes, sir.
I know that's like, come on, man, just let me drive to work or something like that. But it's just not worth taking that risk for your kid, for your mom, for you. You're the one who has to sit in jail. They don't have to. They just miss you. Anything you want to add?
No, sir.
Were you by any chance working at all during this time before you got locked up?
I was going to orientation, but I got locked up the day before orientation.
What orientation?
I had orientation at FedEx and I had orientation at UPS.
Okay. Well, hopefully you can line something like that up again. All right. Well, Mr. Mosley, I find that you did violate your probation in a variety of ways. I will revoke 6 months of your probation and reinstate the balance. I'm going to modify your probation so that you now have, it's 60, not 40. You're going to have 60 hours of community service, and you have to complete those within the next 6 months. So you don't have to complete them tomorrow or next week, but you got to knock them out within those 6 months. You also have to complete your anger management course within the next 2 months. So those are now probation deadlines. I made a mistake in sentencing you and just said, hey, while you're on probation, take care of this. But it's upfront that you need to do it. So you've got 2 months to take care of the anger management course and 6 months to take care of the 60 hours of community service. Obviously, you got to get that driver's license. One thing he didn't do was call the CRU. What does that mean?
For our contact, our supervisors who report only by contact.
Got it. So he wasn't staying in touch. All right, stay in touch.
Yes, sir.
Okay. They don't make it difficult for you to do that. There's a phone number or this or that. Just don't be hard to find, be easy to find. If your probation officer is happy with how you're doing, she will stay out of your way and you'll be able to go about your business. If your probation officer is not happy with how you're doing, then stuff's going to get complicated. Okay? Any questions about any of this?
No.
Is it a daughter or a son?
A daughter.
What's her name?
Culture.
Culture. When did you last see Culture? I guess 6 months ago. More than that? You've been locked up for 6 months.
I seen her like 7 months ago.
Okay, so Culture used to be this big. Culture's going to be this big now. Mom says this big. You got to go be in Culture's life, but you got to do it in a productive way. All right, Mr. Mosley, I hope this works for you. We will see. Reminder that you do have an open case in non-complex. Do we have a case number?
It's 26 SV 000-873.
So you have who's Cameron Mosley?
My older brother.
Your co-defendants, you and, does he live at home with your mom too? No. How much older?
He's 2 years.
Okay. Well, you and your brother are indicted or accused for, here it comes, sale of marijuana and having a firearm doing that. It dates back to something that happened in January of 25. So it's old conduct that was very recently indicted. And you have a court date in 9 days, April 30th. So let's write that down if you don't mind, Ms. Rios, for Mr. Mosley. You don't want to miss court. I think Cazzoli is your colleague.
Yes.
Yeah, that's who is Mr. Mosley's lawyer. And you've got court on the 30th. You want to not miss that.
9 a.m.?
1 p.m. Although it says jail courtroom, they think he's still in custody. So it's that jail calendar. So you don't have court that day. You can't make that date because you're not going to be in jail on that date. That was just a way to move your case forward while you were in custody.
Your court date just called me to see when it's been updated to. Actually, I say tell me in about
You did.
weeks.
Great. Is it still Officer Evans? All right. So what should he call Officer Evans? All right. When you get out, call Officer Evans.
Yes, sir.
Okay? All right, Mom, anything else you need us to tell Kamarian? This is your chance. Anything else you need me to tell him?
No.
No? You'll take it from here?
Yeah.
All right. Good luck, Mr. Mosley.
Thank you, Judge.
I'm gonna get on Zoom. You need me for news to understand here.
Mr. Spears, you're good to go.
Thank you, Judge.
Oh, so I think his brother was on the call. Interesting. All right, Mr. Batiste.
I'll be complete for that. Okay, sure.
Pardon me?
I'll be complete for this case for AD.
Oh, she couldn't make it back.
Oh, they got you, so.
Hey, Mr. Batiste, can you hear us?
Yes, sir. Can you hear me?
I sure can. I appreciate your patience. I know you were on all morning.
I'm trying to make the phone.
Let me know when you're ready.
Ready.
Okay. Well, we're going to go on the record, Mr. Batiste, with your case. It's 25 SC 003092. You are represented by Ms. Wood, who is right there. And Ms. Smith is handling things for the state. She's subbing for Ms. Willingham. Mr. Batiste, you are charged with theft by taking and simple assault, family violence. Ms. Wood tells me you're ready to go forward with a plea. Is that correct?
Yes, sir.
Okay. You are not in court, which is okay, as long as you are willing to waive your right to be here in open court. Are you willing to waive that right?
Yes, sir.
You also are waiving the right to have Ms. Wood be right at your side. If you and she need to have a private conversation, I can arrange that. But for now, she's going to be here in court and you're going to be wherever you are. You all right with that?
Yes, sir.
Okay. Ms. Smith will put you under oath in just a moment and ask you a collection of questions about your rights and about your case. Please answer those truthfully and completely. And also let us know if you've got questions or if for some reason the signal gets bad and you cannot hear us. All right?
Yes, sir.
Great. Ms. Smith?
Yes, Judge, before starting, would you like to know about the changes to the charges? in the case?
Always.
For count one, that'll be no cross. So this would be a misdemeanor plea and
Mhm.
keeping count two.
All right. So Mr. Batiste, the state's dismissing count one and you are pleading only to misdemeanor, family violence, simple assault.
Okay.
Mr. Baptiste, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Javon Baptiste.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone to school?
I'm 22 and I have my high school diploma.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
We do.
Mr. Baptiste, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 12 months probation?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Baptiste, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 003092, how do you plead to count 2, simple assault, family violence?
No, you asking me. I'm sorry.
I can repeat it. As to indictment number 25 SC 003092, how do you plead guilty or not guilty to count 2, simple assault, family violence?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you also understand that process must be completed within 30 days from today?
Yes.
Do you also understand that you have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Okay. Thank you, Mr. Baptiste. Your Honor, if this case were to proceed to trial, the state would show that on October 11th, 2024, Officer Jean Pierre of the Atlanta Police Department responded to a disputed call at 2167 Bolton Drive, Northwest Atlanta, Georgia, that's also in Fulton County. When the officer got there, they made contact with the victim in this case, Ernest Cunningham, who advised the officer that he had been physically assaulted by his boyfriend, the defendant in this case, Mr. Baptiste, at the location of 3380 Peach Street Road, Northeast. Mr. Cunningham, the victim in this case, advised that his boyfriend had been living inside of his apartment with him for past several weeks. And on this day, around 10:30 p.m., a physical altercation took place due to a misunderstanding about their relationship. Mr. Cunningham advised the officers in this case that Mr. Baptiste punched him in the back of the head and in his back about 7 times with a closed fist when he confronted him about the infidelity in their relationship. And those are the facts of the case. Based on these facts, the defendant was arrested for the charges we have before us. Those are the facts of the case. Regarding the negotiated plea between the state and the defense, as stated, count 1 be null pros and count 2, we're recommending 12 months probation
And as far as special conditions of probation, the state is recommending that the defendant have no contact with the victim, complete a family violence intervention program, and also complete 30 hours of community service. And that's all from the state.
Has your office, Ms. Smith, been in touch with Mr. Cunningham to determine if it's no contact versus no violent contact?
Yes, give me 1 second. I'm going to pull up that victim note. All right, it's not working, of course. 1 second, Judge.
While Ms. Smith is looking, Ms. Wood, do you have a sense as to whether Mr. Batiste and Mr. Cunningham still have contact, or if that is something that makes sense, or it's better to keep them apart?
I don't think that they have, I think they're both fine. We talked to Ernest Cunningham way back when I first got this case, and our sense was that he was just ready to move forward. We can definitely confirm with Mr. Batiste, but I don't think they're still together or anything like that.
Okay. Mr. Batiste, we're not talking past you. There'll be a time when you're going to answer some of my questions and then add anything you want. I was just checking. Ms. Smith is filling in for her colleague, so I appreciate her poking around for this. My guess is Ms. Willingham thought through this a little bit, but just didn't pass on the information.
Got you.
I've heard from ADA Willingham that the victim does not want any contact.
Okay, no contact it is. So no contact, family violence intervention program, 30 hours community service.
Yes.
Got it. Okay. Ms. Stallworth, criminal history information, if any, on Mr. Batiste.
Yes, Your Honor. He has one prior arrest. There are no convictions listed. There appears to be an active warrant on his GCIC out of the city of Atlanta for damage to property. The date of that warrant was February the 24th of 2025. And for the last date of arrest, it was February the 24th of 2025. I'm sorry, February 26th of 2025, which was a theft of shoplifting from East Point that was dismissed.
Huh. Okay. Thank you.
Wait. Can she repeat
Did you say there's a warrant for me?
Yeah, can she repeat that?
Well, she doesn't need to repeat it, but we'll talk about it a little bit because interestingly, there is a warrant showing up in the system here too. I'm trying to find it. Yeah, I show a warrant that this would be exactly what Ms. Stallworth was talking about. Judge Wolf, then magistrate, signed a warrant in February of last year for criminal trespass and damage to property. And it shows as still an active warrant. Annoyingly, I don't have access rights to actually see what the warrant says. But more importantly, it says active. And so you're going to want to get with Ms. Wood. She can give you some thoughts about how you can clear that up.
Yeah, because I just came to court for this same case that's been going on since 2024, and y'all, it wasn't a warrant. I sat in front of you, and it wasn't a warrant.
I hear you, but it is showing up. So I don't know. Well, it's not like we're going to take you into custody now. You're not here in court, but it's listed in here, and you need to work with Ms. You ought to work with Ms. Wood to see if there's a way to have it show as inactive.
We'll talk after today, Mr. Batiste.
Yeah.
Okay.
I mean, don't panic. This isn't the kind of thing where they're going to come knock your door down tonight. But if you happen to run a stop sign, I'm not saying an officer wouldn't say, I'm sorry, I can't just give you a ticket. I got to take you into custody because there are these warrants for something that supposedly happened in January of 25, and the warrants were issued in February of 25. But I don't have access rights to warrants, so I can't read them.
Okay.
Okay? Any chance that involves Mr. Cunningham?
We've been separated for a little over more than a year, so this couldn't have been involved with him. And last year, around this time, I don't even think I was here. For January was like the new year. I was in Louisiana.
Okay, well, you don't need to defend yourself. I'm just saying there's a warrant, and so Ms. Wood is going to help you figure out what does that warrant say, and is there a way to deal with it, okay?
Okay.
We're going to focus on this case. Ms. Wood.
Thank you, Judge. So, as you heard, he doesn't have a history. I was always wondering why this was sent to us from non-complex.
Did you read it? I just read it for the first time. Highly complex case that will be re-indicted and should be specially handled by the domestic violence unit.
Anyway.
And it's reduced to a misdemeanor.
He's 22 years old, Judge. He's a high school graduate. He has worked in the service industry.
What does that mean?
I have that he worked at Hop Mountain Tavern, but I think that's a little bit outdated, so I'm not sure what he's doing currently.
Okay.
But we appreciate the state's offer in this case, and we ask you to accept the state's, the negotiation.
Okay. Mr. Batiste, what do you do to put money in your wallet these days?
I'm a server, I'm a hookah manager, and I also DJ on the side.
Where do you serve?
Still at Hobnob.
Oh, at Hobnob. Okay. All right. Well, you stay busy. That's good. Do you have any questions about anything we've discussed other than those warrants, which I can't help you with right now?
No, sir.
Okay. And you've cleared up, Mr. Cunningham is out of your life, and he cleared up with the DA's office. He wants no contact. So that's going to be one of the conditions of your sentence. Okay.
Got you.
All right. Well, Mr. Batiste, I find there's a factual basis for your plea, that your plea is voluntary, meaning no one's forcing you to enter it, and it's knowing, meaning you've understood the things we talked about. Do you agree with both those?
Yes, sir.
Okay. Ms. Wood, can someone in my office sign I think it's an accusation, for you?
Yes.
Ms. Smith?
Yes, Judge.
And Mr. Batiste, can we electronically sign your name indicating your guilty plea to the misdemeanor count?
Yes, sir.
All right, I'll make sure count 1 gets dismissed. I will sentence you to 12 months probation. Special conditions of probation are threefold. Number 1, no contact with Mr. Cunningham. Obviously, you don't call him or write him, but it also means no third-party contact. If you have shared friends, don't use a friend just to say, hey, how you doing? Mr. Batiste wants to know. He goes his way and you go your way. Special condition number 2 is that you complete a family violence intervention program. That is not one class, but a series of classes. And I'm going to require that you enroll in that within the first 2 months of your probation. Not that you finish it, but you get it started within the first 2 months of your probation. And finally, you must complete 30 hours of community service, and you will do that within the first 4 months of your only 12 months probation. Ms. Wood, anything else on behalf of Mr. Batiste?
No, Your Honor, I'm filling out the
Misdemeanor probation form? Great. Mr. Batiste, you will get a call or an email or both from misdemeanor probation. I think they're called Judicial Correction Services or something like that. Make sure you call them back because that's their one outreach to you, and then you need to plug in so they can let you know how supervision is going to work. They can help you find a family violence intervention program, and if you're curious about what qualifies for community service, they can let you know so that you don't bank 10 hours at a place that they say, that's working for your uncle, that's not community service. Okay?
Got you.
Ms. Smith, anything else? All right, that's it. Good luck, Mr. Batiste.
Thank you. And Ms. Smith, you still have the same number?
Ms. Wood?
Ms. Wood, I'm sorry.
Yes.
You still have the same number?
Yeah,
Okay.
and my email's the same as well.
I got
So
you. Would I be able to reach out to you today or no?
You can, but leave me a message because I don't know how long I'll be here.
Okay, got you.
All right, bye-bye.
Bye.
So we've got Mr. Bolton. Who else? I don't know who else is in court. Are you here for people who are in custody? Okay, who are you here for? You. Muse. And way in the back, who are you here for? What?
Can take Compton.
Oh, okay. All right. Are you handling Mr. Abade's? So we'll go in whatever order. It's you too. So pick the order. Mr. Bolton. He looks like he's gonna fall over. Let's get him up here. Then we'll do Mr. Compton, then we'll do Mr. Muse.
How you doing, Jude?
I'm all right, Mr. Bolton. Seeing you, it's always good seeing you. Wish drug court had worked out, but here we are. Yeah, you're in front of the TV?
On this side.
There you go.
Yeah.
Perfect. That way the court reporter can see you and hear you better.
Okay.
You're good. This is a non-negotiated plea in both cases.
Okay. You ready, Ms. Smith?
Yes.
Okay, we're gonna get on the record, Mr. Bolton. You have two cases, 25 SC 006-145 and 25 SC 006-800. One is a theft case and the other is a burglary case. Ms. Wood tells me that you are interested in trying out a plea, but today's your final plea date. And since it's non-negotiated, it may well be that whatever the state is asking for, if I end up agreeing with the state, that you say, no, thank you. And you are entitled to do that today. After today, if you enter a plea, I'm happy to take it, but you are bound by whatever sentence I impose. Today, I'll tell you what the sentence is after I've heard from everyone. And if it's different from what Ms. Wood asked for, then you and Ms. Wood can talk about it and you can say, yeah, I don't love it, but I'll take it. But you can also say, you know what? I'm coming to trial. Then we'll get you back here and we'll go to trial. The state will let me know. We'll do the burglary first or we'll do the theft by taking first. All right?
Okay.
And I know you've gone through this before, but Ms. Smith's going to put you under oath, ask you a bunch of questions. Please answer those truthfully and let Ms. Wood or me know if you've got any questions, okay? All right, let's do it.
Mr. Bolton, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Robert Lee Bolton Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
Yeah, heart medicine, prostate medicine, and high blood pressure medicine.
So Ms. Smith's question was, is there medicine that you normally take that you did not take? Did you skip all that medicine today?
No.
How come?
Because I didn't want to be on it right now.
Okay. Is the fact that you're not on that medicine making you in
I'll take it when
pain? Pardon me?
I'll take it this.
I'm sure you'll catch up, but are you doing okay right now?
Yes, sir.
You understand what's going on?
Yes, sir.
Okay.
Mr. Bolton, how old are you and how far have you gone in school?
65 years old and I graduated.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in both of these indictments?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So wait.
Mr. Bolton, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be subject to another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Bolton, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 006145, how do you plead to count 1, theft by taking, and count 2, criminal trespass?
Guilty.
As to indictment 25 SC 006800, how do you plead to count 1, burglary in the first degree, and count 2, criminal damage to property in the second degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you also understand that that has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right, thank you, Mr. Bolton. You're on the first turn into indictment ending in 6145. If this case were to go to trial, the state would show that on September 21st, 2024, Officer Dixon with the Atlanta Police Department responded to a larceny call at 1273 Almont, that's ALMONT Drive Southwest, involving a male suspected of stealing an air conditioning unit from the rear of the property. When the officers first got to that location, they sat there for a minute to see where the truck that had the AC unit in the back of his bed would go. Eventually, that car started to depart from that location I just mentioned, and the officers pulled it over with the reason pulling it over was because they had that stolen air conditioning unit in the back of the truck. When the officers stopped the car, they made contact with the driver whose name is Latrell Gooden. The defendant in this case was the passenger of that car. The officers were able to make contact with the owner of the house, Arbroso Atron. First name is spelled Alberto, last name is Altrian. The victim in this case told the officers that there was video footage of a male unhooking and removing appliances from his property. He said that the suspect was wearing a cap and a white button-down shirt. After reviewing that footage, the officers were able to match that description to the passenger in the truck, who was the defendant in this case. The defendant did tell the officers, and he admitted to going onto this property and taking the AC unit. Because of that, the defendant in this case was arrested for the charges in the indictment ending in 6145, and it's also occurred in Fulton County. For the facts of the indictment ending in 6800, if this case were to proceed to trial, the state will show that on September 18th, 2024, officers of the Atlanta Police Department responded to a burglary call at 1096 Cordova, Cordova, in reference to a burglary call. This is in Atlanta, Georgia, and also Fulton County. When the officers got there, they met with the victim, in this case, Mr. James Cannon, who advised them that his home was broken into yesterday and several appliances were taken. Mr. Cannon then showed video footage from a camera he had on his tree facing his front door, and the officers were able to observe that a black pickup truck, the same one from the other indictment, came to this home went to the back driveway, was able to make entry into the house and took several appliances, including copper, stoves, and wires of the home. Later that day, through video technology, police officers were able to track that same black pickup truck, and they were going to different recycle, let me get the right term. They were going to different SA recycling departments in East Point where they will turn these appliances in that were stolen and get money for them. The officers were able to track that black pickup truck to several locations that had this recycling department. And then in that truck, they saw the stolen items in the bed. They were able to identify the driver as Latrell Gooden and the defendant, in this case, as the passenger. Because of that, warrants were taken out for Mr. Bolton in this case, and he was arrested for the charges we have in front of us for the indictment ending in 6800. If I haven't mentioned, this also occurred in Fulton County. Those are the facts and circumstances of both indictments. For a global offer, in this case, the state is recommending 10 years to serve 2 with the balance probated. I can break that down per indictment. For indictment ending in 6145, the state is recommending 5 years probation for count 1, 12 months probation for count 2, for both of those counts to run concurrent. For indictment ending in 6800, the state is recommending for count 1, 2 years to serve, and for count 2, 3 years probation, of course, for those to run consecutive. As far as both of the indictments, the state is recommending that both of those indictments are ran consecutive for a total of 10 years to serve 2, with the balance probated. And as far as the special conditions of probation, the state is asking for the defendant to complete an anti-theft course, to stay away from both of the incident locations in the indictments, no contact with the victims of both, in both cases, and for the defendant to complete a drug and alcohol evaluation with treatment if necessary. To be specific, about restitution, in the case ending in 6145, we did speak with the victim in that case. He is not requesting restitution. He's not looking to be reimbursed for the things that were stolen. For the indictment ending in 6800, I did get a chance to speak with that victim, and he stated that multiple appliances were stolen. However, he's provided receipts and documentations for certain items he were able to replace, and those are the only items that he's asking to be reimbursed for, and I'll share those documents with Attorney Wood. But that is all from the state regarding the recommendation and the special conditions of probation.
Got it. Thank you. Ms. Stallworth, I see the recidivist notice that indicates Mr. Bolton has 7 prior convictions, all for burglary. Do you have more felony convictions than that, or is that the full universe?
I counted 13 outside of the 10-year period.
Okay.
And then 2 current probation cases. There was the 23 SC, that's for burglary, first degree, and willful obstruction. And then the 22 SC for criminal attempt to commit felony, possession of tools for the commission, simple battery, and then a 2020 conviction for criminal damage to property, second degree, burglary, second degree, and theft by taking.
Got
And
it.
then one more 2020 for burglary and criminal damage to property. But everything else was 13, outside of the 10-year period.
Okay, thank you. Ms. Simpson, is Mr. Bolton on probation? And that may have been what was in drug court. Are they cases for which he was sentenced before September 24?
He's already been revoked in regards to this case.
These 2 events resulted in revocations in all of his open probation cases. Okay. All right. Got it. Ms. Wood.
Thank you, Judge. Mr. Bolton is 65 years old. He is a high school graduate. He does live here in the Atlanta area. He has 4 children, 14 grandchildren. He is currently disabled, so he just got approved for disability, as you heard about some of his health issues earlier in this proceeding. Your Honor, our request is for 5 years probation to serve 6 months. He's already done 183 days. He got arrested. These happened close in time and he got arrested, so it's served for both cases. I would request a restitution hearing. We are fine with a drug and alcohol evaluation and treatment and an anti-theft course. And I would let the court know, I don't know why I didn't catch this earlier. I was wondering why Mr. Gooden was not on he's in a separate indictment in Judge Schwall's courtroom.
Okay, that was going to be one of my questions is where's the guy driving the black truck? The answer is Judge Schwall.
I missed it. If the notes in Odyssey are to be believed, it looks like he may be receiving adult diversion later, next week, actually. But yes, so he did get charged as well.
Okay.
But that's our request of the court.
Got it. Ms. Stallworth, I neglected to ask you a question about Mr. Bolton's criminal history. Can you tell me the most recent 2 cycles?
Oh, let me check to make sure the date, because I'm sorry, my computer's moving so slow.
That's okay. Mr. Bolton, I'm just trying to figure out what's been going on more recently. I know what's been going on in your distant past, and that doesn't necessarily define the way you're moving forward. These cases are, I'm ready.
I'm sorry, I said you want the last one? You said the last 2?
Last 2 cycles.
Okay, so the last cycle was in 2023 of August of 2023 for a burglary. That was a 23 SC 189813 case that's on probation.
So you don't show any arrest in I know he was arrested in September of 24, and he went into custody for a while.
Sorry, it was still loading. Hold on. So the last arrest on the GCIC is September 21st of 2024.
Okay. He has not been, according to GCIC, he has not been arrested since then.
Correct.
Okay. Thank you.
You're welcome.
That's not bad for you. What have you been up to?
Working and taking care of myself.
You're not well.
No, not really. I had 2 heart attacks since.
When do your benefits kick in?
It kicked in about 2 months ago.
Are they direct deposited? Where does the money go?
Deposit.
Okay.
Yes, sir.
And is it to your bank account or a family member's bank account?
Come to my card.
To your card?
Yes, sir.
Okay. And where are you staying these days?
Staying with my dad.
Your dad? How old is your dad?
87.
How's he doing?
He doing okay. I had to stay there with him. You know, I lost my mom.
Yeah.
Yeah, in 2012. So yeah, I've been hanging in there with my dad, man.
Okay. And you get some benefits. So you're also doing a little work on the side?
Yes, sir.
What kind of work?
Just, clean up and I work help a guy at a printing company. Sometimes I just go help him print funeral programs.
Oh.
Fold them.
Yep.
Staple them.
Okay. So you pick up little side gigs when you can,
Yes,
and then you're getting SSDI.
Yes, sir.
Okay. And is that fairly permanent? You should be able to continue to get the benefits?
I should.
All right. And is your father getting Social Security, or how is he?
He retired.
He's retired.
My dad was an aircraft mechanic.
Oh, so does he have a pension?
From Coca-Cola Aviation. Wow. So he can get a pension.
Good.
All this stuff.
So he's taking care of you?
No.
Okay.
But if you look at him, he look younger than me. He's 87.
He might have taken care of himself a little bit differently.
Yeah, he did.
You've had a complicated life.
I did.
Well, Mr. Bolton, I find there's a factual basis for both these. You were running with, what was the gentleman's name?
Latrell Gooden.
How'd you know this guy?
I met him through one of my best friends, Julius Walker.
Huh?
And I met him, that's his nephew.
Gooden is Walker's nephew?
Gooden, yeah, Terrell Gooden, that's his nephew.
Okay.
And he just asked me, one day he saw me walking, I was going to the store, he asked me, could I help him pick up some appliances? And I helped him on Cordova Street. Now, where we got locked up on Almount Street,
yeah.
I only walked in the yard. It was a furnace laying in the yard.
Yeah.
I walked in the yard to look at it, but the the air conditioning unit that they're talking about, he had already had that on his truck. That air conditioning, what they talking about, had never been touched.
Okay, well, I think you knew what this guy was up to, but that's not, I mean, you need to not roll with someone like that anymore.
I did, but
you-
I didn't know he was, going behind houses and taking and stuff like that. I didn't know that. Then this stuff was they saying that he backed up to the yard and all that. This stuff was on the side of the road.
Okay. Well, I think you are savvy enough to know if this guy's like, hey, I'm gonna go recycle these and this copper.
What he says.
Okay, good. Don't
talk to him, and then I see him every day. I ride right by him or walk by him. I don't.
Okay.
I ain't trying to get in no trouble, Joey.
Good. You haven't either since, I mean, you were in for a little while, but since you got out. All right. Anyway, I find there's a factual basis for both those pleas, that your pleas are knowing, meaning you've understood what we've been talking about, and voluntary. No one's forcing you to enter these pleas. So I will, accept them. Ms. Smith, can someone in my office sign the two, I don't know if they're accusations or indictments, but the two charging documents for you? Ms. Wood?
Yes.
And Mr. Bolton, can we put your name on electronically indicating you're guilty, please?
Yes, sir.
Okay. So you are racking them up. This is by Ms. Stallworth's counts, number 14 and 15 of getting in trouble. And you need to dial it back. 65, that's the retirement age. Retire from doing this stuff as well. When I look at what you got in trouble for, you aren't stabbing someone or hurting little kids. You're feeding your addiction. I mean, that's what you're doing for years, is you were feeding your addiction. Hopefully you are
Can I say
pretty sober right now. What do you want to say?
Honor, believe it or not, I haven't done drugs since I graduated drug court.
All right. Well, look at that.
And that's what, 2017?
That was a minute
I
ago.
haven't done drugs at all. I was just helping a friend out. I got caught up in some more stuff that I didn't have nothing to do with. I just get with the wrong people and get in trouble.
Yeah.
But
you got to stop doing the blaming someone else, because the common denominator of all those things is Robert Bolton.
Yeah.
So, but I'm impressed. You need to come back to drug court then, and maybe when you're done getting in trouble, and say, look, I've actually stayed sober for a bunch of years. Drug court can work. So we got you sober. Now we need to get you out of these little property crimes, because I'm saying no one's getting hurt, but it's still totally disruptive for these two gentlemen who are trying to rehab these houses, and all of a sudden the refrigerator's gone or all the copper wiring's ripped out, and that's money and time, and they're justifiably upset. And you shouldn't give them reasons to be upset. You should give them reasons to say, hey, look at that old man on the rocker enjoying life. Ms. Smith, someone in your office filed recidivist notices. Are you withdrawing those for purposes of these pleas?
I am withdrawing all but the 1671B.
Okay.
That after the fourth or subsequent burglary charge, whatever you sentence to get for that burglary.
Got it. It's a sophisticated partial withdrawal. Got it. Okay, thank you for that. Mr. Bolton, in 25 SC 006145, I'm sentencing you on count 1 to 5 years to serve 6 months with the balance on probation. Count 2 is 6 months to serve. They're going to run concurrently with each other. In 25 SC 006800, I'm sentencing you to 5 years to serve 6 months on both counts. They'll run concurrently with each other and concurrently with your other sentence in the other case. Special conditions of your probation. 1, you need to stay away. So in the Cordova case, you're going to need to stay away from that Cordova address.
Yeah, I haven't been there.
Okay, we'll keep doing that. And in the other case, whatever that address was, where the air conditioner was, you'll stay away from that.
See, I have to go around now because that's right on the next street from where my dad lived.
Okay.
I travel that street every day, but I can go another way.
Just don't go onto that property. It is okay to roll by and you can feel a little sheepish about it, but no one should see you walking around on that property. If you happen to be walking down the street because you're getting your steps, just walk on the other side of the street. Okay. No contact with either gentleman who own those houses, and they may have sold them by now. I don't think you knew those guys, but the names will be in your sentence. And just for good measure, I am not doubting you, because you actually are speaking more clearly and look a little healthier than when I saw you before. I must still have you do that drug and alcohol evaluation. Will you just meet with a medical expert who's going to say, tell us what's going on? And if what's going on is you smoke some cigarettes and that's it, and that's on you. But you won't need any treatment. But if they decide you ought to go to a few AA or NA or whatever the classes are, that's part of your probation. Okay?
Okay.
All right. We are tabling restitution for right now. If Ms. Smith gathers some paperwork, she'll share it with Ms. Wood. Ms. Wood will look at it. If it looks like it's legit, then she'll let me know, and there'll be some restitution you owe. If not, as in if she doesn't agree with it, then we'll have a hearing on it, and we'll see. But I appreciate you're not rolling in money. If you do have to pay restitution, you'll pay as you are able. Okay? So you're gonna be on probation for 4.5 years. It is really important that I don't see you in court again. Because if I see you in court, it's because you will have been arrested since we were talking today. And that breaks the streak of, I haven't been in trouble since September 24, I haven't used since 2017, and it all comes crashing down. And there's some pent up demand on the state side to stick it to you, because you got a lot of convictions. And I appreciate Ms. Smith's recommendation. If you were 10 years younger and in better health, and I wasn't familiar with the good work you put in drug court, I would have gone along with the 2 years. And it's a recidivist 2 years to the door. And that wouldn't have been a bad fit given all you've been up to. But you're 65, and I think you're in those happy sunset years where if you're making trouble, it's because maybe you aren't playing a clean hand of cards with someone, and nothing more than that, okay?
Okay, sir.
We know where to find you, so make good choices.
Okay, thank you.
Ms. Smith, anything else on behalf of the state?
I have a quick question with the indictment reading 6800.
Yes, ma'am.
Say for both counts is 5 years to serve 6 months.
Yes.
Okay.
Was that not a legal sentence?
Well, I was just wondering because under the burglary charge, whatever they're sentenced to is what he has to serve. So I was thinking, did you want to do just 6 months for that count? Like, for example, the 5 served 6 months can't be probated.
Really?
Under the burglary statute.
I thought it's just that whatever time, yes, I'll need to change it, but I didn't, what's the statute again?
1671.
No.
It's
just technical.
Okay.
Okay.
All right, I'm not arguing with you. I just, and I appreciate you, invoking it, in a situation like this.
It's Friday. Either, probation.
Right there.
Mm-hmm. Yep.
I'm out.
I know, but you gotta get logged in with these 2 cases, okay? So that's gonna connect everything together, but you still gotta be there,
Okay.
okay? And I
At
put
8
my number,
o'clock.
yep, and that's,
He needs to go at 8 o'clock, right, on Friday?
Huh,
and then,
okay.
yeah, so just call me. Kevin.
So, yeah, 6 months to serve. Thank you.
So just report that.
So Ms. Nelson, to recap on the case ending in 800, it's 6 months to serve for count 1 and 5 years to serve 6 months balance probated on count 2. Our recidivist expert caught that. All right, Ms. Simpson, Mr. Bolton probably should have lifetime friends in the probation office. Does he currently, do you know who your probation officer is? Who is it?
Officer Relaford.
Last name?
Relaford.
Relaford?
Yes, sir.
Okay, do you know that person's phone number?
I got it in my phone.
Okay, good. Should he call off?
I haven't missed a report since.
No one said you did. All right, keep it up. Should he call Officer Relaford, within 48 hours?
He can, we have a different officer, actually it's Officer Rivers, supervisor that's showing.
So that's where you just make sure you connect.
Okay.
He can call either one, I gave him the other officer.
Okay,
As well.
all right. Make sure you make contact with someone in probation who says, I got you, Bolton, you're okay.
Okay.
All right?
I just report Friday at 8.
Yeah, just, do that.
Okay.
Yeah, you know where the office is? Right nearby.
Pre-trial.
Yep,
Yeah, right on Memorial Drive.
yep. It's got a pretty sign on it.
Yeah.
Department of Community Supervision, all that stuff. Okay,
Okay.
Good luck.
All right.
Give my best to your dad.
All right.
You're free to go. You're very welcome.
I
Make good
appreciate
decisions,
y'all.
okay? Judge, can we do Miss Ballard very quickly on Zoom?
What are we doing with Miss Ballard?
It's our final plea hearing.
Okay,
That's
I
the-
promised these young ladies, but that's
No,
fine.
no,
We'll
it's
do Miss
okay.
Ballard.
I'm sorry. I keep forgetting about her.
Oh, yep, there she is. Hey, Miss Ballard, can you turn your camera on, please? She may have passed out. We want to give her a
I
text.
know, so one device did die already, so let me.
I was worried that Batiste was going to die at some point. Like, sorry, my battery's not 800 hours. While you're doing that, why don't we bring Mr. Muse to the
Okay.
door? Because that was a real quick conversation anyway. Ms. Rios is gone.
I'll
You got
see.
it? Okay. Hey, Mr. Muse, how you doing?
All right.
Kind of disappointed I'm seeing you again in this setting. But I wanted to give you an update that I don't think is an update for you, meaning I shouldn't be telling you anything new, but I want you to hear it from me. You were here for a probation revocation. Ms. Rios was working with Mr. Richardson, who I think is representing you on your new charges. And Ms. Rios at first thought that maybe Mr. Richardson was also handling the revocation piece, but he explained to Ms. Rios that he's been retained to handle the new charges, but not also the revocation. So you and your family may want to talk to him about that, and he may say, that's more money. That's a discussion for your family and Mr. Richardson. But when Ms. Rios realized, all right, I'm handling Mr. Muse's revocation, she engaged with the prosecutor, Ms. Smith, who's seated over here to my left, and learned that the state is seeking to revoke enough of your remaining probation because of these new allegations that it makes sense to get the state to prove it up. Sometimes it's negotiated. If the state was saying, oh, time served, defendants will say, great, I'll take time served. Who wouldn't take time served? That's not what the state is saying. But you have a right to hold the state to its burden, where they'd have to bring in a witness or witnesses to prove up whatever the new allegations are, which is another arrest for guns and drugs. And so the state's going to bring in that witness or those witnesses. And we have a mini trial. There's no jury, but a witness has to testify, and your lawyer will get to cross-examine the witness. And then I'll decide if the state proved by a preponderance that you were mixed up in whatever they're alleging you were mixed up in. We're just not doing that today because no one knew that's how it was going to play out. We thought Mr. Richardson would be here, and then we weren't sure, is it going to be negotiated or not? It seems like both sides are pretty far apart. So we'll have that hearing. And for now, Ms. Rios will get ready for it. If you bring Mr. Richardson on board, he can get ready for it. Okay? All that makes sense? Any questions? Okay, I don't know who this, pardon me?
You know, when that date will be.
Oh, 2-3 weeks. We just got to set it out long enough so that the state can subpoena. It's probably officers who will be coming. And so they just need to get those subpoenas out. So it's not months and months, but it's not this week. Okay? All right. And I don't know who the young lady in the purple shirt is to you, but she has been here all day. All right? Okay. Take care. Was it worth it to wait that long? Okay. Well, I'm glad you got to see him. How old is your kid? In you. Oh my gosh. How much longer? Okay,
Full talk your ass, you finna things decide.
got it. You need him out.
Can I tell you?
Nope, don't talk about it. Nope, you can talk to, well, Ms. Wood is a colleague of the lawyer who is going to represent him, so you guys could talk. But, okay, if you told Ms. Rios, you told the right person. Well, you got stuff going on as well, and it's important that you be heard, but if Ms. Rios heard you, then you're good to go, all right? Take care. So Mr. Compton?
So.
No.
Yes, no, before we do that, Miss Ballard,
Oh, Ms. Ballard, right, did she turn on?
so she's still on. She
Whoops.
says that no, she's not there.
Can I possibly get contact his
I can hear y'all.
Okay, hold on, Ms. Ballard, 1 second.
Because since he's been on probation, Marion has never seen a probation, so what happened was apparently he had a probation officer and they go to another.
All right, we'll get a name and number of a probation officer to you. Okay? All right. Yes, Ms. Ballard. I heard her for a moment. We'll go with audio only if we can pull that up.
Having connection issues.
All right. So can you unmute Ms. Ballard? She's unmuted. Great. All right, Ms. Ballard, can you hear me?
I can hear you.
Great. I'm Judge McBurney, and your lawyer, Ms. Wood, is here. And we need to have a quick conversation about your case so we can keep it moving forward. It may feel to you like it froze today, but we really are making progress. So I think this is just a final plea hearing.
Yes.
Okay. And Ms. Ballard's on the May 7th calendar, so we'll see her soon. So let's get on the record. Your case, Ms. Ballard, is 25 SC 006 282. And you are charged with 2 counts of aggravated assault. Ms. Wood, any discovery concerns that you've got?
So I don't know if I would call it a concern. Ms. Smith and I have been talking a lot, and there is some medical records that we're just interested to see if they exist. And I know Ms. Smith is looking to see if they exist.
Okay. These would be medical records of the complaining witness or witnesses. I don't know. There are 2 counts. So I don't know.
Yes, 2 people.
Okay. Well, those are kind of equal opportunity. People could do subpoenas or get court orders, but if the state's trying to get them, they'll keep working on that. But that doesn't, I'm hearing you say, it's not like they're sitting on a GBI report or something. Okay. Ms. Smith, what is the state's offer if Ms. Ballard wanted to resolve her case today?
Yes, Judge, the state's offer is 10 years to serve 5 with the balance probated.
Okay. Ms. Ballard, were you able to hear what Ms. Smith said?
Yes.
Okay, I'm going to repeat it.
I have to only serve 5.
Right. So if you were to enter a plea today, what the prosecutor would recommend is that I sentence you to 5 years in custody, followed by 5 years on probation. That's the 10 serve 5 balance probated. And I'm looking at the indictment, and that would be for allegedly driving your car at Taylor Fields and Patrick Hoffman. But it sounds like you are not interested in accepting that offer today. Is that correct?
Right.
Okay. Then we will move your case on to the trial calendar. A couple things you need to understand. You are still able to enter a plea later if you want to. What changes after today is that you will not be able to withdraw your plea if you are unhappy with the sentence that you get. So today, the state would be recommending 5 years to serve. Ms. Wood might argue for straight probation. If I were to sentence you to a year to serve, that's more than what Ms. Wood asked for. And so you could withdraw your plea and say, no, thank you, Judge. After today, if you decide to enter a plea, you're welcome to do that. You just don't get a back out if you're unhappy with the sentence. Do you understand that?
Like I understood it, but like I'm trying to fathom it. But yes, I hear you.
Okay, now I'll use concrete examples. Like I said today, if Ms. Wood asked for straight probation and I said, nah, this was pretty serious, this guy's leg broke, and I'm making all this up. But his leg broke, you hit him with your car. So you're going to need to go to prison for a year and then have some probation. Today, you could say no thank you to that. You may decide, your trial calendar is on May 7th, so just a few weeks away, that you don't want to go to trial. You know what the evidence is. You don't want the jury to go through all that. All right, Judge, I want to take a plea. So on May 7th, you take a plea, and Ms. Wood still asks for probation. And I say, no, this was too serious. I think that Ms. Ballard needs to do a year in custody. You would have pled guilty. You don't get a back out of the plea after today. You would be bound by your guilty plea, and you'd get whatever sentence it is that I imposed. Does that help you fathom it better?
Yeah.
Okay. All right. The only other thing that changes after today is that the state's offer is not a permanent thing. That may be something Ms. Smith is willing to leave open until May 7th. It may be that when Ms. Wood checks again, Ms. Smith says, you know, I've looked at the medical records and I'm now it's 10 to do 8. It could get better for you. It could get worse. You just need to understand that it's not a forever offer. Does that make sense?
It makes sense.
Okay. So you will need to be here in person, not virtually, on May 7th. That is the trial date for you. So you and Ms. Wood will be here. I'm sure she'll be talking with you before then, but that is the next time you got to be here. Are you still on Bentley Road in Marietta?
Yeah.
You paused for a minute. Are you not sure?
No, it's because I move around, so but I do still be over there. That's fine.
Okay. How about, are you in regular touch with Ms. Wood?
Yes.
Okay. So if you move around a little bit, if she's reminding you, hey, you got to come to court on May 7th, you'll hear from her?
Yes.
Okay. Well, that's the plan. Ms. Smith, anything else from the state?
Nothing further, thank you.
Ms. Wood, on behalf of Ms. Ballard?
No, Judge, thank you.
All right. We'll see you on May 7th, Ms. Ballard.
Sorry, wait. So what about the other people? Like,
The other people.
are we waiting? Are we waiting for them?
Ms.
still?
Ballard, we'll talk after today.
All right. Ms. Wood wants to take that one offline with you, okay?
Okay.
All right. She'll be in touch. Thank you for being patient today.
Mm-hmm.
All right. Bye-bye. Let's bring out Mr. Compton, please. I thought for a minute we were going to see like the whole belly when it's like we didn't, it's going to be TMI.
So I'm very excited for you to be in family court, Judge.
I really thought she was saying like, yeah, like we've got a 6-month-old or something. Like, nope, right in here. Okay. Yikes. Hey, Mr. Compton, come on up. Stand next to Ms. Wood, please.
Where are you going?
Other side. Right there. Stop right in front of the screen. There you go. Excellent. All right. We're going to get on the record in your case, Mr. Compton. It's 23 SC 187611. You are charged with murder, felony murder, aggravated assault, and possession of a firearm during the felony. Today's your final plea date, which is a day if the state makes an offer in which you are interested, for you to pursue that offer when you could withdraw your plea if you were unhappy with the sentence that you got. Your charges are such that the state's offer is probably going to be something you're not interested in, but we've got to go through this process anyway because everyone needs to be given the same opportunity. Ms. Wood, before I hear from Ms. Smith about the state's offer, how is the state doing in terms of getting you discovery?
We have everything.
Okay. You're ready to go on this one?
Yes.
All right. Ms. Smith, what is the state's offer in Mr. Compton's case?
Yes, Judge, the offer is life, and ADL body told me that the gun charge in this case you ask for it to be suspended, but as far as the sentence, it'll be to life.
Okay, life plus 5 suspended.
Yes.
Got it. So Mr. Compton, the state's offer right now is the lowest they could go unless they dismiss or reduce charges. but it's also one of the highest sentences you can get, life plus 5 years suspended. Is that something you're interested in pursuing today? Need you to answer out loud.
No.
No, okay, not surprised, understand that. So I will make sure your case moves to the trial calendar and for your planning purposes, and your guest who is here, you are on, whoops, that's Mr. You are on the May 28th trial calendar. So about a month away, you'll be here, and we'll figure out when to get you in for a jury during that trial calendar. All right? Any questions about anything we discussed? No?
No.
All right. Ms. Wood, anything else on behalf of Mr. Compton?
No, Judge.
Ms. Smith, anything from the state?
Nothing further, thank you.
All right. Appreciate it. We'll see you on May 28th at the latest, Mr. Compton.
Thank you, Judge.
Do we know who that was to him?
I can guess.
Girlfriend? Okay. All right. We took care of Bolton. Not a chatty guy.
Yeah.
That's who was banging. So he can be vocal. Interesting. So neither defendant was a very large defendant in this case.
Yes, Harrison, please.
Gordon knows who's like, I'm ready to go home, my judge. I know who's like, that's it. Harrison is the only one left. Another drug court friend.
Right.
Hey, Mr. Harrison.
This man Bernie, how are you?
Derek Harrison, how are you?
Hello, how are you?
Hey, slide that way so you're in front of the screen.
sorry.
You're good. That's all right. Ms. Wood was just grabbing your folders.
Okay.
Give me 1 second. Let me know when you're ready, Ms. Smith.
Ready.
Ready, of course. All right. Last pleas of the day. We have here in court Mr. Harrison. He has 2 cases, 24 SC 003208 and 25 SC 004240. 1 burglary, 1 possession of a controlled substance. Mr. Harrison is represented by Ms. Wood, also here in court, and the state's represented by Ms. Smith. Mr. Harrison, Ms. Wood tells me you're ready to resolve these 2 cases. Is that correct? Yes?
Yes, sir.
Okay. Ms. Smith is going to put you under oath in just a moment and ask you a bunch of questions about your rights and about these cases. Please listen carefully and answer truthfully, and also let me or Ms. Wood know if you have any questions. You do that?
Yes, sir.
Excellent. Then let us begin.
Mr. Harrison, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Derek Anthony Harrison Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 36. So I got as far as the 9th grade.
Are you able to read, write, and understand the English language?
Yes, I am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in these indictments?
Sure. Yes, ma'am.
Do you need more time to discuss your case with your attorney?
Not at all.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
We do.
Mr. Harrison, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you aware of any outstanding warrants?
No warrants. No.
Do you understand that this is a non-negotiated or blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you also understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Harrison, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 24 SC 003208, how do you plead to count one, burglary in the second degree?
Guilty.
As to indictment number 25 SC 004240, how do you plead to count one, possession of a Schedule II controlled substance, and count two, theft of lost/mislaid property?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
I'm sorry, can you come again with that, please?
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Oh, yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Harrison.
Sure.
Your Honor, regarding indictment ending in 3208, if this case were to proceed to trial, the state would show that on April 30th, 2024, officers of the Atlanta Police Department responded to 1170 Crescent Avenue Northeast. That's in Atlanta, Georgia, and also in Fulton County, in reference to a business burglary. The officer stated that, the caller that made the 911 call stated that a male was seen pulling on the door handle of the Subway restaurant that's at this location and forcefully made his way inside of the restaurant. And he grabbed a couple of drinks, cookies, and snacks from the sales rack. He then left that establishment. When the officer got there, they did see the defendant sleeping in front of the building, and he was asked to relocate. At this time, the officers were able to find those the snacks and drinks that were stolen from the Subway on the person of the defendant. He was arrested for the charges we have before us today. And that's for indictment ending in 3208. For the facts in 4240, if this case were to proceed to trial, the state would show that on January 15th, 2024, the defendant was taken into custody for theft. This was because there was a call made about theft of a person's property. When the officers got to the location of 200 Ted Turner Drive, that's in Atlanta, Georgia, and also in Fulton County, the officers made contact with the defendant in this case. It was reported that he had picked up a book bag belonging to the victim, last name Coakley in this case, where his AirPods, Nike shoes, and 2 laptops were inside of the backpack. The victim in this case, before the police got there, made contact with the defendant. The defendant gave him back the AirPods, gave him back the Nike shoes. However, the laptops were nowhere to be found in this case. Because of that, and because the defendant in this case took acknowledgement that he took the bag that had those items in it and gave them back to the defendant, the ones that he had, the officers took him into custody for the theft of mislaid property regarding the possession of a Schedule II controlled substance. Once the officers got there and they searched the victim, the defendant in this case, they did find methamphetamine in his front pocket. It was tested as less than 1 gram at the GBI lab. And those are the facts of the case with the indictment ending in 4240. Regarding the recommendation from the state, we're asking for a global offer of 5 years to serve 3. I'll break that down. So in the indictment ending in 3208, the state is asking for 3 years to serve for that burglary in the 2nd degree. And then for the indictment ending in 4240, the state is asking for on count 1 for 2 years probation, and then count 2, 12 months probation for those counts to run concurrent. For both of those indictments, we're asking for them to run consecutive. A little background on why the state is asking for serve 3 is my understanding that the defendant has already served 1 year or over 1 year in custody, so he'll get credit for that time served. But I think the biggest issue that the state wants to address in this case is the defendant's drug issues. It's my understanding that he was a part of the drug court program we have here, and he was terminated because he was still using. And I know that the defense in this case wants him to work with PAD. However, the state is kind of concerned that because PAD is voluntary, that he won't complete it when he was in a program that was kind of mandatory and was terminated from it. So the idea behind the 3 years is for him to get credit for that 1 year he's already served, and then to complete the RSAT program while in custody, and for that serve 3 sentence to be commuted to time served once the completion of that RSAT program has been completed. Again, this is to just so the defendant addresses those substance abuse problems he may have, and to deter any future type of criminal activity that may be the result of if he was still on using drugs or having these substance issues. But altogether, the global offer in this case is 5 years to serve 3. Regarding the special conditions of probation, the state is not asking for restitution in the case ending in 3208. That's the subway indictment. The victim in this case does not want restitution. Regarding the indictment ending in 4240, I did talk to the victim in this case, and he says his biggest concern is that he wants the defendant to get help. He wants the defendant to get help. However, if he's able to get restitution for the 2 laptops that he was not able to get back, that he would like that. However, he is aware of Mr. Harrison's situation and the position that he may be in, especially with his substance abuse problems that he has. The other conditions of probation that the state is asking for is for the defendant to stay away from both of the incident locations in these indictments, to have no contact with the victim. I do believe it's stranger on stranger, but just in case he sees them, to go the other way, for there to be random drug screens, and also for the defendant to have gainful employment.
Okay.
That's all from the state.
Question about the case ending in 240 with the theft of lost or mislaid property. I didn't quite follow. Does the victim say, I put my backpack down, or Mr. Harrison, I saw him take it, or I lost my backpack, I don't know what happened, and then Mr. Harrison ended up being the person who had the backpack?
Yes, from my understanding, the book bag, all of the items were left in a car. Someone threw a brick inside of that car and stole the book bag. we don't have evidence that that person was Mr. Harrison in this case. However, the person later found with that backpack was Mr. Harrison. He said that he saw the backpack, took it, and then gave the victim back the AirPods and the shoes, but no computers.
Got it. So there's not a way, I'm not saying he did, but to connect Mr. Harrison with the entering auto offense.
Correct.
Just he ended up with, doesn't seem like there's a dispute about it, what was, some of what was taken from that car.
Yes.
Understood. Okay, thank you. Ms. Stallworth, our last case of the day for you. Can you share with me criminal history information for Mr. Harrison?
Yes, Your Honor. He has 14 cycles total. There's a 2015 first offender, 15 SC 138286 for aggravated battery and aggravated assault. And the last date of arrest was for the 29th of 2025, but that case was dismissed. It was for criminal damage to property, second degree.
Okay, so you found just one conviction and it's not necessarily a conviction, that's the first offender.
Correct.
Okay, all right. So thank you so much. Ms. Simpson, Mr. Harrison, is he on active probation?
Case closed out, July 31st.
Okay, all right, it's done. Ms. Wood.
Thank you, Judge. Mr. Harrison is 36 years old. As you heard, he has a ninth grade education. He has worked in customer service type jobs. He's worked at McDonald's. He's done warehouse work through temp services. As you know, more than I do, he struggles with a meth addiction. The reason we are asking for a different sentence is because he was in drug court on a diversion track. So my proposal to the court is that he receive a chance to do probation. And then, of course, if he doesn't do well on probation, then the court has that option of revoking his probation and sending him to RSAT. I'm asking for 6 to serve 1. I think it needs to be structured a little bit differently though, because on the 24 SC case, he's only done 324 days. And then on the 25 SC case, he's done 397 days. Otherwise, he has been accepted to work with PAD. We have no issue, obviously, with the drug and alcohol evaluation treatment, a stay away. I would ask that gainful employment be included as a special condition of his probation. And then finally, I would ask for a restitution hearing.
Okay, Mr. Harrison, anything you want to add?
I would like to be given a chance, Judge, for my sake, for my ability, for my willingness, because I know I can. I know I won't be back in here, once I'm able to gain fully employed, with occupation. I haven't gotten a chance before, I was in drug court. So I was really eager to get back to work. That's one of my family's biggest willingness for me to do is get back to work. And I'm just really hoping I get the chance to get back out, get the chance to get back in employment and do what I have to do for me and for my family, please.
Where's your family? I don't remember where family
My dad's
is.
side of family is here.
Is local?
It's my grandmother. Yes, ma'am. Yes, sir. She's my biggest support. Her and my auntie Marie, they are my biggest support system. They want me to get back into employment. They want me to get an apartment again. And so do I. So I'm really asking for that chance, please.
So I'm glad they are supporting you and wanting you to do that, but it doesn't sound like they're in a position to make it happen. They are supportive, but they don't have an apartment for you or a job for
It
you.
would be me to do the job, to get the apartment for me. I want that opportunity. I love to work and I want to get back to work.
Okay. The struggle I have is you also, I don't know, you love it, but you have this affinity for meth. You got a lot of support through drug court, and then we had to ratchet it up to you being in residential treatment, and even residential treatment didn't keep you away from the substances. And so I share Ms. Smith's concern that we are setting you up for harm by not having a lot of structure in place.
It wouldn't be any harm. I'm really hoping I get a chance to help myself, shrink away from the drugs because I want a chance to be back. The drugs is what kept me away from my family.
I understand, but then with pretty rigorous treatment, you still didn't stay away from the drugs. So I'm just not following why now it would be different. I don't know what's changed from 3 months ago.
I'm really asking for a chance, please. Do you think that there isn't a chance that probation, if I can have the opportunity to like get may random drug test me or get me into some classes, if you will? I'm asking for the chance.
Do you have a sense, Ms. Simpson, as to whether Mr. Harrison could be accepted into MADRC, or if they would say no because drug court didn't work out?
I don't see why they wouldn't, it's pretty much the same structure as drug court is. So I don't see why not,
Where would you stay when you get out?
Well, if I'm accepted, well, I'm already accepted into pay.
So they'll help you with supportive housing.
Sir, yes, sir.
concern would be he would be responsible because he doesn't have stable housing. He would be responsible for reporting every week.
Well, MADRC, isn't it, not just every week, it would be initially Monday through Friday.
But he would still be responsible for reporting every week just to.
Oh, meaning to probation?
Yes.
Yeah.
And so we would need to be able to find.
Yep. But PAD will provide housing. That's one of the benefits.
And I don't think I won't get out until Pat come pick me up.
Correct.
So, right. So at least he'd start out in a stable house. Whether he stays there or not is up to him. But that's the same with MADRC, whether he avails himself of it. And if that doesn't work out, then to Ms. Wood's point, then we can revoke to RSAT.
And once the MADRC says, once you get kicked out, they don't take it back.
Right. Well, and they shouldn't. I mean, because Mr. Harrison will have, if that were to happen, I don't want to prejudge, he would have not worked out with drug court and not worked out with MADRC. We'd look a little silly looking for another plan like that. All right, Mr. Harrison, anything more you want to add?
No, sir.
Okay. Well, I find there's a factual basis for both your pleas. These aren't the most serious crimes ever. You broke into Subway to get some food. You didn't take valuable property, and you ended up with some guy's stolen backpack. To me, they're symptomatic of you struggling with addiction because it sounds like you were homeless at the time of the Subway situation. You needed food and then you fell asleep outside the Subway where they found you with the food, which is more a crime of desperation than anything else. I would love to help lift you up. Problem is that the meth keeps pulling you back down. So we'll see how this plays out. But I do find there's a factual basis for both your pleas, and that your pleas were knowing, meaning you've understood what we talked about.
Yes, sir.
And voluntary, meaning no one forced you to enter the plea. Is that correct?
Correct.
Ms. Smith, can someone in my office sign the 2 indictments for you?
Yes, Judge.
Ms. Wood?
Yes, Judge.
And Mr. Harrison, can we sign your name to both indictments indicating your guilty pleas?
Yes.
All right. On 24 SC 003208, I'm sentencing you to 6 years to serve 11 months with a balance on probation. Special condition of probation number 1 is that you get your GED, and you'll need to enroll in your GED course within the first, if he's at MADRC, I don't want to double duty with GED. So.
I'm not mistaken, I don't think that one is.
Yeah, so part of your probation is that you get your GED, but another special condition is that you enter into and complete the Metro Atlanta Day Reporting Center, which is going to strike you as being kind of similar to drug court, which is a good thing, assuming you keep up with it. If you are terminated from MADRC, that's going to mean that we send you to RSAT, okay? You'll need to stay away from that subway. You will need to get your GED, but probation's going to understand when you're doing the day reporting center, that's not quite full-time, but you'll be busy at first, and so GED may need to wait a little bit. In 25 SC 004 240, I'm sentencing you on, is that just 1 to 3?
Mm-hmm.
Okay. I'm sentencing you to a year to serve on count 1 and 12 months to serve on count 2. Those will run concurrently with each other. So that case will close out when you are released. And I can't make PAD a condition of anything, so I won't mention PAD, but you should understand, Mr. Harrison, that I'm gonna add language to your sentence that says release to program, and that's gonna be PAD. And then when PAD is able to get you that housing, which will be soon, it's not a months and months thing, Ms. Wood will get an order that I'll sign that lets the sheriff know PAD's coming to get you on, I'll make it up, April 28th, and they'll release you then, okay? So you'll be released to having supportive housing in place. You will need to report to probation and then start going to the day reporting center. Any questions about that?
So everything will be ran concurrent for probation on my time.
Well, yeah, you only have one case that's gonna be on probation. Your other case was purely custodial. So you've got 5 years and a month of probation. All right. And just to reiterate, if day reporting center doesn't work out, you get booted from that because you're testing positive, because they test you there. If you're testing positive or you don't show up, then that's a signal that we're going to go with the residential substance abuse treatment program, which is drug court, but it's drug court where they lock the doors on the outside. You don't get to leave. Okay?
Yes, sir.
Ms. Smith, anything else?
Nothing further.
All right, Ms. Wood?
No, Judge, thank you so much.
And probation reporting instructions, you'll talk to Mr. Harrison about that?
Actually, needs to be just within 48 hours.
Okay. So
Don't leave yet.
they'll cover that with you.
But we can do that.
Great, thank you.
Oh, were you there? That was a bigger. Do you have a bigger? Oh, yeah.
Hold on one sec. Yes?
With the day reporting center, is that something where the defendant is referred or is it just court ordered?
It's court ordered.
Okay.
Yeah. Now, every once in a while, someone is rejected from there, like for a medical reason, he wouldn't be rejected from there. So it's kind of a way, if you want someone to get drug court for sure, you say day reporting center.
Okay.
It's a little less structured than drug court, but pretty close because it's not just sobriety counseling, but there's job readiness and things like that. But it's a lot of classes and some people are like, this is a pain, I don't want to go anymore. And they violated probation. And then we go with the Smith plan.
Okay, thank you.
All right. So we've got a 4 o'clock to talk about the remnants of the trial calendar. You guys are welcome to stay here. You're welcome to hurry back to a remote location, but it'll be on this Zoom. I'll just kill the larger feed.
Okay.
How old is council?
Not old, like
About
20, yeah, 21 maybe.
Man, he was just playing too much.
It was what?
Playing too much for back.
Well, so you mean, you've noticed it. Sometimes the little guys are the ones who have to act big. So bad stuff doesn't happen. He was born in December of '03. So he'll be 23. So he's 22 now. 5'4", 135.
Can I give these to you to get
Sure.
this Nelson?
Yeah,
Thank you.
you bet. Thank you. Mr. Harrison. So Lonzie Johnson never came back. Did he end up? She hooked him up? She's so good.
Stuff like location.
Mm-hmm.
Send it to you. It is.
Okay, you can send it to me.
If you've already got it. I did, but I can tell you like.
Okay.
1170 Crescent Avenue. Northeast Atlanta, Georgia. And then that zip is 30309.
Thank you for helping Lonzie Johnson.
He thought she was in trouble, but she actually was not.
Thank you.
Good.
Thank you on my behalf too.
Does Ms. Johnson call you a lot?
Oh my gosh, yes. Yeah, she called me back just a few minutes ago and I said, didn't you come to work? I thought you called me. She said, I thought you called me. No, I did not call you.
She got bumped out of Salvation.
Yeah.
Oh, you put it nicely, bumped out.
She got bumped out of Salvation Army and apparently Pat had sent her through there. And because she got bumped out, she thought it put her in violation. And I said, Pat will let us put it in, look at the conditions. So I said, no, it's not a part of your condition, but she did everything right.
Good.
She tried to call her officer, she couldn't get him, so she showed up at her office. And they told her, call your officer, and she finally got him. And she said, I'm supposed to see him Thursday. I said, good, you did everything right.
Yes,
So
yes.
I said, explain to your officer what happened.
Yep.
And I said, ask him to reconnect you back with Pat so that you
Good.
can feel Pat. Salvation Army moving me out.
Okay.
She was happy with that.
Good. She should be. She and showing up. I was supposed to tell her, hey, you showed up here. That's good. You're clearly not trying to run from anything. It's just it was kind of a busy day, so we don't have a ton of time for the theatrics.
She's ready to come back. And she was like, do I need to be here one? No.
Nope. Thank you.
This was stressing out.
She did.
How did I miss her?
Yeah, she was way in the back, and we were done. And I'm like, all right, I gotta go. And she's Judge. I'm like, oh, right, because Gordon had sent me a card. Lonzie Johnson is here.
Left me so many, like, she's.
But she said you don't answer the phone.
I don't anymore. And she left me one message and was saying she was gonna like go find the governor and like complain about me.
Oh, the governor.
See, Michael Simpson told me he was gonna call his congressman because he wanted to know why we were trying to set him up for failure because he is still on probation and he insists that he is not. So fun. That is the conversation I got.
Oh, we just got a case sent to business court. Excellent.
Judge,